My lord.
And hence 2 weeks. ಹೇಳಿ ಮೇಡಮ್ ಏನು ಈ ಕೇಸಲ್ಲೇನಾ?
Yesterday I received the notice, sir, for the respondent.
ಹೇಳಿ ಏನ್ ಮಾಡ್ತೀರಿ? ವಕಾಲತ್ ಹಾಕ್ತೀರಾ? ಹೆಸರು ಹೇಳಿ ಮೇಡಮ್ ನಿಮ್ದು.
Savita D. Savita D.
Savita D.
Savita or Kavita?
Savita.
Savita.
Kavita.
Kavita. Counsel Kavita undertakes to file wakalat for respondent on the ground that yesterday they have received the notice. And hence 1 week or 2 weeks?
2 weeks, my lord. 2 weeks.
And hence 2 weeks time. If wakalat is filed, show the name of the counsel. And list this matter on 22nd March. ಏನು ಇದು ಮೇಂಟೈನಬಿಲಿಟಿ? Petitioner counsel orally seeks the permission of this court to convert the revision petition as a criminal appeal permitted. For the statistic purpose, criminal RP is disposed of. ಅಡ್ಮಿಟ್ ಆದಾಗಲೇ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆಗಿದೆ. ಇವತ್ತೇನಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಿದೆ? PCR ಅವೈಟೆಡ್ ಅಡ್ಮಿಷನ್ಗ ಅಡ್ಮಿಟ್ ಆದ್ರೆ ಹೆಂಗ ಇವತ್ತಾಕ್ ಬಂದ್ಬಿಡು? ಬಂದಿಲ್ವಾ? ಬಂದಿಲ್ಲ. ಒಂದಂದ್ರೆ ಯಾವ್ದು ಅಪಲೇಟ್ ಕೋರ್ಟ ಅಥವಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್? ಆಯ್ತು. The office is directed reminder to send the lower court PCR. And list admit ಆಗಿದೆಯಾ? ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ ಪೋಸ್ಟ್ ಮಾಡಬೇಕು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಷ್ಟೇನೆ. And post matter for final hearing as soon as records received from the trial court ಅಷ್ಟೇ. ಅಡ್ಮಿಟ್ ಆಗುವ ಕಂಡೀಷನ್ ಆರ್ಡರ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಎಲ್ಲ ಮಾಡಿದೀರಾ? ಸರಿ ಆಯ್ತು. 14 compliance of office objection raised on IA 2/22 for extension of time. ಹೇಳ್ರಿ office objections IA ಮೇಲೆ ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಶುರು ಮಾಡಿಲ್ವಾ? ಕೊಡಿ. ಕಾಪಿ ಶುರು ಮಾಡಿಲ್ಲಲ್ಲ ನೀವು? ಕಾಪಿ ಶುರು ಮಾಡ್ಬೇಕಲ್ಲ. ರೆಫ್ಯೂಸ್ ಟು ಟೇಕ್ IA ಕಾಪಿ ಅಂತಂದ್ರೆ ಯಾರು? ಅಡ್ವೊಕೇಟಾ? ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಯಾರು ಇದು? ಹೂ ಹ್ಯಾಸ್ ರೆಫ್ಯೂಸ್ಡ್? ಶ್ರೀಕಾಂತ್ ಬಿ ಯಾರು? ಅಡ್ವೊಕೇಟಾ? ಅಡ್ವೊಕೇಟ್ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು. ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಲ್ರಿ ಯಾರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು ಏನು ಅಂತ? ಯಾರು ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ರೆಫ್ಯೂಸ್ಡ್ ಅಂತ ಬರ್ದ ಹಾಕಿದ್ರೆ ಅಡ್ವೊಕೇಟ್ ತಗೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ. ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ಗೆನೆ ಬರೀ ಪೀರಿಯಡ್ ಆಫ್ 2 weeks ಅಂತ ಕೊಟ್ಟಿತ್ತಾ? ಏನಿದು ಅಮೌಂಟ್ ಅಂತಾನೆ ಬರ್ದಿದ್ರಿ ನೀವೇನ? ಅದು ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದೆ? 18/11 ಅಲ್ಲಿ 4 weeks ಅಂತ ಆಯ್ತು. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ 4 weeks ಒಳಗೆ ಹಾಕಿದೀರಾ? ಮತ್ತೆ after the expiry of ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗ್ಲೇಬೇಕಲ್ಲ. ಕೌನ್ಸಿಲ್ ರೆಫ್ಯೂಸ್ಡ್. ಕೌನ್ಸಿಲ್ who is on record now ಯಾರು ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಪಾರ್ಟಿ ಮೇಡಮ್ ರೆಫ್ಯೂಸ್ ಟು ಟೇಕ್ IA ಕಾಪಿ ಅಂತಿದೆ. ಯಾರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು? ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಹಾಕಿ ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕ್ಬಿಡಿ. ದೆನ್ ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಯುವರ್ IA. ಯಾರು ಅಂತ ಹಾಕಿ ಫಸ್ಟ್. Counsel submits that respondent refused to take IA copy and hence directed to file affidavit regarding refusal is concerned. ಯಾವ್ದು ಬೇಕು? ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಹಾಕ್ತೀರಿ? This matter on 15th, next Tuesday. Chetan B. Council 6 weeks time to comply with office objection. Praveen Kumar Mishra. Non-compliance of office objection for second time. Then appears. However, 1 week time granted to comply with office objection. Manjunath HR. Same order. It is second time. Then appears. 18. Chetan BC. Regarding maintainability. RP na? Told none appears. 1 week time granted to comply with office objection. Office objection see the notice. 7 office objections. Petitioner counsel to comply with office objection. 1 week. 2 days, sir. Post the matter immediately after compliance of office objection. Sudhindra BS. That is not only stay prayer is not maintainable on the order of conviction. Office objection ಏನಿದೆ ನೋಡಿ. Petitioner counsel seeks 1 week time to comply with office objection. Post the matter after compliance in fact. Sunil Shastri.
Lord, petitioner in this case, my lord.
Really, office objections.
My lord, 1 week time may be granted, my lord.
Counsel seeks 1 week time. Post the matter after compliance. Raghavendra K. Petitioner counsel
appear
absent.
for the petition limits, madam.
Lord,
I appear for the petition. Kindly permit me to withdraw this petition with a liberty to file a criminal petition. The office has raised the objection stating that revision is not
criminal petition. Petitioner counsel seeks permission to withdraw this petition with liberty to file criminal petition. And hence permitted to withdraw with liberty to file criminal petition.
Sir, office may be directed to give back the papers, madam.
Give back certified copies. The office is directed to return back the certified copies.
Certified copies, madam. Is grateful.
Release of amount. 23, serial number 23. Who filed an application for? Then. ಆಯ್ತು ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ? 8 adjournment for cross of PW1. ಮತ್ತೆ you are present but you have not cross examined the witness. Why? ಯಾರು? Who underwent for cataract operation? Accused underwent ಆದ್ರೆ ಲಾಯರ್ ಕೆಲಸ ಅದು. ಕ್ರಾಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಲಾಯರ್ ಕೆಲಸ. ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್. No grounds. Dismissed. ಏನ್ ಆಪರ್ಚುನಿಟಿ ನಿಮಗೆ ಮನಸ್ಸಿಗೆ ಬಂದ ಕಾನೂನಲ್ಲಿ ಯಾವಾಗ ಒಂದು ವಿಚಾರಣೆ ಆಗಿ PW1 absent. Counsel for accused as application 145 for recurring of PW1 for cross. Hence, said application followed. Recalled for cross of PW1. Yavaga, that was on 27/1. Cost of ₹100. ML cross of PW1. ಹೋಗಿ ನೀವು ಕ್ರಾಸ್ ಮಾಡಿದವ್ರು ಏನ್ ಮಾಡ್ಬೇಕು? PW1 present. PW1 present. 1 2 3 4 5, 6, 7, 8, 9, 10. 10ರಲ್ಲಿ ಒಂದ್ ದಿವಸ ಮಾತ್ರ PW1 ಆಬ್ಸೆಂಟ್, ಬಾಕಿ ದಿವಸ ಎಲ್ಲ PW1 ಪ್ರೆಸೆಂಟ್. ಏನ್ ಬರೆದ್ರು ಆರ್ಡರ್ ನಲ್ಲಿ? ಹೌದು, ಕರೆಕ್ಟ್ ಅಲ್ಲ, ತಪ್ಪೇನಿದೆ ಅದ್ರಲ್ಲಿ? ವೈ ದಿಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಎಕ್ಸರ್ಸೈಸ್ ದಿ ರಿವಿಷನಲ್ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್? ಹೇಳಿ. ಮಾಸ್ಕ್ ತೆಗಿರ್ರಿ. ನಾವಿಲ್ಲಿ ಮಾಸ್ಕ್ ತಕ್ಕೊಂಡು ಕೆಲಸ ಮಾಡ್ತಾ ಇದೀವಿ, ನೀವು ಮಾಸ್ಕ್ ಹಾಕೊಂಡು ಏನ್ ಹೇಳ್ತೀರೋ ಅದು ಗೊತ್ತೂ ಆಗೋದಿಲ್ಲ. ಯಾವಾಗ? ಏನ್ ಈ ಕೋರ್ಟ್ ಅಲ್ಲ? ಆಯ್ತು, ಏನಾಯ್ತು? ಏನ್ರಿ ಗ್ರೌಂಡ್ಸ್ ಏನ್ ಹೇಳಿ? ರಿವಿಷನ್ ಸ್ಕೋಪ್ ಚೆಕ್ ಅಮೌಂಟ್ ಎಷ್ಟು? ಯಾರಾಗ್ಲಿ ಚೆಕ್ ಅಮೌಂಟ್ ಎಷ್ಟು? 5 lakhs ಸರ್. ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಯಾವ ವರ್ಷದಲ್ಲಿ ಆಗಿರೋದು? 2017. ಆಯ್ತು, 50,000 ಕಾಸ್ಟ್ ಕೊಡ್ಲಿ, ರಿಮೈಂಡ್ ಮಾಡೋಣ, ಕಾಸ್ಟ್ ಮಾಡ್ಲಿ ಅವರು. ಲೆಟ್ ದೆಮ್ ಪೇ ಕಾಸ್ಟ್ 50,000. 2017 matter ಅಲ್ಲ, with time bound, within 3 months trial court to dispose of the matter. Let them pay cost of rupees 50,000 because PW1 is not cross examined. ಯಾವಾಗ ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದ್ದು? 18 ಅಲ್ಲ, 19 ಅಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. ಚೆಕ್ 5 ಲಕ್ಷನೇನಾ? 5 ಲಕ್ಷಕ್ಕೆ 5 ಲಕ್ಷನೇ ಕೊಟ್ಟವ್ರ? ಇನ್ನೇನ್ರಿ? ಲಾಯರ್ ರೆಫರ್ ಆದ್ರೇನು? ಲಾಯರ್ ಮಾಡಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೆ ನಿಮಗೆ ರೆಫರ್ ಮಾಡೋ. ನೀವು ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದೀರಾ ನೋಟಿಸ್ ಹೋಗ್ಲಿ? ನೋಟಿಸ್ಗೂ ರಿಪ್ಲೈ ಕೊಟ್ಟಿಲ್ಲ, ಸರ್ವಿಸು ಆಗಿದೆ. ದೆನ್ ವಾಟ್ ಇಸ್ ಆಗಿದ್ದಾರೆ? ಪೋಸ್ಟಲ್ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಎಕ್ಸಿಬಿಟ್ P5. No grounds. Even after the service of notice also, your client has not given any reply also. Then why matter has to be remanded to the trial court? ಆಯ್ತು, ಹೌದು, ಲಾಯರ್ ಮೇಲೆ ರಿಕವರಿ ಮಾಡ್ಕೊಂಡು ಬಿಡಿ. ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮ್ ಹೋಗ್ಲಿ, ಕಂಪ್ಲೇಂಟ್ ಅಕ್ಯೂಸ್ಡ್. ಪ್ರಾಬ್ಲಮ್ ಏನಾಗ್ತದೆ? ಲಾಯರ್ ಫೀಸ್ ಇಸ್ಕೊಬಿಟ್ಟು ಜೇಬಲ್ಲಿ ಇಟ್ಕೊಂಡು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದವ್ರ, ಅದ್ ಲಾಯರ್ ಕೆಲಸ ಅಂತಾರ? ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಎ ಫ್ರಾಡ್. ಕಲೆಕ್ಟಿಂಗ್ ಫೀ ಫ್ರಮ್ ದಿ ಕ್ಲೈಂಟ್ ಅಂಡ್ ನಾಟ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನಿಂಗ್ ದಿ ವಿಟ್ನೆಸ್, ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಎ ಫ್ರಾಡ್. ಈಗ ಹೌದಿಲ್ಲ? ನೀವೇ ನೋಡ್ತಿರಲ್ಲ, ಇಲ್ಲಿ ಅಪೀಲ್ ಎಷ್ಟು ಜನ ಬರ್ತಾರೆ ಕೋರ್ಟ್ಗೆ. ಡಿವಿಷನ್ ಹಾಕಿ 10 ವರ್ಷ ಆದ್ರೂ ಯಾವ ಲಾಯರು ಬರಲ್ಲ, ಬರೀ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್ ಮಾತ್ರ ನಿಂತ್ಕೋತಾರೆ. ಫೀಸ್ ಹಾಕಿ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಮಾತ್ರ ನಿಂತ್ಕೋತಾರೆ ಇಲ್ಲ ಅಷ್ಟೇ. ದಿಸ್ ಇಸ್ ಅಡ್ವೊಕೇಸಿ. ಏನ್ ಮಿಸ್ಟೇಕ್ಸ್ ರೀ? ಎಲ್ಲಿ ಬೇಲ್ ಪಿಟಿಷನ್, ಎಲ್ಲಿ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್, ಎಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಸ್ಟೇ? ಲಾಯರ್ಸ್ ಆರ್ ಮೆಂಟ್ ಫಾರ್ ದಟ್ ಓನ್ಲಿ. ಸತ್ಯ ಹೇಳ್ಬಿಟ್ರೆ ಸಾಹೇಬ್ರು ಬೈತಾರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಬೈದೇನೇನ್ ಮಾಡ್ಬೇಕ್ರಿ ಇಂಥವ್ರಿಗೆ? 10 ದಿವಸ ವಿಟ್ನೆಸ್ ಕೋರ್ಟಿಗೆ ಹೋಗಿದ್ದಾನೆ, ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿಲ್ಲ. ಇದು ಅಡ್ವೊಕೇಸಿನಾ? ಮತ್ತೆ why the court has to exercise the revisional jurisdiction? ಹೋಗ್ಲಿ ಬಿಡಿ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮ್ಗೆ ಲಾಯರ್ ಮೇಲೆ. ಏನ್ರಿ ರಿಪ್ಲೈನು ಕೊಟ್ಟಿಲ್ಲ, ಚೆಕ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ಲ, ಏನಕ್ಕೆ ರಿವಿಷನ್ ಮತ್ತೆ ರಿಮೈಂಡ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನೋ ನಾಟ್ ಎ ಕೇಸ್. ಕೊಡಿ ಏನಂತ. ವುಡ್ ನಾಟ್ ಬಿ ಸೆಕ್ಯೂರ್ಡ್ ಇದ್ದಾಗ ಇಲ್ಲಿ ಸೆಕ್ಯೂರ್ ಪ್ರಶ್ನೆ ಇಲ್ವೇ ಇಲ್ಲ. ವಿಟ್ನೆಸ್ ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಏನು 28(9) ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್. ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಪ್ರಿನ್ಸಿಪಲ್ ಏನ್ ಹೇಳ್ತದೆ ಹೇಳ್ರಿ? ಇದು ಹೇಳ್ದ್ ನೋಡ್ರಿ, ಇನ್ ಎ ಕ್ರಿಮಿನಲ್ ಟ್ರಯಲ್ ವೇರ್ ದಿ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ದಿ ಅಕ್ಯೂಸ್ಡ್ is a must and where the presence of the accused could not be secured in the manner known to law within a reasonable time, the case against such accused will have to be split up. In the case against so present before the court could be proceeded with further in accordance with law. The same will be in procedure applicable even in cases instituted for the alleged offense also. So this is not a case of accused was not secured before the court. 28. Accused secure ಆದ್ಮೇಲೆ ಟ್ರಯಲ್ ಕಮೆನ್ಸ್ ಆಗಿದ್ದು ಹೌದಾ? ಹೌದು. ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡೋ ಪರ್ಪಸ್ಗೆ ಡಿಫೀಟ್ ಮಾಡಕ್ಕೋಸ್ಕರ ಆಯ್ತು. In his presence only chief evidence was recorded. ಹೌದಾ? Chief evidence was witness examined in the presence of the PW1. ಹೌದಾ? Subsequently he did not appear before the court. ಆಯ್ತು. That's why how this judgment applicable ಹೇಳಿ ಅಷ್ಟೇ. 28. ಯಾವ ಇಯರ್? 18. 6/9, 16/8, 28/9, 6/9, 28/9. ಹೌದು. ಕೇಸ್ ಕಾಲ್ಡ್ ಔಟ್. Complainant and counsel for the complainant are present and the accused and counsel for the accused absent. And perusal of the order sheet it reveals that complainant himself examined as PW1 when the matter was posted for cross examination PW1 and subsequently the accused has failed to appear before this court and accordingly to secure his presence before this court NBW has been issued against him. And same as unexecuted and accordingly the bail bond stands cancelled and cash rupee amount of 5,000 deposited and so at the time of the last and bail is forfeited to the state. Since the present complainant is summary trial in nature and quasi criminal in nature and it is likely like recovery proceedings process of PW1 is taken as no process and recording the statement of accused and the is hereby dispensed with. And as for the new amendment act 144, the accused has failed to file an application for producing his defense evidence and accordingly defense evidence is taken as no evidence. What is the wrong in the order? Huh? 3663. Is it a case of after the examination of the accused was absconded? Is it a case of after the examination of the complainant in the presence of the accused? Not holding a trial. Therefore, in a criminal trial where the presence of the accused is a must, the accused appear agilla. Where the presence of the accused could not be secured in the manner known to law within a reasonable time, the case against such accused will have to be split up in the manner as provided under chapter so and so. ಹೌದು. ಟ್ರಯಲ್ ಕಮೆನ್ಸ್ ಆಗಿದೆ. The same will be the procedure applicable even in cases instituted so and so. Yeah, this is prior to the amendment of section 148 alva. This is prior to the amendment. Amendment ಆದ್ಮೇಲೆ ಏನಂತಿದೆ ಈಗ? After the amendment. That's what the trial court has observed. Not find any application even for reducing evidence. And after the examination only, when the witness present for 6 times, no cross examination was done by the counsel, and subsequently the accused also not appear. Third. Third, the petitioner, counsel, and also the counsel appearing for the respondent on IA 1/22 for release of amount. Have you filed any statement of objections to IA? Hakidra illa? Hakilla. The counsel appearing for the respondent appellate complainant pays this court to release the amount of rupees 1 lakh. But ನೀವೇನ 2.5 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀನಿ ಅಂತೀರಿ? ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೀರೇನ್ರಿ? ಕಟ್ಟಿಲ್ವಾ? ರಿಲೀಸ್ ಬಿಟ್ಬಿಡ್ರಿ, ಕಟ್ಟಿದಾರ ದುಡ್ಡು ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲ, ಅವ್ರ ಪ್ರಕಾರ 2.5 ಲಕ್ಷ ಕಟ್ಟಿದ್ದೀರಿ, ನೀವು ಬರೀ 1 ಲಕ್ಷಕ್ಕೆ ಮಾತ್ರ ಕೇಳ್ತಾ ಇದೀರ. ಅದಕ್ಕೆ ಇಲ್ಲಿ 1 ಲಕ್ಷ ಕಟ್ಟಿದಾರ. ಈಗ ರಿಲೀಸ್ ವೆರಿಫೈ ಮಾಡಿ, ಅದಕ್ಕೂ ಇನ್ನೊಂದು ಅರ್ಜಿ ಹಾಕಿ ಕೊಟ್ಟಿದ್ದೆ, ವೆರಿಫೈ ಮಾಡಿ ನೋಡಿ. ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ರಿ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ಕಟ್ಟಿರ್ಬೇಕು ನೋಡ್ರಿ. ಅಪೀಲ್ ಇಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್, ಅಪ್ಲೇಟ್ ಕೊಟ್ರ ರೆಕಾರ್ಡ್ಸ್ ಅಥವಾ ಇಲ್ಲಿದೆ ಇದೆಯಾ ನೋಡಿ. After disposal ಇರುತ್ತೆ ನೋಡಿ ಮೇಡಮ್. After disposal, during the pendency of the appeal, any amount is deposited before the appellate court records ಇದೆಯಾ ನೋಡಿ. ಅಲ್ಲೇನ ಸ್ಟೇ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಏನಾರು ಆರ್ಡರ್ ಮಾಡಿದಾರ? Permitted to deposit on or before 25/4/2019 final ಎಂತಿದೆ? ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ ಇಲ್ರಲ್ರಿ? ಇಲ್ವಲ್ಲ ಎಲ್ಲೂ ನಮ್ಮಲ್ಲಿ ಇಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ. The petitioner was required to deposit 50% of the fine amount imposed by the trial court, but he has deposited sum of rupees 1 lakh only. The amount deposited by the petitioner is accepted. In view of the reason stated, IA number 2 is allowed 6 weeks time granted to deposit balance sum of rupees 50,000 ಅಂತಿದೆ. ಇದಂಗ ಆಗ್ತದ್ರಿ 50,000 ಚೆಕ್ ಅಮೌಂಟ್ 5 ಲಕ್ಷ ಅಲ್ವಾ? 1 ಲಕ್ಷ ಏನ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರೆ? ಇಲ್ಲ ಅಲ್ಲ ಇಲ್ಲೂ ಮಾಡಿದಾರೆ. ಇಲ್ಲ ಫೈಲ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಫಾರ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಇಂಟ್ರಿ ಮಾಡರ್ ಡೇಟೆಡ್, ಅದಕ್ಕೂ 50% ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ. ಅಯ್ಯ ಹಾಕೊಂಡಿದ್ದೀರಿ. ಎಲ್ಲಿದೆ ಮತ್ತೆ ಕಟ್ಟಿರೋ ದುಡ್ಡು? 1 ಲಕ್ಷ ಅಲ್ಲ ರೀ. ಆಮೇಲೆ 50% ಅಲ್ಲಿ ಎಲ್ಲಿ ಕಟ್ಟಿದಿರಿ? ಫಿಫ್ಟಿ 50% ಕಟ್ಟಬೇಕು ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅದಿಲ್ವಲ್ಲ, ಅದೆಲ್ಲಿದೆ ಆ ಅಮೌಂಟ್ ಇಲ್ವಲ್ಲ ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು. ನೋಡಿ ವೆರಿಫೈ ಮಾಡಿ. ಬೋತ್ ದಿ ಕೌನ್ಸಿಲ್ಸ್ ಆರ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ವೆರಿಫೈ ಅಂಡ್ ಸಬ್ಮಿಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಡೆಪಾಸಿಟ್ ಮೇಡ್ ಬೈ ದಿ ರಿವಿಷನ್ ಪಿಟಿಷನರ್ ಆಸ್ ಡೈರೆಕ್ಟೆಡ್ ಬೈ ದಿಸ್ ಕೋರ್ಟ್. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 15th. ಅಷ್ಟೊಳಗೆ ವೆರಿಫೈ ಮಾಡಿ ಡೆಪಾಸಿಟ್ ಆಗಿದೆ ಏನು. LCR ಇದೆಯಲ್ಲ ನೋಡ್ಬಿಡಿ, ಕೊಡಿ. ಎಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ? ಬರೀ 1 ಲಕ್ಷ ಕಟ್ಟಿರೋದು ಮೇಡಮ್ ಅದು. ಹೌದು, ಅದು ಕಟ್ಟಿಲ್ಲ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಕಟ್ಟಿದ್ದಾರೆ ಯಾವ್ದು ಇಲ್ವಲ್ಲ, ಮಾಹಿತಿ ಏನಿಲ್ಲ. 50% ಆಫ್ ದಿ ಫೈನ್ ಅಮೌಂಟ್ ಅಂತಂದ್ರೆ 5 ಲಕ್ಷದಲ್ಲಿ 2.5 ಲಕ್ಷ ಬರುತ್ತೆ. ಇಲ್ಲ ನೋಡ್ಲಿ, ಅವ್ರು ವೆರಿಫೈ ಮಾಡಿ ಅವ್ರು ಅಸಿಸ್ಟ್ ಮಾಡ್ಲಿ ಕೋರ್ಟ್. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 15th. ಮಾಡ್ತೀನಿ, ಅದು ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ. ಅಲ್ಲೂ ಡೆಪಾಸಿಟ್ ಮಾಡ್ರಿ, ಇನ್ನೊಂದು ಐ ಹಾಕಿ ರಿಲೀಸ್ ಮಾಡೋಣ ಎರಡೂ. ಆಮೇಲೆ ನೋಡೋಣ. ಹಾಕಿರೋದು 1 ಲಕ್ಷಕ್ಕೆ ಮಾತ್ರ ಹಾಕಿದಿರಿ. ಈಗ ವೆರಿಫೈ ಮಾಡಿ ಹೇಳಿ ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರೆ, ಎಷ್ಟು ಅಮೌಂಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ, ಇಲ್ಲೆಷ್ಟಿದೆ. ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಡೆಪಾಸಿಟ್ ಅವ್ರ ಪ್ರಕಾರ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೂ ಒಂದು ಹಾಕೊಳ್ಳಿ, ಆರ್ಡರ್ ಮಾಡೋಣ. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 15th. 24 ಯಾರಿಲ್ವಾ? ಇಶ್ಯೂ ನೋಟಿಸ್ 440 days ಇದೆಯಾ? ಬೇಡ. ನನ್ ಅಪಿಯರ್ಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 21st. 25 ಸೋಮಶೇಖರ KM CD of 366 days. None appears. This matter on 21st. Jairaj. Release of amount. Heard. The petition of counsel and also the counsel appearing for the respondent on IA 3/21 filed by the respondent for release of amount. This court ordered to deposit the 50% of the amount and accordingly amount has been deposited. The counsel appearing for the petitioner also says, petitioner also says no objection to release the amount. And 51 is allowed and directed to release the amount and proper identification in favor of the respondent. Same, Adunu same, 27 same, 28.
28 IPF for petitioner, my lord. I oppose the withdrawal of the amount.
Why?
My lord, in the event, my lord, reversal of judgment, my lord.
The reversal will order to.
We cannot recover the money from them.
Repay the amount. We will
already 40 lakhs. Already 40 lakhs which had been deposited in the appellate court, my lord, is withdrawn by them. This is 20 lakhs in furtherance of the order of this honorable court. Already
the amount deposited in the appellate court is already released in favor of the respondent.
Yes,
now why you are objecting before this court?
Because my lord already has taken that amount. The amount which had been admitted in the trial court, my lord, is 25 lakhs. That is the reason, my lord. They let this amount be kept in deposit, my lord.
That's all.
Please.
Heard the petitioner counsel and also the new respondent, respondent counsel. And IA number 1 of 22. The counsel appearing for the respondent has filed an application to withdraw the amount of rupees 20 lakhs, which is in deposit before the trial court. So illa.
Before the trial court,
consequent upon the order passed by this court. And counsel submits that the petitioner was ordered to pay a fine of rupees 2 crore 2 crores 10,000. 10,000
10,000 fine amount.
10,000.
2 crores, my lord, for
Fine
1
amount.
crore, 1 crore, 1 crore was the check amount.
Ah,
Double the amount had been.
right.
Deposit is in as per the orders of the courtsman.
And the amount which was in deposit as directed by the appellate court already released in favor of the respondent. And the counsel would submit that check amount is rupees 1 crore and double the amount is awarded.
Admitted amount is 25 lakhs.
Counsel would submit that. According to you, admitted amount is
It's 25 lakhs.
25 lakhs. I thought. Right, madam. The counsel appearing to the respondent, petitioner would submit that matter amount may be kept in FD. On the ground that if the revision petitioner succeeds, is very difficult to recover the amount.
And he has also filed civil suit.
The counsel also submits that admitted amount is 25 lakhs. And already released an amount of rupees 40 lakhs. 40 lakhs as ordered by the appellate court.
They have also filed suit in civil court.
And also filed a separate suit in civil court. Having heard the petitioner counsel and also the counsel appearing to the respondent and also taking into note of material and record, check in question is for rupees 1 crore and trial court after considering material and record ordered to pay double the amount, that is 2 crores and an amount of rupees 40 lakhs was released in terms of the order passed by the appellate court. The very contention of the petitioner counsel that admitted amount is only 25 lakhs. And already there is a concurrent finding by both the trial court as well as the appellate court. And when such being the factual aspects of the case and consequent upon order passed by this court, an amount of rupees 20 lakhs is deposited before the trial court. And having taken note of the material and record, and also the contention urged by the revision petitioner, it is ordered to release the amount in favor of the respondent with proper identification, the amount in deposit, that is 20 lakhs. 20 lakhs.
In the indemnity application, the bond may be executed. Bond may be executed in the event of
Right. Accordingly, he has disposed of. ಏನು earlier ಏನಾದ್ರು ಆರ್ಡರ್ ಇದೆಯಾ? ಅಪ್ಲೈ ಮಾಡಿದಾರಾ? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನಿಲ್ಲ. ವೈದ್ಯರ ಇದು ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ನೋಡಿ ಮೇಡಮ್ ಹಿಂದೆ. ಏನಾಯ್ತು ಅವಾಗ ಏನಾಯ್ತು? Charge sheet. Directed to produce the charge sheet. List after 2 weeks ಅಂತಿದೆ. ಏನು charge sheet? ಏನ್ ಪಾಸ್ ಓವರ್ ಮಾಡನ್ನು ಅಥವಾ ಏನ್ ಬರ್ತಾರ ಅಥವಾ ಡೇಟ್ ಕೊಡನ್ನು ತಗೊಳ್ಳಿ. Petitioner counsel is absent and this court by order dated 8/2/22 directed the petitioner counsel to produce the charge sheet. ಹಾಕಿಲ್ಲಲ್ಲ ಮೇಡಮ್? And in spite of the order, no charge sheet is filed as directed and no representation also. However, in the ends of justice, one more opportunity is given. List this matter on 21st.
My lord, appearing for the petition, my lord. My lords, on the last petition, my lords, we mentioned that the matter has been compromised, my lords. And thereafter, my lords, my lord directed us to find the decisions in respect of the post-conviction compromise, my lords. The decisions are ready. May kindly pass over the matter, my lords.
Pass over, right.
Yes. Much obliged.
31. S.T. Bhagwan, N.R. Girish for R1, Rajaram Suryambal for R2. Rajaram Suryambal, ಯಾರಿದಾರ? ಆಟ್ ಟು ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತಿದೆ, ಅವ್ರದ್ದೇನಿಲ್ವಾ? R1 ಆಯ್ತು, ಹೇಳಿ ಏನು? Page 15. 15.
Section 340 CRPC describes who can take cognizance of the offense. The document agreed response, if it is not produced in court and not evidence, then any party can file complaint. Once all the document admitted in evidence, that except this work in which it is produced, no other person can file the complaint for the offense punishable. This is completely against the canon of the law made of the text. As also, this letter number 411 is subsequently important. In 2009, 3 SSC 380. The other was the Constitution bench of the Apex Court. The case reported in the area of Supreme Court 2119 has held that is the document is in custodial registry and it is not fabricated. May read what it says. Discussion made about
ಇದು ಅವ್ರಿಗೆ ಕೊಡಿದ್ದು ಹಳೇದು, ಅದು ಹಿಂದಿನ ಅಡ್ವೊಕೇಟ್ ಯಾವ್ದು 2005. ಸೇಮ್ ಮೇಡಮ್, ಸೇಮ್ ಇದ್ದಂಗೆ.
In view of the discussion made about, we are of the opinion that such not sin has been correctly decided. The view taken by is correct. Section 191B2 CRPC would be attracted only when the offences enumerated with the said column have been committed with respect to the document after it has been produced or given in evidence in the proceeding in the court. Namely, during the trial when the document was in custodial registry. In the present case, we have been produced in court subsequently. It is not this case that the offense as enumerated in Section 192 was committed in respect to the subject after it had been produced or filed in court. Therefore, by creating the Section 192 CRPC would not come into play. There is no embargo on the court to take cognizance on the basis of complete fact. The same effect, the magistrate as lawyer. Therefore, the complaint which has been dismissed on the ground, that ground is non-exercise of the jurisdiction vested in the magistrate. Therefore, the orders will be second.
That's all. That's all. Yes. Yes, counsel. Counsel for respondent.
Not supported by any. Now, here the case is power. That judgment perhaps not the take the judgment. 2015.
ಆಯ್ತು ಅದೆಲ್ಲ ಗೊತ್ತು ಹೇಳಿ ನೆಕ್ಸ್ಟ್. ದಟ್ ಇಸ್ ದಿ ಕೇಸ್ ಇನ್ ಬ್ಯಾಂಕ್ ಅಫಿಷಿಯಲ್ಸ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದ್ದು ಸರ್ಫೇಸ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ. ಶ್ರೀವಾತ್ಸವ ಕೇಸ್ ಅಲ್ಲಿ 156(3) ನಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವೈಲ್ ಕ್ವಾಶಿಂಗ್ ದಿ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ವೆನ್ ದಿ borrower had lodged the complaint against the bank officials. That's why the Supreme Court comes to the conclusion that a false complaint is filed against the bank officials and this mischief has to be curbed. That is the reason only the principles laid down in that judgment. Srivatsava case. ಆಯ್ತು ಹೇಳಿ ಎಷ್ಟು ಹೇಳಿ.
In general, all private companies
But the reason given by the trial court, that is not the ground. Apart from other arguments, that is one ground.
A bill of exclusion. In that bill, there are registered three witnesses. While producing before the world original to appear, one of the witnesses, Vaishnav has put in that's why they can't.
Whether that witness was present at the time of registration of the will or not.
And 2018, the complaint after 6 years, complaint is lost.
What is the finding of the trial court in that suit? Suit still pending. Dispose agide. What is the finding with regard to the suit dismissed regarding tampering of document? What is the finding of the trial court?
The bill would have been support of that is not allowed. But the suit is decreed. Not in my support of the decree. I have your
My question is, while disposing of the matter suit on merits by the trial court, what is the finding with regard to the fabrication and tampering? Any finding?
Finding, there is no allegation in that's number one. You don't know. That all conflict complaining. As the bill came to be produced by tampering outside the court.
If the court proceedings, any document is produced, then it is tampered or forced or anything is done, then section 340 attracts.
Six years later, the complaint so supporting that how not only from pertaining to bank cases. All private companies, they never want to see
because the Supreme Court comes to the conclusion that it is an abuse against the legal agency which they have invoked the Surface Act. And that juncture, the borrower had indulged in filing a complaint which is not supported by the affidavit. That's why the Supreme Court comes to a conclusion that it is nothing but an abuse of process. That's what the principles laid down in that judgment. She was a case.
The guidelines what the Supreme Court stated, all the
ಬೇಕಲ್ಲ, ನಾನು ಅದು ಓದಿದ್ದೀನಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅದಕ್ಕೆ. ಆಯ್ತು, ಅದು ನಾನು ಅಂಡರ್ಸ್ಟುಡ್. ರೀಸೆಂಟ್ ಆಗಿ ಮೊನ್ನೆನೂ ಒಂದು ಹೇಳಿದಾರೆ ನೋಡಿ, ಇನ್ ಕೇಸ್ ಆಫ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಫಿಡವಿಟ್, ಈಗ ಒಂದು 15 ದಿವಸದಿಂದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರೇ ಹೇಳಿದ್ದಾರೆ. ಮತ್ತೊಂದು ರೀಸೆಂಟ್ ಆಗಿ ಒಂದು ಹೇಳಿದ್ದಾರೆ 15 ದಿವಸದಿಂದ. Now only your argument is with regard to not supported by affidavit. Is any other ground? Delay. Delay in lodging complaint. Since document was produced in 2012, how that? Since will produced in 2012. Complaint filed in the year 2018. In 2018. Delay. Right, next. But this court also comes to the conclusion that if affidavit is not filed, that is a curable defect, matter can be referred back to the trial court and then complainant can be given an opportunity to file the affidavit. That is also there. Adana. ಆಯ್ತು ಅದೆಲ್ಲ ಬೇಡ ನಮ್ಗೆ. ನಮ್ಮ ಮುಂದೆ ಅಷ್ಟೇ, ನಮ್ದು ರಿವಿಷನ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಮಾತ್ರ ಹೇಳಿ ಅಷ್ಟೇ ಸಾಕು. ಹೇಳಿ. ಎನಿ ಅದರ್ ಗ್ರೌಂಡ್ ಹೇಳಿ. ಕೊಡಿ ನೀವು ರಿವರ್ಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತಂದ್ರೆ. ಓದೋದು ಬೇಡ, ನಾನು ಓದಿದ್ದೀನಿ ಸೆವರಲ್ ಟೈಮ್. ಅದು ಕೊಡಿ, ಅದು ಕೊಡಿ. ಇದ್ರೆ ಅದು ಕಾಪಿ ಹಾಕಿದೀರಾ? ಯಾರು ಹಾಕಿದಾರೆ? ಅವ್ರೇನು ಹಾಕಿಲ್ಲ. ಅವ್ರು ಹಾಕಿರೋದು ಓನ್ಲಿ ಒಂದೇನೋ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ. ಅದು PCR ಮಾತ್ರ. ಇಲ್ಲಿ PCR ಕಾಪಿ ಮಾತ್ರ ಇದೆ, ಅದಕ್ಕೆ ಬೇರೆ ಏನಿಲ್ಲ. ಅಂಡ್ ಆಮೇಲೆ ಆರ್ಡರ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಜೆಕ್ಟಿಂಗ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಅಷ್ಟೇ ಇರೋದು. ಸೊ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕಾಪಿ ಇದ್ರೆ ಕೊಡಿ. ವಿಲ್ ಸಿ ವಾಟ್ ಈಸ್ ದಿ ಅಬ್ಸರ್ವೇಷನ್ ಅಂತ. ಇನ್ನೇನು ಬಂದಿದೆ? ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಕೊಡಿ, ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ ನೋಡೋಣ. ಒಂದ್ ಸೆಕೆಂಡ್, ನಿಮ್ಗೆ ರಿಪ್ಲೈ ಕೊಡ್ತೀನಿ ಅವಕಾಶ. ಇದು ವಾಯ್ಸ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್. ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಎಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. RA ಕಾಪಿ ಇದೆ. RA 585 of 2016 ಅದೇನಾ? OS ನೋಡ್ತಾ OS 138 of 10 ಕರೆಕ್ಟಾ? 138 138 ಆದ್ಮೇಲೆ RAನಾ? ಸೇಮ್ RA ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. 585 of 2016 ಎರಡು ಇದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಬೋತ್ ದಿ ಕೋರ್ಟ್ಸ್. ಆಯ್ತು, ನಿಮ್ಮೇನ್ ಇದೆ? ರೆಕಾರ್ಡ್ಸ್ ಇದೆ. ಆಯ್ತು. ಏನ್ ರಿಪ್ಲೈ ಹೇಳಿ?
Such on 4/2/16. The date of disposal of the said person so. And on 17/10/2017, the date of the said RA, he was disposed of. Complaint was filed on 10/7/2018. The explanation is that ordinary. I'm not responsible.
Result. ಅದೆಲ್ಲ ಕೊಡಿ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ. ಐ ವಾಂಟ್ ಟು ನೋ ದಿ ರೀಸನ್ಸ್ given by the trial court. 32 ಕಾಶಿನಾಥ್ ಜಿಡಿ. ಇದು ನೋಟ್ಸ್ ಇಡಿ ಮೇಡಮ್. ನಂಬರ್ ಕೊಡಿ ಆಯ್ತಾ. ಟುಮಾರೋ day after tomorrow ತಗೊಳ್ಳಿ. Both the council submits that already matter is settled and going to find a giant memo and else list this matter day after tomorrow. 9th 33 na ಅವ್ರದೇ ಎರಡೂನು ಸೇಮ್ ಅವ್ರದೇ. 34 ನಾಗರಾಜ್ ಡಿ. ಇಲ್ವಾ ತಗೊಳ್ಳಿ. petitioner counsel absent list this matter on 21st. 35 Rudrappa P, Sachin BS. Dismissed on for non-prosecution. Page number 23. CRPC is dismissed for non-prosecution with no order as to cast bail and surety bonds also detentions are cancelled. Return the trial court records along with the system task. Why it was dismissed, counsel? Hello, why it was dismissed? ನೀವು ಯಾವಾಗ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಒಂದೇ ನಿಮಿಷ. The appellant shall execute a bond with surety for 10,50,000. Appellant shall deposit a sum of 2,10,000 before the trial court. Deposit ಮಾಡಿಲ್ಲ ಆಯ್ತು ಒಂದು. ಆಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಏನು ಹಾಕಿದೀರ ಮತ್ತೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ ಅಮೌಂಟ್ extend the time to deposit the amount. Counsel for the appellant has filed application ಇದೆ ರೀ. ಆಯ್ತು. ಆಮೇಲೆ 20% of the compensation fine amount has to be order extended till 4/11/2019. ಆಮೇಲೆ appellant and his counsel are absent, no representation. Case is advanced on the application of the learned counsel for the appellant. Appellant is present. The learned counsel for the appellant has time to comply the order. Again, grounds made out are satisfactory, hence time extended. Again 2012 ಹೋಯ್ತು ಮತ್ತೆ ಹೌದಾ. Case called out parties present for compromise ಅಂತ ಆಯ್ತು. Case called out parties present, matter is conciliated. Present matter is conciliated, compromise could not be arrived at. Next matter is conciliated. Case is advanced on the application. Appellant is present. Counsel for the appellant files the application for extension of time again. Notes made out are satisfactory. Now extended to 4/1/2020. Wakalat on behalf of the appellant after obtaining no objection from so and so. Grounds are made out are satisfactory. Extended till 18/1/2020. ಮತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರನ್ರಿ. ಎಷ್ಟು ಸರಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದಾರೆ ಡೇಟ್? ನೆಕ್ಸ್ಟ್ ಅವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಪ್ಲಿಕೇಶನ್, ಅದು ಅಲೋ ಆಗಿದೆ. Case called out, respondent is present, appellant and her counsel are absent, the trial court records are received, no representation. Case is kept by for hearing on main appeal. Case again called. ಮೂರು ಸರಿ ಕರ್ಸಿದ್ದಾರೆ, no representation. Hence the following. ಆಯ್ತು ಹೇಳಿ. ರಿಮೈಂಡ್ ಮಾಡ್ಬೇಕ. ಯಾರು ಅದರ್ ಸೈಡ್ ಸಚಿನ್ ಇಲ್ವಾ? ಸಚಿನ್ BS ಪಾಸ್ ಓವರ್ ಮಾಡಿರಿ ನೋಡೋಣ ಬರ್ತಾರ. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಷ್ಟೇ ಅಲ್ಲ, ಓನ್ಲಿ ಫಾರ್ ರಿಮೈಂಡ್. Nataraj BS. Suspension of sentence and bail. Nagamani NOC. K. Nagabhushan Reddy. Hear it. Not led. Why? An opportunity is given or not? Not given. Why? Cross examination ಮಾಡಿದಿರಾ?
Immediately the matter was posted from judgment and argument turned on the same day.
Order sheet ಹಾಕಿದಿರಾ?
Inquest number 34.
34.
17/4/2018. I have cross-examined the PW1. The matter posted on 18/5/2018 for the
Complainant present, accused absent, EP filed, same is allowed, accused filed application on 311 of CRPC, complainant submits to allow the said application and payment of cost. Accordingly, permitted the accused to reopen the case for purpose of cross examination of PW1. Present PW1 cross examined by the accused counsel. 313 statement complainant and accused absent. Accused filed EP, same is allowed. 313 statement by 26 and 5. Complainant present, accused absent, no representation. In spite of opportunities, accused is not present for 313 statement. Hence, complainant counsel pressed to pass judgment. Accordingly, as per the ratio of Honorable Apex Court reported in 2014, Supreme Court cases 590 between Indian Bank Association and others versus Union of India and others, and the statement of CRPC is dispensed.
on that the warrant was not issued.
Yeah.
Warrant was not issued.
Right. So defense evidence ಅಂತ ಮತ್ತೊಂದು ಅವಕಾಶ ಕೊಟ್ಟರು. Dispensing the accused absent, EP filed, same is allowed for defense evidence ಅಂತ ಮತ್ತೊಂದು ಡೇಟ್ ಕೊಟ್ಟರು. ಹೌದಲ್ಲ? ಅಂದಡ್ಡೆ ಅಲ್ರಿ ಮತ್ತೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡ್ರಿ, 3 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ 23/6 ಕೊಟ್ಟಿದಾರಲ್ಲ. EP ಫೈಲ್ ಮಾಡಿದ್ರು ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಗೆ ಮತ್ತೊಂದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. 23/6 ಇಂದ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅವತ್ absent, no representation, hence defense evidence taken as closed ಅಂತ ಆಗಿದೆ. Then again ಮತ್ತೆ posted for arguments. ನೀವೇನ್ ಮಾಡಿರಿ ಹೋಗಿ ಆಮೇಲೆ arguments ಪೋಸ್ಟ್ ಆದ್ಮೇಲೆ? ಹೌದು, ನೀವೇನು ಹೋಗ್ದವ್ರು ನೀವೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ PW1 ಆದ್ಮೇಲೆ ನೀವೇನ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ? Not only one day, not only one day. Chief examination ಆಗಿದ್ದು ಯಾವಾಗ ಒಂದು ಫಸ್ಟ್? ಅದೇ ಸ್ವಲ್ಪ ಹಿಂದೆನಾ, ಯಾವಾಗ ಅಂತ ಕೇಳಿದೆ. Even LBW also recalled with
24/11. And they appeared and obtained the bail. And the same day the LBW has recalled the cross examination of PW1.
This witness was examined.
Statement ಆಗಿದ್ದು chief examination ಅಂತ consider ಮಾಡಿದ್ದಾರೆ. chief examination
2/11/17 ಅಲ್ರಿ? ನೀವು ಅಪೇರ್ ಆಗಿದ್ದೀರಲ್ಲ? ಆಗ 24/11 ಅಪೇರ್ ಆಗಿದ್ದೀರಲ್ಲ ನೀವು? ಹೌದು. No. NBW is recalled. Substance of accusation read over and explained to the accused. He pleaded not guilty, plea recorded. KVP advocate has filed an application on section 145(2) of NI Act. Heard perused application is allowed. For class of PW1 ಅಂತ post ಮಾಡಿದ್ದಾರೆ. PW1 ಅಂದ್ರೆ 10/1 ಡೇಟ್ ಕೊಟ್ಟರು. 10/1 ಏನಾಯ್ತು? PW1 present, accused absent, no representation. ಅವತ್ತು ಇಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಡೇನು ಇಲ್ಲ, 4/2/18 ಇಲ್ಲ. ಆಮೇಲೆ 3 ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ಲ ಅಂತ ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ, ಆಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ, ಅಲ್ಲೋ ಆಗಿದೆ, ಅದು ರೀಕಾಲ್ ಆಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ. ಸರಿ, ಎಲ್ಲಾ ಸ್ಟೇಜ್ ಅಲ್ಲೂ ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ನೋ ಗ್ರೌಂಡ್ಸ್. ಇನ್ ರಿವಿಷನ್ ಅಲ್ಲ, ರಿವಿಷನ್ ಅಲ್ಲಿ ವಾಟ್ ಆರ್ ದಿ ವೆರಿ ಗುಡ್ ಗ್ರೌಂಡ್ ಹೇಳಿ. ಯಾವ ಕೇಸು ನಡ್ಸಂಗಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಇಲ್ಲಿ ಬಂದು ರಿವಿಷನ್ ಅಲ್ಲಿ ರಿಮೈಂಡ್ ಮಾಡಿ ಅಂತ ಕೇಳು. ಮತ್ತೆ ಇನ್ನೇನ್ ಕೇಳ್ತಾ ಇದೀರಿ ನೀವು ಹೇಳಿ? ಈಗೇನ್ ಕೇಳ್ತಾ ಇದೀರಿ ಹೇಳಿ? ವಾಟ್ ಈಸ್ ಯುವರ್ ಪ್ರೇಯರ್ ನೌ ಬಿಫೋರ್ ದಿ ರಿವಿಷನಲ್ ಕೋರ್ಟ್? ವಾಟ್ ಈಸ್ ಯುವರ್ ಪ್ರೇಯರ್? ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ನೀವು ರಿಲೈ ಮಾಡ್ತಾ ಇರೋದು? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಪೇಜ್ ನಂಬರ್, ಪೇಜ್ ಹೇಳ್ರಿ. ಪೇಜ್ 5 ಜಡ್ಜ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದೀನಿ, ಎಲ್ಲಿದೆ ಅಂತ ನೀವು ಹಾಕಿರೋ ಪೇಜ್ ಎಲ್ಲಿ? ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಣ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದೀನಿ. ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಪೀಲ್ ಇದೆ, CC ಆಮೇಲೆ ಹಾಕಿದ್ರಾ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ? ಹೇಳಿ ಪೇಜ್ ನಂಬರ್ 5 11 ಹೇಳಿ. Except there is no defense evidence has been placed by the accused, except appearance. There is no rebuttal evidence to display the complaint case. Of course, PW1 is prosecuted by the accused counsel, but nothing is elicited any important points. On the other hand, and perusal of exhibit P1 and P2, P6 documents, it is clear that the accused has issued check for legally enforceable debt. Thereafter, it was dishonored. In spite of service of notice, accused has not complied as per section 138 of the. So, attitude of the accused indicates to the court that he has intentionally to dismiss the complaint as issued exhibit P1. Accordingly, accused liable for the offence 138 of in Act, because the material faced by the complainant corroborates with each other with respect to the involvement of legally recoverable debt under exhibit P2 as a ratio laid down in judgment 160. Only what is your defense in the class examination of PW1? Where is the evidence? What is your defense? As well as guidelines issued by the Honorable High Court on express disposal of the account. I am of the opinion. What is wrong in the order? No, what is your defense? At least nim ground and revisional. Revisional and ground read. No opportunities given. Ashtana?
Consideration and talking.
ನೋಡಿ ಇದಾರ ಅದರ್ ಸೈಡ್ ಯಾರು ನಾಗಮಣಿ ನೋಡ್ರಿ, ಇದಾರ NOC ನಾಗಮಣಿ ಅಂದ್ರೆ ಯಾರು NOC ಕೊಟ್ಟಿರಾರ ಅಥವಾ ಈಗ ಹಾಕಿರಾರ? ಈಗ ಹಾಕಿರೋದು ನಾಗಭೂಷಣ್ ರೆಡ್ಡಿ ಹೆಸರು ಡಿಲೀಟ್ ಆಗ್ಬೇಕಾ ನೋಡಿ. Heard the petitioner counsel and counsel seeks time to produce the deposition of PW1. Respondent counsel is absent. The office is directed to delete the name of K. Nagabhushana Reddy since P. Nagamani has filed Wakalat with NOC. This matter day after tomorrow, 9th. 9th March. Kodi ad noda nimge effective cross examination enar madidira. Nirlagi Jeevan Babu. Annamalai for R1 and R2. Then what is the matter? Oh, last time, you know, this matter was heard. Copies of notice dated 21/10/2018. Exhibit P2 issued by the department. This is dated 21/10/2018. This is represented. The Commissioner of Income Tax TDS, 1 second. This is not in respect of reply. What is the order? Why the prosecution should not be initiated against him for the offense punishable by Section 276A of the Act. Exhibit P2 notice cannot be considered as the notice under Section 235 of the Act. Without the notice under Section 235 Act cannot be tried as the accused, along with accused number 1. Where is the contents of in Exhibit P2? In compliance of Section 235 of the Act. Only you have called for explanation, otherwise you are going to be prosecuted. That's what the observation by the. I am not on merit counsel. Only whether it is in the notice which you are relying upon Exhibit P2 is in compliance with Section 235 of the Act. Where is that content?
Be able to develop in another year. But the department
Huh? Huh?
another year.
Not another year. For the year.
Year under reference, I have asked the department to get hold of the land.
This is the document exhibit P2 was marked before the trial court.
P2 is not P2 is so called that
Yeah?
P2
Ah.
is there. So called.
Because trial court record the document exhibit P2. Which is the document exhibit P2?
P2 is this matter.
Yeah, this one. The observation made by the trial court is correct. Nothing is referred with regard to section 235. What is wrong in the order?
Order the same thing is mentioned.
Huh?
Order P2 is only mentioned.
P2 is mentioned. What is the wrong in the order? The observation of the trial court that on perusal of exhibit P2, it cannot be considered as the notice under section 235 of the Act. No grounds. The reply is also not in respect. Reply is also not in respect of the notice. Exhibit P2. Then exhibit P2. There is mark the exhibit P2. P2. Here is a P2. Note. The petitioner, counsel, and also the counsel appearing for the state. The state or the respondent. This revision petition is filed challenging the order passed by the trial court dated 7/12/2019, discharging the second respondent in CC number 89 of 2019. The factual matters of the case is that the proceedings is initiated against the respondent herein, who has been arraigned as accused number 2. Invoking the offence under section 276B of the Income Tax Act 1961, wherein an application is filed for discharge from the charge of offence contending that accused number 2 is not the managing director of accused number 1 and only the director of the accused number 1, and hence falls under the charging of section 235B of the Act, which requires a notice to treat him as the principal officer of the accused number 1. The mandatory requirement is not complied. Hence, accused 2 cannot be treated as principal officer of the accused number 1. The notice dated 21/10/2018 cannot be considered as the notice under section 235 of the Act. It is contended that income tax officer within bracket TDS, do not have the jurisdiction to issue such notice. The Commissioner of Income Tax TDS did not issue the show cause notice to the accused number 2 before according to sanction. The accused number 2 is not involved in day-to-day affairs of the accused number 1. The complaint is filed without the direction of the officers stated in the proviso annexed to section 279(1) of the Act. Hence, the prosecution is not valid. Even if the offence is committed, it is without the knowledge of the accused number 2. Hence, is not liable for any punishment in view of the proviso attached to section 278 of the Act. The qualified persons in the account department of the accused number 1 was entrusted with the responsibility of deducting TDS and remitting the TDS. The accused number 2 has not signed on form number 16A. It is contended that single order of sanction is passed for the entire financial year, but the TDS returns and statements are filed once in a quarter. The complaint is not filed within 30 days from the date of passing the sanction order. It is contrary to the standing operating procedure. The complainant has filed objection statement before the trial court contending that all the procedure and legal requirements have been followed. Whether there exists justifiable reasons for not remitting the TDS or the accused number 2 was not in charge of the affairs of the accused number 1 is the matter of trial, and hence prayed to reject the application based on the contentions taken by the respondent herein and also the objection statement by the petitioner herein. A point for consideration was considered by the trial court whether the accused number 2, that is respondent herein, proves that there are no evidence to claim the charge against him, along with accused number 1. The trial court, while answering the point for consideration, comes to the conclusion that there are no materials to claim prima facie that accused number 2 was treated as the principal officer of the accused number 1, so as to try him along with accused number 1 for the offence punishment under section 276B of the Income Tax Act. Consequently, the application is allowed and discharged the accused number 2. Hence, the present division petition is filed before this court. The counsel appearing for the petitioner would vehemently contend that the court below has committed an error in coming to the conclusion that there are no prima facie materials to hold that respondent number 2 herein was treated as principal officer of the first respondent company, has to try him along with respondent number 1. The very approach of the trial court is erroneous. The trial court has held that no notice is issued to the respondent number 2 herein, and same is mandatory. The court also relied upon the judgment passed in ITO versus Roshini Gold Storage and Homi Firoj versus State of Maharashtra, rendered by Madras High Court and Bombay High Court. The trial court has held that notice issued under section 235 of the Act, which is served on respondent number 2, cannot be considered as notice issued under said section since it is not stated in said notice that respondent number 2 herein was in charge of day-to-day affairs of the company. The very finding of the trial court is erroneous, and the very approach of the trial court that notice issued under section 235 was valid and legally sustainable one, and the same has not been considered by the trial court in a prospective manner, and hence it requires interference of this court. This court, after hearing the matter, also directed the petitioner to place the document exhibit B2, wherein any thing is stated with regard to the compliance of section 235 of the Act, and produce the document dated 21/10/2018. The council would submit that in terms of the letter dated 21/10/2018, having not remitted the amount, notice was issued and so-called notice also given. For contra, the council appearing for the respondent would submit that the trial court, having considered the grounds urged by the respondent and also the contention of the complainant in detail discussed in paragraph number 7 to 15, and while arriving for conclusion, taken note of exhibit P2. In paragraph number 17, has observed that in terms of the notice, only accused number 2 was asked to show cause as to why the prosecution should not be initiated against him for the offence punishment 276B of the Act. But categorical observation is made that exhibit P2 notice cannot be considered as the notice under 235 of the Act. Without the notice under section 235(2) of the Act, the accused cannot be tried as the accused along with accused number 1, and hence ordered to discharge the respondent. And hence there is no any merit in the revision petition to exercise the revisional jurisdiction. Having heard the respective counsel and also on perusal of petition available on record, and no doubt in terms of Exhibit P2, notice issued against the respondent number 2, a categorical averment is made that from the records they have deducted an amount of Rs 4,69,806 and not remitted the amount. And hence, in paragraph number 3 also stated with regard to the punishment provided. And also as put to show cause notice and asked in the notice to show cause for non-payment of amount. First of all, the very contention of the respondent before the court before the trial court that he is not the managing director, and only he is the director of the accused number 1. Hence, under section 235, which requires a notice to treat him as the principal officer of the accused number 1, the mandatory requirement is not complied. And the very contention is also that notice given in terms of Exhibit P2, it is not in compliance with section 235 of the Act. The trial court also taken note of several judgments while coming to such a conclusion. In paragraph number 17, categorically held that Exhibit P2 is not in compliance with section 2 within bracket 35 of the Act. The same cannot be considered as notice under section 235 of the Act. This court also directed the petitioner counsel to place the document Exhibit P2, whether the same is in compliance of section 235 of the Act. And on perusal of reading of document Exhibit P2 dated 21/10/2018, I do not find any error committed by the trial court in coming to the conclusion that Exhibit P2 is not in compliance with section 2 within bracket 35 of the Act. And except the issuance of show cause notice, that provision of section 276D provides the punishment, that is imprisonment, and he will be prosecuted. And the same is not in compliance with section 235 of the Act. The very reasoning given by the trial court is not suffers from any perversity or legality, and only scope of revision is if the order passed by the trial court is not in pursuance of the provisions, and if it suffers from any legality and correctness, then only can invoke the revisional jurisdiction. The reasons assigned by the trial court while coming to the conclusion that Exhibit P2 is not in consonance with section 235 of the Act, is not suffers from any legality and its correctness. And hence, I do not find any reasons to entertain the revision and set aside the order passed by the trial court in discharging the respondent number 2. In view of the discussions made up, I pass the following order. Revision petition is dismissed. Narasimharaj, along with office note. Petition of counsel seeks time. Compliance, office note to office objection for compliance of office objections. Hence, post the matter after compliance of office objections. 40. Narasimha Prasad. None appears. Third, petitioner counsel is absent. Is this matter of on 21st? SPPN read. What is the error? Discharge application allowed. Issue notice. Immediate PF could. Issue notice to respondent. Satish or DJ? An admission, huh? Today then. SDN Prasad ಅಂತಿದೆ ಇಲ್ಲ ಸತೀಶ್ ಅಂತಿದೆ ಯಾರು ಫೈಲ್ ಮಾಡ್ತಾ ಇರೋದು ಯಾರು 14 ಯಾವ್ದು ಡೇಟ್ ಕೊಟ್ಟವಲ್ಲ ಅದು ಹೌದಾ 40 ನಲ್ಲಿ ಹಾಕ್ತಾ ಇದ್ದೀರಾ ನರಸಿಂಹ ಪ್ರಸಾದ್ ನೋಡಿ petitioner counsel has filed memo for withdrawal on the ground that matter has already been settled before the Lok Adalat and hence he may be permitted to withdraw. You have the memo permitted to withdraw. 42 new respondent. They are not deposited. Is it a conditional order? Then you proceed against the petitioner. That's all. You can enforce the order. That's all. Totally. Petitioner counsel absent. Respondent counsel is present. Miss this matter on 21st. If it is a conditional order, you proceed with. That's all. 43. Harish Bandari.
Yes, I am for the petitions, Your Lordship.
Matad Mahesh Ayya Rudraya. Idiralla? Yes, counsel.
In this case, Your Lordship, we have made the payment of rupees 2 lakhs rupees before this honorable court, Your Lordship. In the matter
2 lakhs before this court.
Yes, yes. 50,000 something deposited before the appellate court, Your Lordship. However, the due of rupees 3 lakhs is existing. And in the meanwhile, it was some negotiation was going between the parties there in Your Lordship at Davangere, where the parties are. Subsequently, Your Lordship, ಏನಾಯ್ತು ಅಂತ ಅವರು ಬಂದು ಹೇಳಿದ್ರು ನಮ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ ಅವರು
ಏನಾಯ್ತು ಏನಾರು ಆಗಿದೆ ಏನ್ರಿ ಪಾರ್ಟೀಸ್ ಏನೋ ನೆಗೋಷಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಿಮ್ಗೆ ಏನಾದ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆಯಾ ಏನಿಲ್ಲ ಅಂತಲ್ಲ ಅವ್ರಿಗೂ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ನಿಮ್ಗೂ ಇಲ್ಲ ಅವ್ರಿಗೂ ಇಲ್ಲ
ಒಂದು ಡೇಟ್ ಕೊಟ್ಟು ನೆಕ್ಸ್ಟ್ ಒಂದು ದಿನದಲ್ಲಿ ಕೇಳ್ಕೊಂಡು ಆ ಮುಂದುವರ್ಸೋಣ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ 2.5 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ ಇವಾಗ
2 lakh ಆಯ್ತು ಟೋಟಲ್ ಅಮೌಂಟ್ ಎಷ್ಟು
5 lakhs 50,000 ಫೈನ್ 5 lakh 50,000 and 5.5 lakhs.
ಏನ್ ನಿಮ್ಮನವರೇನು ಹೇಳಿಲ್ವಾ ತೊಳಿ ಮೇಡಮ್ petitioner counsel submits that parties were negotiating the matter for settlement, but he is not having any instructions. And counsel appearing to the respondent also says that he is also not having any instructions and seeks 10 days time, and hence this matter on 10 days kalpodi madam no 17th 18th
18th
argument ಮಾಡಿ ಅವತ್ತು
ಇಲ್ಲ 18th ಬೇಡ 18th I am not
18th ಬೇಡ 18th ಬೇಡ ಅಂದ್ರೆ ಎಷ್ಟು ಇದೆ 21st
21st ಆಗ್ಬೋದು
ಆಯ್ತು 21st
ಮೀನ ಐವ ಕೊಟ್ಟಿದ್ದು ಒಂಚೂರು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು ಇಲ್ದೆ
ಎಂಟ್ರಿ ಮಾಡ್ರೆ
ಎಂಟ್ರಿ ಮಾಡ್ರು ಕೊಟ್ಟಿದ್ದು
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನಿದೆ ಸಬ್ಜೆಕ್ಟ್ ಡೆಪಾಸಿಟಿಂಗ್ 50% ಮಾಡಿದಿರಲ್ವಾ
ಮಾಡಿದ್ದೀನಿ ಇಲ್ಲಿ
ಮಾಡಿದಿರಾ ಇಲ್ಲ ಹೇಳಿ ಮತ್ತೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಅಯ್ಯೋ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನಿದೆ
2 lakhs ಅವರೇ ಕ್ಯಾಶ್ ತಗೊಂಡಿದ್ದಾರೆ ಕೋರ್ಟಲ್ಲೇ ತಗೊಂಡಿದ್ದಾರೆ
ಕ್ಯಾಶ್ ತಗೊಳ್ಳಿರಿ ಬಟ್ ಆರ್ಡರ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ acknowledged ಆಯ್ತು subject to final intended submission between the parties amicably settled. Counsel is directed to acknowledge sum of provisions with payment of rupees 2,55,000 is paid out of rupees 5,55,000. Bandari is also served. Rudrappa Lanesh also fine amount. To make submissions on the estate of hearing, Rudrappa counsel Hiramata Mahesh release this matter. ಏನಿಲ್ಲ ರೀ ಬರೀ ನೀವು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ರ ಬಗ್ಗೆ ಮಾತ್ರ ಮೆನ್ಷನಿಂಗ್ ಇದೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ they'll have the benefit of the interim order ಅಂತ in lieu of the payment of rupees ಅಂತ ಇದೆ ಅಷ್ಟೇ ಅದೇ ಯಾವತ್ತವರೆಗೆ ಅಂತ ಏನಿಲ್ಲ the revision petitions will have the benefit of the interim order ಅಷ್ಟೇ
Oblige, Lordship.
Venkat Reddy. Yes, madam. Non-compliance of office objection.
For the respondent, madam.
Already served the copy. Yes.
For the respondent.
Yes, counsel. Criminal appeal. Petition filed by the petitioner is allowed in part. Respondent is directed to pay maintenance of rupees 6,000 to the petitioner and her children as monthly maintenance. Out of petitioner is entitled for 4,000 till her marriage succeeds with respondent, and her children are entitled for 2,000 per month till they attain the age of majority. Madam, you are questioning the enhancement of maintenance of rupees. The petitioner is serving in Indian Army. When he was in the line of control, notice was and the order was passed on 15/9/2018. And on 15/10/2018, the respondent filed with Indian Army. Here, the petitioner has challenged appeared and challenged what is the error in enhancing the amount 9,000 plus 3,000? Page number 30, page number 38. Yes. 43,000. This is dated. I can produce a recent certificate what is his salary? 43,000. Now only 1/3 is ordered. 9,000 plus 3,000. Child 3,000. Is it possible to provide an education as well as provide food to the child at the rate of 3,000? Madam, no. Here you see basic pay 42,800 at page number. Military service pay 5,200. Total salary is 48,000. Deduction that is only deductions. After deduction only you are getting 43,000. Total salary is 48,000. She is already working. The wife is working, and she's working in international. She's joint service and also she's having a house. And, have you produced any document regarding this? And I've filed another supporting document. What is that supporting document? In that Have you produced these documents before the appellate court? No, I have not done so. Why? Because I was not having this. Now you see the house and it's now named Rescom. Rescom will explain page number 20. This case is filed only in retaliation after he filed the divorce petition. There is no domestic violence. He was that I will challenge. Where is the document regarding her employment? Employment I have not produced because I get to know now when. Unless you produce any document regarding employment is concerned, we merely because she is having a house, whether she is. She herself has applicant. Yes, madam. Even assuming that she is having a house. Maintenance is sought for her livelihood. The main divorce the act was filed only in retaliation with you. Whatever it may be, madam, is it not your duty to maintain your wife and child? Yes, sir. Now, you are in army also. ದೇಶ ಕಾಯೋನ ಜೊತೆಗೆ ಫ್ಯಾಮಿಲಿ ಕಾಯೋ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಇದೆ ಮೇಡಮ್. Why you are on depression? Oh. No, madam. Madam, if no material is placed before the trial court. Revision scope is very less. Revision scope is very less only if any order suffers from any legality and its correctness. Because 2 children are there. 2 children. How it is high, madam? You are drawing 48,000. You are drawing 48,000, madam. 10,000 plus 3,000, 3,000. One simple question: is it possible to maintain a child with the amount of rupees 3,000? That is secondary, madam. Maybe she's. No, madam. This is a revisional court. Revisional court. I cannot. Opportunity. You. Where? Ex parte before where? Thereafter you are represented through an advocate at appellate court. Appellate court. No, madam. Whether it is served before the trial court or not. Issue notice against respondent through jurisdictional police. Case called. Reissue notice against respondent. What happened? Service is held sufficient or not? Well, then that is enough. If you are not contested the matter, that is not a ground in revision. Trial. Contested the matter, engage the counsel, being maybe is it? Or the petitioner counsel and the counsel appear. What is a counsel? Respondent.
In fact, my lord, the statement of objections what I have filed, first the contention is, my lord. First the contention is revision petition is not maintainable. In view of the law laid down by the Honorable Supreme Court, 2014, my lord. I am sorry, my lord, whether this Honorable Court has received the list of citations what I have produced.
No such list of citations here.
I see. I'm sorry.
Why it is not maintainable against the order of appeal? Concurrent finding, revision only maintainable.
No, that is what 2014 AIR Supreme Court 5709.
What is the ratio?
That is, my lord, had not be, my lord, powers of High Court.
2014.
Yes, my lord.
Page number
5709, my lord. SCW
5709 ante 5709. Volume any volume? AR antar
no, there is no volume as such.
AIR
SCW.
AR SCW Supreme Court Weekly. What is the ratio?
I'm sorry. Page para 25, my lord. This is what it can be seen from a DV Act. No further appeal or revision is provided to the High Court or any other court against the order of the Sessions Court under Section 29. This is the ratio. Because against the order of the trial court, I filed the appeal under Section 29 before the appellate court for enhancement. That order has become final. So the revision doesn't provide. That is the ratio of the Honorable Supreme Court. That is one thing, my lord. That is why, my lord, in the statement of objection, first line I have added. Revision is not maintainable. If this honorable court quotes that revision is maintainable, then I will argue further. Otherwise, my lord, as my lord.
1 second, certified copy of the order sheet. On what date you have filed statement of objections?
That is, my lord, 16/2/22, my lord.
16/2.
Yes, my lord.
Have you served the copy on the other side?
Yes, we have served. We have served.
No. Sent copies through email. Mail.
Yes, I'm sorry. Through email we have sent.
Statement of objection sent through mail. Mail ID and madam, mail ID ಏನು? ರಾಧಾ ಮಾಧವ ಯಾವ ಮೇಲ್ ಕಳಿಸಿದ್ರಿ ನೀವು? ಬರ್ದಿದ್ದಾರೆ ಅಷ್ಟೇನೆ.
ಹೌದು, ಲಿಸ್ಟ್ ಆಫ್ ಸೈಟೇಷನ್ಸ್ ನಾವು ಇವತ್ತು
ಅಲ್ಲ ಸ್ಕ್ಯಾನ್ ಕಾಪಿ ಸೆಂಟ್ ಥ್ರೂ ಮೇಲ್ ಅಂತಿದೆ ನಿಮ್ಮ ಎಂಡಾರ್ಸ್ಮೆಂಟ್. ಹೌದು, ಯಾವ ಮೇಲ್ ಕಳಿಸಿದ್ರೆ ಮೇಲ್ ಐಡಿ ಹೇಳಿ.
ಸೇಮ್ ರಾಧಾ.
ಇವನ್ ಸಿಗ್ನೇಚರ್ ಕೂಡ ಇಲ್ಲ ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ. ಯಾರು ಮಾಡಿದಾರ ಅದನ್ನು? ಮೇಲ್ ಸೆಂಟ್ ಥ್ರೂ ಮೇಲ್ ಅಂತ ಬರ್ದಿದಾರಲ್ಲ ಪ್ರೆಸೆಂಟೇಶನ್ ಫಾರ್ಮ್ ಅಲ್ಲಿ. ನೋ ಸಿಗ್ನೇಚರ್ ಆಲ್ಸೋ.
ಕರೆಕ್ಟ್.
ಯಾರಿಗೆ ಕಳಿಸಿದ್ರೆ ಹೇಳಿ, ಹೋಗ್ಲಿ ಹೇಳಿ. ಯಾವುದು ಮೇಲ್ ಐಡಿ? ಯಾವುದು?
ಇಟ್ ಈಸ್ ಮೈ ಮಿಸ್ಟೇಕ್.
ಮೇಲ್ ಐಡಿ ಯಾವ್ದು ಹೇಳಿ? ಮೇಲ್ ಐಡಿ ಯಾವ್ದು? ರಾಧಾ ಮಾಧವ್
@gmail.com.
ಸೇಮ್ ಏನೋ ಕಳ್ಸಿದಾರ ಅಂದ. ಇಲ್ಲ ಚೆಕ್ ಮಾಡಿ ಗೊತ್ತಾಗ್ತದೆ. ಈಗೆಲ್ಲ ಅಲ್ಲ. ಆನ್ ವಾಟ್ ಡೇಟ್ ಯು ಹ್ಯಾವ್ ಸೆಂಟ್?
ಯಾವಾಗ ಕಳಿಸಿದ್ರಿ? ಸೇಮ್ ಡೇಟ್ ಮೇಲೆ.
ಸೇಮ್ ಡೇಟ್ ಅಂದ್ರೆ ಯಾವಾಗ ಅಂತ ಬೇಕು? 11/2 ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ 11/2, ಬಟ್ ಇಲ್ಲಿ ಡೇಟ್ ಹಾಕಿರೋ 16/2. 16/2 ನಲ್ಲಿ ಬಂದಿದೆಯಾ ನೋಡಿ.
16/2 ಮೇಲೆ. I will not stand on technicality, my lord. I will send one more copy.
ಆಯ್ತು. ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದು ಕೊಡ್ಲಿ ನೋಡಿ, ಒಂದ್ಸರಿ ಚೆಕ್ ಮಾಡ್ಬಿಡಿ. ಸೇಮ್ ನಂಬರ್ ಅವ್ರು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ತಾ ಇದಾರೆ. ರಾಧಾ ಮಾಧವ್ 5@gmail.com. ಈಗ ಬಂದು ಇಫ್ ಯು ಆರ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ಅಂದ್ರೆ ಒನ್ ಮೋರ್ ಕಾಪಿ ಕೊಡ್ತಾರಂತ. ಆಗ್ಬೋದಾ? ನೋಡಿ, ದಿ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ 15th ಆಯ್ತು. ದ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ statement of objection sent to the council, petitioner la respondent council, to the petitioner council on 16/2/2022 to her mail ID. The council submits that not received the same. Once again directed that the respondent council to send one more copy of statement of objections to the petitioner council and list this matter on 15th.
Please.
45. Naveen Nanda DP. ಹೇಳ್ರಿ, ಏನ್ ಮ್ಯಾಟರ್ ಏನು? ವಾಟ್ ಇಸ್ ದ ಮ್ಯಾಟರ್? Have you represented before the trial court or not? Have you took the defense before the trial court? Now, what is the finding of the trial court? What is the finding of trial court with regard to the said aspect? Now, your contention is that company is not made as party. So that your defense is under section 141 of NI Act. H.V. Nirmala Chandrasekhara Reddy. You have suspension of sentence. You deposit 50% of the amount, then deducting that 20%. Third, and IA number 1 of 21. Petition of counsel on IA number 1 of 21 for suspension and sentence and bail. For the reasons mentioned in for the grounds urged in the revision petition, and also the submission of the counsel that the company is not made as party to the not made as accused, and the check is issued in the name of the company. Hence, matter requires to be reconsidered, exercise in the revisional jurisdiction. Hence, IA 1 of 21 is allowed, subject to same depositing of 50% of the amount and executing a bond for rupees. Is to check amount, fine amount, madam. Check amount 12 lakh. 12 lakh, subject to the deducting the amount already deposited ಅಂತ ಮಾಡಿದ್ದೀನಿ ನಾನು ಹೇಳಿ. Bond amount on the 2 lakh with 1 surety. Deducting the already amount deposited 50%. Issue notice against respondent. Call for records also. Records. So 46. 4 weeks. 4 weeks. Assess 4 weeks only. Henry. 138 of enact. Appellate court al deposit madidira? Naito, remaining 30% deposit madi court. For the reasons mentioned in the revision petition. Main contention and nimdu?
The witness is
incompetent. Whether competent or incompetent, court will decide. That is the only ground? Many grounds. So what is that main ground to be considered in revision?
There is an admission that the amount has been received, and there is a further admission that the amount has been repaid. And with respect to
madam, heard of the same having considered the reasons, grounds urged in the revision petition and also the main submission of the counsel appearing for the petitioner that in spite of there is an admission by the witnesses, perverse order has been passed. And considering the grounds urged, it is a case for it requires reconsideration, exercising the revisional powers. Same order, 50%. If any amount is deducted, at the same subject to check amount. What is the check amount? 1 lakh with 1 surety. 1 lakh with 1 surety. With amount amount second mat.
in this case is 11 lakh rupees.
11 lakh. 11 lakh under 2 lakh with 1 surety, madam. 50% deposit.
There is a clear intention. In the first case, there was an admission by the accused that they have received 4 lakhs and they have repaid. And they have given stated to us given that comparing the right case.
Usually ground and hand second matter.
This is how to contention to handle. And we have clearly stated that we have not received that amount. There's earlier transaction. We have produced all this case details, CC and WA details. We have produced the court stating there was one more transaction. In that transaction, we have given 10 checks.
Now, what is the ground in the revision council? Ground.
The lower court without appreciating the fact
that is concurrent finding regarding appreciation. Revisional ground. What is the revisional ground?
Because that admission in the other case has been taken as admission.
Or at the same, madam, having perused the grounds urged in the petition and also the submission that the trial court, while considering the admission given in other matter, taken the said admission while appreciating the material in this case and reasons and having heard and also perused the grounds, the revision jurisdiction are the same. 50% deposit to remaining 2 lakh with 1 surety before the trial court. 8 weeks, okay? Then other 6 weeks, madam, amount just then 6 weeks. Madland 4 weeks, so it's 6 weeks. 48. Vinay, other Arjun aita. Further hearing. Subra one company by M. Narayan Bhatt. Next. Final hearing. Lokesh M. Lokesh. Yen madam matter idu. Kodi yaru baralla 2012 andre yaru barodilla. Nave nodona. 279 304. ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಮೇಡಮ್? ಅವಾಗ್ಲೂ ಬಂದಿಲ್ವಾ? ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ಇಲ್ಲ, ಬರೋದಿಲ್ಲ. ಹಾಗನ್ನ ಏನ್ ಮೇಡಮ್ 6 months 304 ಏನಾ? Oh, this witness was also there, PW1, at the time of the accident. ಏನ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಬರ್ದಿದ್ದಾರೆ ಆರ್ಡರ್ ಮೇಡಮ್? ಅಪೀಲ್ ಅಲ್ಲಿ ಒಂದೇ ಪ್ಯಾರ, no reappreciation of evidence at all. During the course of argument, the learned counsel for the appellant failed to brought out the lacunas in the prosecution evidence adduced before the trial court. And as such, I am unable to accept the contentions of the appellant that judgment and sentence passed by trial court is not in accordance with law. This is the reasoning. Viewed from any angle, conviction and sentence passed by trial court is just and proper. Where is the appreciation, reappreciation of evidence? Is there any reasoning? Beginning itself, finding is that apart from legal lacuna, absolutely there are no grounds to disbelieve the prosecution case in this case. In paragraph number 10, nothing else discussed. What is the evidence led by the prosecution? One paragraph order. The trial court has considered all the aspects, as such there is no merit against the appeal. ನಾನು ಅದಕ್ಕೇನು 4 ಪೇಜ್ ಅಲ್ಲಿ ಬರ್ದವ್ರಲ್ಲ, ಏನದು ನೋಡೋಣ ಅಂತ ನೋಡಿದೆ. ಇವರೆಲ್ಲ ಪುಣ್ಯಾತ್ಮರು, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ಗಳು. ಹೋಗ್ಲಿ, ಏನಿದೆ ನೋಡೋಣ ಎವಿಡೆನ್ಸ್ ತಗೊಂಡು. ಎಡಬದಿಯಲ್ಲಿ ಸೈಕಲ್ ನಲ್ಲಿ ಬರ್ತಿದ್ದಾಗ ಆರೋಪಿಯು ಸತ್ಯಕಾಲದ ಕಡೆಯಿಂದ ಕೊಳ್ಳೇಗಾಲದ ಕಡೆಗೆ ಮಿನಿ ಬಸ್ ಅನ್ನು ಅತಿವೇಗ ಮತ್ತು ಇದು ತಲೆ ಮತ್ತು ಇತರೆ ಭಾಗಗಳು ಗಾಯವಾಗಿ ಸ್ಥಳದಲ್ಲೇ ಮೃತಪಟ್ಟಿದ್ದು. ಸದರಿ ಮಿನಿ ಬಸ್ ಉಳಿಕೊಂಡು ಬಸ್ಸು ಕೂಡ ಉಳ್ಕೊಂಡಿದೆ. ಸಾಧಾರಣ ಗಾಯಗಳಾಗಿ ಮತ್ತು ಸಾಕ್ಷಿರೋದು ಅವರು ಬಸ್ ಅಲ್ಲಿ ಇದ್ದವರೆಲ್ಲ ಬಂದು ಸಾಕ್ಷಿ ಹೇಳಿರೋದಾ? PW4 Oh, they are the witnesses, all passengers of the mini bus. ಸತ್ತವನು ಒಬ್ಬನೇನ? ಇವನು ಬೈಕಲ್ ಬರ್ತಿದ್ದಾನ? ಸೈಕಲ್ ಸೈಕಲ್ ಸವಾರ. Whether these witnesses have supported, why they have examined this much of witnesses? Maybe 1 or 3 or 4 hours ಸಾಕಾಗಿತ್ತು. 25 ವಿಟ್ನೆಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಲ್ಲ. 28. All are supported or not? P1 major witness, P1 and P2 major witnesses. ಅದಕ್ಕೆ ಗೊತ್ತು, ನಾನು ಅಪಘಾತದ ಬಗ್ಗೆ ದೂರನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ, ಸದರಿ ದೂರನ್ನು ಸಾಕ್ಷಿ ಅಪಘಾತವಾಗಿದ್ದು ನಿಜ. ಅಪಘಾತವಾದಾಗ ಜನರೆಲ್ಲ ಸೇರಿದಾಗ ನಾನು ಹೋಗಿದ್ದೆ ಅಷ್ಟೇ. ಇಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಾರೆ ವಿಟ್ನೆಸಸ್. PW4 ಇಂದ ಟೆಂಪೋ ಚಾಲಕ ಸೈಕಲ್ ನನಗೆ ಗುದ್ದಿಸಿದ ಆಗ ಟೆಂಪೋ ಮುಗಿಸಿಕೊಂಡು ನನಗೆ ಬಲಗೈ ಪೆಟ್ಟಾಯ್ತು. ಇವರೆಲ್ಲ ವಿಟ್ನೆಸಸ್ PW 4 to 28 ಅಲ್ಲಿ ಅವರೇನಾ? PW10 not supported. $25 is IVO. $26. RTO madam 28. ಹೇಳ್ರಿ. ಏನ್ರಿ ಗ್ರೌಂಡ್ ರಿವಿಷನ್ ಅಲ್ಲಿ? ಯಾವ್ದ್ರಲ್ಲಿ? ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಬಿಟ್ಬಿಡಿ. ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ ನಿಮ್ಗೆ? all are who are traveling in the bus comes before the court and says that dashed against the motorcycle. ಏನ್ ಡೇ ಆಫ್ಟರ್ ಏನಿಲ್ಲ. 2012 matter ಹೇಳಿ. I have read in your absence. Council grounds ಏನು ಹೇಳಿ. I understand that trial court, first appellate court has not considered the material on record. But what is the ground for Division Petitioner Council 6 time. List this matter 9. 51. BB Kaudar and H.E. Basuraju, Sohani Holla. Yes, madam.
For the revision petition here in this case, Your
Madam,
Lordship.
what is the matter?
It is the case of impersonation, Your Lordship, and forgery. The sections are 419, 420, 465, 468, 460, and 468 and 471, Your Lordship. And the punishment which has been imposed is 1 year simple imprisonment for each count and 500 rupees fine for each offense, Your Lordship. And appellate court has confirmed the same. Being agreed by that, we have filed this revision petition. So in the case of the prosecution, that the accused had obtained duplicate marks card, and he had for the year for PUC 11th, Your Lordship, first PUC, and for 3 years of BSc examinations, Your Lordship, first year, second year, and third year as well, which has been produced at Exhibit P5 to P9, Your Lordship. And he had submitted the same to KPSC to get the post of inspector in the Department of Legal Metrology, weights and measures. And he's been working, he's been selected and he's been working in the said department, Your Lordship, for more than 25 years. And
more than 25 years?
Yes. And later on, when they had a doubt regarding his departmental examination, because on 2 different dates, he said that he had passed departmental examination. And when they asked to verify the same, the COD came up, there were some 3 issues. One is regarding his date of birth. One is regarding the examination part. That, and one is regarding that he had given the address of Bidar office, where he was not posted at all, Your Lordship. And one is regarding the SSLC marks, the name change in the SSLC as well as in the BSc marks cards, Your Lordship. So when that was inquired by the COD police, they came up, PW3, he conducted the inquiry. So he came up with this, after the inquiry, he came up with the finding that this person was Ashwatha Narayanappa, son of one Veerappa Setti, and he has impersonated himself as Satyapal, son of Sridhar Rao. And he was never the student of Vijaya College. He's not the student of Vijaya College during the years of PUC and BSc. And that was the finding given by them. And based on the request of the superiors, he's filed a complaint. So complainant is PW3, who's the inquiry officer of the COD. And complaint is at Exhibit P10. It is our case that the grounds are that the identity, they have set up one person as Satya Palu, Your Lordship. He's examined at Exhibit PW1. And he says that he was earlier Satya Palu, and then later on he himself says that he has changed his name in the year 1978. 1978, he says he has changed his name to one K.S. Satya Prasad. He himself is not Satya Palu anymore, though he is deposed as Satya Palu, son of Veerappa Setti. So that itself, the identity of the original person itself, whom they claim to be Satya Palu.
Earlier you said that Satyapal, son of Sridhar Rao.
There are two Satyapals, Your Lordship. One is son of Sridhar Rao, who has graduated from this Vijaya College. That is what the college record says. One is son of Veerappa Setti.
Satya Prasad, son of Veerappa Setti.
Veerappa Setti, that is the accused, Your Lordship. So this accused was known earlier till his SSLC, 10th standard, as Ashwatha Narayanappa. In the year 1970 itself, he has changed his name to Satya Palu, Your Lordship. So since 1970 onwards,
Satya Palu or Satya Prasad?
Satya Palu, he has changed, Your Lordship. There is a confusion. That's what. Both of them have changed their names, Your Lordship. The accused as well as the original person who's known as, whom they claim to be Satya Palu, both have changed their names. So this becomes a bit doubtful. The identity of the original person who's known as Satya Palu itself becomes doubtful, because the original Satya Palu also has changed in the year 1978 his name to K.S. Satya Prasad, Your Lordship. And in that regard, he has not produced any documents, Your Lordship, regarding his name change. Neither affidavit nor any documents to show that he has changed his name from Satya Palu to K.S. Satya Prasad. This K.S. Satya Prasad is working as a SBI deputy manager or so. And he has been examined and he has produced the original marks card. They state that he has produced the original marks card, and that has been marked from Exhibit P1 to P4. Yes.
That is in the name of original name or change name?
Sorry, both are Satya Palu, because in the marks card, no father's name and all is not shown, Your Lordship. Both are Satya Palu. And then one is regarding this identity of the person is very confusing, because only person they have examined in this regard is the classmate who he says that he knows. It is not a classmate actually, who says he knows this Satya Palu. That is that PW2 is the witness who's working along with him as a worker in this SBI, Your Lordship. So that person becomes an interested witness, and he is also not very clear. He says in his examination, cross-examination, that he does not know that he has changed his name. Recently, he came to know about it, and then he has not verified the documents. And there is no one has been examined, and they have not gone to that place, Your Lordship, wherever this man has grown up, whichever schools and colleges he's gone. They have not examined any person from there. And PW3, who has conducted the inquiry from COD, and who is a complainant also, has stated in his evidence that he has not gone to any place, and he's asked his deputy to go and do all this inquiry, and the deputy also has not gone, and none of the statements which has been produced there has been produced in this case, Your Lordship. They've not gone to the village, they've not gone to the school, and then identity is not established of the original Satya Palu is one of the grounds which I'm taking. And then they've gone to the college, but the principal is not the same who was there in 1970. It is
whether you have examined before the trial court explaining that changing of name and all?
Not very clear, because in the judgment also
Defense evidence also not led.
Defense evidence has not been led, but they have produced all the documents, and then the marks card also what has been produced. It is suo moto. They say suo moto. They have made him produce the duplicate marks card, and they have marked and they have sent. It is not. KPSC clearly says that they have lost all those original documents. They keep
whether they are originals or duplicate, any authority has been examined.
FSL has been examined as far as the suo moto documents which has been produced before the inquiry officer. That has gone for FSL, and they say there is some tampering regarding the date of birth, Your Lordship. But KPSC, it cannot be said that the same duplicate were submitted to the KPSC. It is not being procured by the KPSC, Your Lordship. In case if he has done this impersonation, then the KPSC should have been those documents whichever has been submitted regarding.
What are the documents are produced while obtaining the job through the KPSC?
Yeah, it is the marks card and the whole of service record.
Whether those marks card are seized or not.
No, Your Lordship. There is only one marks card which is being seized of the final year BSc examination, which is at Exhibit P31, Your Lordship. From
P31.
From the KPSC authority, but that is not the document which is being sent to FSL, Your Lordship.
FSL not necessary, because Xerox marks card final year, that is Xerox marks card final year BSc. That is Xerox was given while getting the job by KPSC.
But the KPSC has not produced any original documents. Most of the documents they say after 5 years they have destroyed. They don't keep it after 5 years. That has come in evidence.
But what are the documents are placed before the KPSC while getting the job?
Either caste certificate or other certificates and all are there, Your Lordship.
And also the degree certificates.
Pardon, Your Lordship?
SSLC and degree.
This is the SSLC marks card. The name appears as Ashwatha Narayanappa. In the year 1970 itself.
Now the first argument is identity is not proved. The second argument?
From KPSC they have not got the documents. It's not
originals not used by KPSC.
How the ingredients of the offense itself is not proved, Anta Swami. They say to procure the job and heluvaga allindani documents bandu aa documents FSL ge hogbekittu.
Impersonation is not proved.
Not proved, Anta. Not proved. And in the judgment, trial court judgment also, it's been clearly stated that page number 17, if Your Lordship can go through. Page number 7, no, Adrali, only after last few sentences, Your Lordship, last paragraph, paragraph 8, only after ensuring that the bona fides of the accused are doubtful, then he files a complaint. So bona fide is doubtful, and it will not amount to that, it is proved beyond reasonable doubt. And page 17, the trial court comes to a conclusion. Though para 17 last sentence, Your Lordship, last but one sentence. Adrali, they state, though there are some inconsistencies which would not take the credible case of the prosecution. Anta. So where there are inconsistencies, then the benefit of doubt should naturally go to the accused. Anta. It is my argument. Reasonable doubt anta band kudle. Though in the next sentence they say it is proved beyond all reasonable doubt. So so the guilt is not proved beyond reasonable doubt anta heluvanthadu Swami.
Yes, madam. PW1. His marks card are tampered. Original marks card. He studied in Vijay card. Principal also examined. PW5. Principals. Tampered. There was a tamper. What is that exhibit P28? 28. 28 is opinion. 28 is also the signature of PW10. That is opinion. What is the document subjected for examination? Accused given himself. ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯಾವ್ದು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ಎಕ್ಸಿಬಿಟ್ SSLC ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡು, ಡಿಗ್ರಿ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್, ಯಾವ್ದದು? P5 or P5 to 8?
P5 to P9.
Duplicate marks cards.
P11 is the affidavit.
5 to 8. P1 to 4 original marks card, that is Satyapal marks card. What is the finding of the appellate court?
Confirm the sentence, Your Lordship.
Appellate court finding.
It has more relied on the evidence of PW4 and PW5, Your Lordship. One is the person who has issued the certificate, a duplicate certificate, and there he has clearly stated in his cross-examination.
Who issued the duplicate certificate?
PW5, Your Lordship. This evidence is there.
No. PW5 is the principal.
PW's.
He comes and says that this petitioner never studied in the college.
Yes, and then PW6 says that he has, I think it is Jayap. PW7, Your Lordship.
Duplicate.
Working as a junior assistant in Bangalore, and there he says that after confirming he has issued, and later on he says that he has, I do not know whether we were directed to produce the original register. Original register was not produced before the court, Your Lordship. It is true to suggest that the original register pertaining to Exhibit P8 is not produced before the court. It is true that I have issued Exhibit P8 by copying the contents of the original register. And in the cross-examination of PW3, he clearly states there is no tampering, Your Lordship. PW3's cross-examination.
In the original, no tampering.
No tampering.
Original, that is original documents.
Allah, Swami. No tampering of the
PW?
PW3.
Issued marks card of whom? But whom? He gave to whom? To accused or to the?
While making inquiry, PW3 states in his cross-examination, I did not find any tampering in the testimonials.
What is 7? You are reading appellate court order or appellate court order? Page 47. Para 36. That I read. That exhibit P8 has been changed now. Obtained in the year 1980. Further, it is clearly from the evidence of PW1 that he has already obtained a job in the bank and he is the chief manager of SBI. And there was no any necessity for him to obtain a duplicate marks card. That PW1 his friend and they both were studying at Vijay College, Bangalore. This PW2 doesn't say that accused is also his friend and the fatal accused was studying in Vijay College during that year. But the very principal comes and says that he never studied. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that this petitioner with a dishonest intention to get a government job has impersonated PW1 Satyapal alias KS Satyaprasad by forging the duplicate marks card belonging to PW1. The accused, knowing fully well that those documents are not belongs to him, used them as a genuine documents and applied for the post of inspector in the Department of Legal Metrology. The accused, by virtue of the fabricated testimonials, got appointed as an inspector in the Department of Legal Metrology through KPSC. Thus, he has cheated the government. Hence, on the complaint given by PW3, the then DYSP COD Bangalore, as per Exhibit P10, initially case was registered in Kaban Park PS under crime number 110 of 2002. It appears later investigation of the case was transferred to COD Bangalore. Hence, having conducted detailed investigation, has submitted the charge sheet. The prosecution, in order to prove the case, examined PW 1 to 10 and got marked to document Exhibit P1 to 37. The accused examined himself as DW1. There are some documents he has produced on the but list. Depends how many documents he has got marked.
3 documents, Your Lordship.
D1 to?
D3.
D1 to D?
3.
D3. Madam. Defendant document D1 to 3 only. Accused. Defense documents only D1 to 3. Oda? D1 to 3. Again, he examined himself as DW1. I thought. The trial court, after considering both oral and documentary evidence, convicted the accused for the offence punishable under section 419, 465, 468, 469, 471 of IPC, 471 and 420 of IPC. And punishment and sentence imposed is 1 year for all the offences. Howda? And sentence will run concurrently, and fine is also 500 rupees in all the cases. Being agreed by the judgment of conviction and sentence, an appeal is filed in criminal appeal number 401 of 2011. The appellate court also, on reconsideration of both oral and documentary evidence, confirmed the judgment of conviction and fine and dismissed the appeal. Hence, present revision petition is filed before this court. The counsel, who is an amicus curiae, in her arguments, she vehemently contend that first of all, the prosecution has not proved the identity of the petitioner. Apart from that, KPSC has not produced the original documents which have been relied upon while seeking for an order of appointment.
Original petitioner, original PW1, original Satyapal, Your Lordship. Identity of original Satyapal.
That is first one. Identity is not proved with regard to the original. Identity is not proved with regard to the original Satyapal. The KPS also not produced original documents. The prosecution also not proved the impersonation. And unless guilt is proved, the very conviction and sentence passed by the trial court, as well as confirming the same by the trial court, is erroneous. Appellate court is erroneous. The prosecution mainly relies upon the evidence of PW1, PW2, who is the friend of PW1, and PW3, who conducted the investigation, and also particularly relied upon the evidence of PW5, who is the principal who come before the court identifying the original PW1. And the material collected by the prosecution is not sufficient to prove the impersonation. And both the courts have committed error in convicting and confirming the judgment and sentence. There are several weaknesses in the evidence of prosecution witnesses. The counsel also brought to notice of this court the observation made by the trial court, particularly in paragraph number 17, wherein though comes to the conclusion that though there are some inconsistencies, which would not take the credible case of the prosecution. Hence, it is clear that there are inconsistencies in the evidence of prosecution. And in spite of giving benefit in favor of the petitioner herein, erroneously convicted and sentenced the accused. The counsel also brought to the notice of this court paragraph number 8, wherein an observation is made that PW3 categorically admitted, as per the direction of the government, only he has conducted preliminary inquiry regarding bona fides of the accused. The counsel also brought to notice of this court that an observation is made that only after ensuring that the bona fides of the accused are doubtful, hence he filed the complaint in terms of Exhibit P10. Only it is only a doubtful, not having any clear material, that he indulged in impersonation and made use of the tampered document for getting the job. And hence it requires interference of this court. For contra, the counsel appearing for the state would submit that PW1, who is the person Satyapal, has been examined and his original marks card are marked as exhibit P1 to 4. And he also got the job in SPI. And he was the student of Vijay College in which he obtained the degree. The council also would submit that PW5, the principal, who comes and deposes before the court that the PW1 Satyapal is the student of Vijay College and he has studied in their college. And this petitioner never studied in Vijay College. And hence the very contention of the petitioner counsel that there is no any identity of original Satyapal cannot be accepted. The council also brought to notice of this court that the evidence of PW10, who is the handwriting expert, gave the opinion in terms of exhibit P8, particularly in respect of exhibit P5 to 8, which have been tampered and made use of those documents for availing the job. The council also submits that PW6, who issued the marks card, categorically says that when he has issued the marks card and those marks cards are not tampered when subsequently the said document was tampered by erasing the entries. And hence the evidence of PW1, 5, PW10 and PW6 is very clear that this petitioner impersonated himself as Satyapal and obtained the documents, and those documents are made use of getting the job, and hence both the courts have not committed any error in convicting the accused for the offences punishment to 419, 465, 468, 469, 471 and section 420 of IPC. And there are no grounds to interfere with the findings of the trial court as well as the appellate court, and the revisional jurisdiction is very limited. Having heard the respective counsel and also the material on record, particularly both oral and documentary evidence, the point that would arise for the consideration of this court are whether the courts below have committed an error in convicting the accused for the charges leveled against him, accused oblique revision petitioner leveled against him, and appellate court also committed an error in confirming the same. And whether this court can invoke divisional jurisdiction in coming to the conclusion that the order passed by both the courts are perverse, and the conviction as well as confirmation suffers from any legality and its correctness. What order? Having heard the respective counsel and also on perusal of material, the very charges leveled against the petitioner that he has impersonated PW1 Satyapal alias KS Satyaprasad by forging the duplicate marks card belonging to PW1. It is also the charge against the petitioner that knowing fully well that those documents are not belong to him, he made use of those documents as genuine documents and applied for the post of inspector in the Department of Legal Metrology. He also got the job as inspector of the Department of Legal Metrology. And in terms of the direction given by the government, an investigation is conducted, and at the earliest point of time, DYSP, who has been examined as PW3, inquired into the matter, and initially he filed the complaint in terms of exhibit P10. Thereafter, the matter was also referred to the COD, and COD also, after conducting detailed investigation, submitted the charge sheet. The prosecution mainly relies upon the evidence of PW1 and 5 with regard to the impersonation is concerned. The PW1 who is Satyapal comes before the court and deposes that based on his certificates, he has already joined the SPI and working as chief manager. And it is also important to note that the PW5 who comes before the court, who is a principal of Vijay College, for the period in which the PW1 studied in the said Vijay College, deposes before the court that PW1 was the student of Vijay College, and he identifies that he was a student of Vijay College. But his evidence is that this petitioner never studied in the Vijay College. And it is not the case of the petitioner also. He had studied in Vijay College. But only his contention is that earlier his name is Ashwath Narayanappa, and subsequently he got it changed his name. But in order to substantiate the change of name, he has not placed any material before the court. It is also important to note that the case of the prosecution also that the documents are obtained through PW6, and PW6 also comes and deposes before the court that he has issued the marks card. But when the documents which have been marked as exhibit P 5 to 8, they were not tampered. Only subsequently they were tampered by using of erasure. It is also important to note that regarding tampering is concerned, PW10, the expert also examined, who gave the report in terms of exhibit P28, particularly in respect of disputed documents exhibit P 5 to 8. And it is his clear evidence that those documents are tampered. When such being the case of the prosecution, the very contention of the petitioner that identity is not proved cannot be accepted as contended by the amicus curiae. The PW1 was identified by the PW5, who is the original student of Vijay College, who studied as Satyapal. The other contention that original documents are not produced by the KPSC, and no doubt the original documents are not produced by KPSC. But the fact that this petitioner has applied for the post of inspector at Department of Meteorology is not in dispute. And when this petitioner is not studied in Vijay College as deposed by PW5, and it is also not his case that he was Satyapal, but his contention is that he was Ashwath Narayanappa, but he got changed the name as Satya Prasad. And to evidence the said fact, nothing is placed on the record that he has changed his name. The fact that he was worked as an inspector in the Department of Legal Metrology and different places is also not in dispute. The PW1 who conducted the preliminary investigation also clearly says that who set the law in motion by filing the complaint as per exhibit P10. In this evidence, he categorically says that he was entrusted the work of investigation in the year 2001. And by that time, this petitioner was working as inspector in the Department of Legal Metrology. The allegation against this petitioner is that he relied upon the degree marks card and SSLC marks card are different and they are not belongs to him. Not only that, the date of birth also rectified in that records of the accused, which were produced at the time of departmental examination. It is also noticed by the PW3 that accused had given the address of Bidar office at the time of departmental examination, but he never posted to that place. In this regard, also PW3 conducted a detailed preliminary investigation by visiting the schools and colleges where the accused said to have been studied. After confirming that the testimonials produced by the accused are fabricated one, he submitted the report to higher officials, and thereafter he had filed the complaint in terms of Exhibit P10. When the doubt arises with regard to the genuineness of documents only, the complaint is filed in terms of Exhibit P10. The very contention of the prosecution that even, the very contention of the petitioner counsel that even when the original documents are not produced by the KPSC, question of fabrication of document doesn't arise. The PW3 deposed before the court that yes, reposed that the very accused has handed over those documents at the time of inquiry. And when the documents are handed over by the petitioner himself during the course of investigation, those documents, the petitioner counsel cannot contend that he has not indulged in impersonation and cheating. The very evidence of PW1, PW5, and PW10, apart from that, these witnesses, PW6, who had issued the subject matter of the disputed documents, it is clear that there is a fabrication of document and made use of those documents. And the very contention of the petitioner counsel that the guilt of the accused is not proved cannot be accepted. The very report given by PW10 examining the documents and given the opinion in terms of Exhibit P28 that Exhibit P5 to 8 are tampered and made use of those documents when getting the job. And when the PW5 also identifies that this petitioner never studied in Vijaya College and only one Satyapal, that is PW1 was studied in Vijaya College and those documents are pertaining to him. And the evidence of the handwriting expert is clear that Exhibit P5 to 8 and the entries which are made are erased, retyped and rewritten, and the words in digit and years have been tampered with in the said documents. Nothing is elicited in the cross-examination of PW10 to disbelieve the opinion given by the PW10 Exhibit P28. I do not find any error committed by the trial court in convicting the accused for the offences and charges leveled against him. The appellate court also in detail on reappreciation of evidence available on record, particularly with regard to the indulging of the offences of impersonation and also tampering of documents. In paragraph number 34, and also the evidence of prosecution and petitioner evidence who has been examined as PW1 discussed in detail, and except exhibit D1 to D3, the petitioner also not relied upon any document. Only he has produced the ID card issued by Government of India in terms of exhibit D1, and the interview notice at exhibit D2, and the report submitted by SCST Welfare Committee at exhibit D3. In order to substantiate his contention that his name is shown as Ashwath Narayana, only he submits that he volunteers that it is a mistake committed by the headmaster. Name was shown, but exhibit P5 to P7, which are the testimonials, are tampered. And in order to prove the fact that he has studied in this particular college and those documents are not utilized, even he has not examined any witnesses to support the claim. On the other hand, the prosecution relied upon the evidence of PW2, who comes and deposes before the court that he studied along with PW1, and PW1 is the original Satyapal, and the same has been considered in detail by the appellate court in reappreciation of both oral and documentary evidence, particularly in paragraph number 36. Hence, I do not find any error in appreciation of both oral and documentary evidence by the appellate court also. No doubt this court can exercise the revisional jurisdiction when the judgment of the trial court as well as the appellate court is perverse and capricious and not consider the cogent evidence available on record. And I do not find any such circumstances in the case on hand. Both the courts have relied upon particularly evidence of the prosecution witnesses, that is PW1, PW5, PW6, and PW10, regarding impersonation as well as making use of the documents which have been tampered and then getting the job. And only this court can exercise the revisional jurisdiction if the orders of the trial court as well as the appellate court suffers from any legality and its correctness. And such circumstances is not warranted in the case on hand. And hence I do not find any ground to invoke section 401 of CRPC comes to the conclusion that the order passed by both the courts suffers from any legality and its correctness. The very contention that identity is not proved and original documents have not been produced by the KPSC and the impersonation is not proved cannot be accepted. The other contention that guilt has not been proved also cannot be accepted. In view of the discussions made above, I pass, and hence I answered point number 1 and 2 as negative. In view of the discussions made above, I pass the following order. Revision petition is dismissed.
Idರಲ್ಲಿ identity was he's been identified by PW5 ಅಂತ ಬಂತು judgment ಅಲ್ಲಿ.
PW5 ನೇ principal.
ಹೌದು principal.
College of Vijay College.
ಹೌದು, he was working as a principal from the year 1972 to 2006. ಅದರಲ್ಲಿ evidence ಅಲ್ಲಿ he has verified the documents and on basis of documents he states that, your lordship.
Documents that PW1 was studied.
ಹೌದು, it is not like
in the college not the accused ಅಂತ.
ಹೌದು, ಐಡೆಂಟಿಫೈ ಮಾಡೋದಿಲ್ಲ ಬಟ್ ವೆರಿಫೈ ಮಾಡಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತಾರೆ ಅವರು. ಹಾಗಾದ ಕಾರಣ
documents pertaining to the PW1 only ಅಂತ. Those documents.
ಹೌದು ಹೌದು, because he was working only from 1990 onwards. The marks card all is of the year 1970
onwards. Subsequent to the on the date of examination he was a principal ಅಂತ.
ಹೌದು ಹೌದು, 1990 to 2006 he was a principal.
But he studies earlier.
70s ಅಲ್ಲಿ ಅವರು ಬ್ಯಾಚ್ ಇಂದ ಹೊರಗೆ ಬಂದವರೆಲ್ಲ.
ಅದೇನೆ ಸತ್ಯಪಾಲನ್ ಅವ್ರು ಓದಿದ್ದಾರೆ, ಇವನ್ ಯಾರು ಅಶ್ವಥ್ ನಾರಾಯಣ್ ಅವ್ರು ಓದಿಲ್ಲ ಅಂತ. ಅವನ ಹೆಸರು ಕಂಟೆನ್ಷನ್ ಅಶ್ವಥ್ ನಾರಾಯಣ್ ವಾಸ್ ದಿ earlier his name.
ಹೌದು, ವೀರಪ್ಪ ಶೆಟ್ಟಿ.
Petitioner number ಅವನು ಅಶ್ವಥ್ ನಾರಾಯಣ ಸನ್ ಆಫ್ ವೀರಪ್ಪ ಶೆಟ್ಟಿ.
ವೀರಪ್ಪ ಶೆಟ್ಟಿ.
ಅದೇ ವೀರಪ್ಪ ಶೆಟ್ಟಿ. ಆ ಹೆಸರಿನವ್ರು ಯಾರೋ ಅವ್ರ ಕಾಲೇಜಲ್ಲಿ ಓದಿಲ್ಲ ಅಂತ ಬಂದು ಹೇಳ್ತಾರೆ. ಅಮಿಕಸ್ ಕ್ಯೂರಿ, dismissed and the office, the registry is directed to pay the.
I will file a memo regarding pro bono.
ಇದ್ರಲ್ಲೂ ಅದೇ ನಮ್ಮ ಮೇಡಮ್ ಸೇಮ್ ಪ್ರೋ ಬೋನೋನ ಮಾಡಿದ್ದಾರೆ ಸೇಮ್. ಏನ್ ಒಂದೇ ನಿಮಿಷ ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ. Council serial number 57. ಏನೇನು ಎಲ್ಲ 2013 ಗೊತ್ತಾಗದೇನು? ಕಾಗ್ನಿಸ್ ಬರುತ್ತೆ ಅಷ್ಟೇ. ಕಾಗ್ನಿಸ್ ಯಾರ ಸಚಿನ್ ಅಂತಿದೆ 57 ಅಲ್ಲಿ. ನೋಡ್ರಿ, Petitioner counsel seeks time on the ground that his name is not shown. But ನಿಮ್ದು ಒಕ್ಕಲತ್ ಹಾಕಿದೀರಾ? ಹಾಕಿಲ್ಲ ನೀವೇನು? ಮತ್ತೆ ಅವ್ರದ್ದು ಹೆಸರು ಹಾಕೋಬೇಡಿ, ಫಸ್ಟ್ ಹೆಸರು. Petitioner counsel seeks time ಅಂತ. Is this matter on 21st? 70? ಹೇಳಿ ಏನ್ 71? Petitioner counsel seeks time. Is this matter on 21st? 90? 59 ಹೇಳಿ. ಏನ್ರಿ ಎಲ್ಲ ಬಂದು ಹಳೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಟೈಮ್ ಕೇಳಿ. 59 ಹರೀಶ್ MG. Petitioner counsel seeks time. Is this matter on 21st? ಏನ್ ಡೇ ಆಫ್ಟರ್? ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದಿರಿ? ಆಯ್ತು. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ? ಮತ್ತೆ ಕ್ವಾರ್ಟರ್ಸ್ ಓಲ್ಡ್ ಮ್ಯಾಟ್ರ. ಏನಕ್ಕೆ? ವಾಟ್ ಈಸ್ ದ ಅರ್ಜೆನ್ಸಿ? ಆಯ್ತು. ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರ? ಕನ್ಕರೆಂಟ್ ಆಗ್ಲಿ. ನಿಮ್ಗೆ ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕು ಹೇಳಿ? ಅದು ಆರ್ಡರ್ಸ್ಗೆ ಏನಕ್ರಿ? ಏನಾಗ್ಬೇಕು ಆರ್ಡ್ರು? ವಿಡ್ರಾಯಲ್ ಹಾಕಿದೀರಾ? ವಿಡ್ರಾಯಲ್ ಹಾಕಿದ್ರಿ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ ಅಂತ ಈಗ ನೀವು ರೆಕಾರ್ಡ್ಸ್ ಕಳ್ಸಕ್ಕೋಸ್ಕರ ಹಾಕ್ತಾ ಇದ್ದೀರಾ? ಇಯರಿಂಗ್ ಹೆಂಗ್ ತೊಗೊಳಕಾಗುತ್ತೆ? ಯಾವ ಇಯರ್ದು? 21 ಈಗ ತಗೊಂಡು ನೀವೆಲ್ಲ ನೋಡಿದ್ರಲ್ಲ, ಒಂದು 10-11 ವರ್ಷದವ್ರದೆಲ್ಲ ಇದಾರೆ, ಅವ್ರನ್ನ ಬಿಟ್ಟು ನಿಮ್ಗೆ ತೊಗೊಳಕಾಗುತ್ತಾ? ಇಯರಿಂಗ್ ಆದ್ರೆ ಇಲ್ಲ. ನಿಮಗೆ ಏನಾರು ಬೇಕಾ? ಏನಾರು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಏನಕ್ಕೆ ಏನ್ ಟೋಕ್ಸ್ ಅಂತ ನನ್ಗೇನ್ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ. ನಿಮ್ಗೆ ಏನಾಗ್ಬೇಕು ಹೇಳ್ರಿ? ಇಯರಿಂಗ್ ಎಲ್ಲ 2021 ನಾನು ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ. ಯಾಕೆ ಅಂತಂದ್ರೆ ಮ್ಯಾಟ್ರಸ್ ಎಲ್ಲ 2011, 9, 10 ಅದೆಲ್ಲ ಇನ್ನೂ ಉಳಿದಿದೆ. 10 ವರ್ಷದ ಬಿಟ್ಬಿಟ್ಟು ಈಗ 2021 ತಗೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಆಗ್ತದೆ? ರಿವಿಷನ್ ಎಲ್ಲಾನು ರಿವಿಷನ್ 6000 ಇದೆ ರಿವಿಷನ್. ಒಂದಲ್ಲ ಎರಡಲ್ಲ 6000 ರಿವಿಷನ್ ಇದೆ. ಎಲ್ಲ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಮೇಲೆ ಎಲ್ಲದಕ್ಕೂ ಹೈಕೋರ್ಟಿಗೆ ಬರೋದೆ. ಕೇಸ್ ಇರ್ಲಿ ಇಂದ ಹೋಗ್ಲಿ ಬರೋದೆ. ನೋ ಗ್ರೌಂಡ್. ನೆಕ್ಸ್ಟ್ ಹೇಳ್ರಿ. 51 or 61? 41. ಹೇಳಿ 61 ಏನಾಗ್ಬೇಕು? Okay. Petitioner counsel 6 times list this matter on 21st. ಎಲ್ಲ 2013 ಮ್ಯಾಟರ್. ಮೇಡಮ್ ಎಲ್ಲ 13 ಬರ್ತಾ ಇದೆಯಲ್ಲ, 9, 10 ಯಾವ್ದೋ ಇತ್ತು ಅಂತ ಇದ್ರಲ್ಲಿ ಇಲ್ಲಿ ಹೋಗು. 12 ಇದೆ. 12 ಯಾಕೆ ಬರೀ 3 ಹಾಕಿದ್ದಾರೆ? 4 ಇದೆಯಲ್ಲ, ಎಲ್ಲ ಬರೀ 13 ಬರ್ತಾ ಇದೆ. 12 ಎಲ್ಲ ಇಲ್ವಾ? ಎಷ್ಟಿದೆ 12? 9, 10 ಏನಾರು ಇದೆಯಾ? ಲಿಸ್ಟ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಮೋಸ್ಟ್ಲಿ 11 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತೀವಿ. 10ರಲ್ಲಿ ಅದು 1-2 ಇದ್ದಂಗಿದೆ. 9 ಪೋಸ್ಟ್ ಆಯ್ತು. ಅದು 9 ಪೋಸ್ಟ್ ಆಯ್ತಾ? 9 ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ? 11, 10 ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ? 11 23 ಇದೆ. ಪೋಸ್ಟ್ ಆಯ್ತಾ? 12 100 ಇದೆ. ಮತ್ತೆ ಬರೀ 2 ಹಾಕೋರು ನೋಡಿ. ಇವತ್ತು 2, 3, 4 ಹಾಕಿದ್ರೆ 4, 4 ಇದೆ ಅಲ್ವಾ? ಮತ್ತೆ ಕೇಳಿ ನೋಡಿ ಯಾಕೆ ಅಂತ. 12, 13 ವರ್ಷ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀವಿ? ನಮ್ ಕೈಲಿ ಆದಷ್ಟು ಹಳೆವೆಲ್ಲ ತೊಳೆಯೋಣ. ನಾವಿರೋದೇ ತೊಳೆಯಕ್ಕೆಲ್ಲ ಹಳೆವನ್ನ. ಆಯ್ತು, ಅಕ್ಕ ಕೇಳಿ. ನಾವು RF ಹಂಗೇನಾಯ್ತು? 2003, 2004, 2005, 2006, 20 ವರ್ಷದವೆಲ್ಲ RF, RS ನಮ್ಗೆ.
Your Lordship, serial number 64, Your Lordships. Your Lordship, serial number 64. I pray for a short accommodation in serial number 64, Your Lordships.
64.
For the petitioners, Your Lord. Please, Lord.
Why one time, madam?
Your Lordship, this matter has come up suddenly after 7 years, Your Lordship.
After 7 years.
For a short accommodation.
Told madam, serial number 64. Petitioner counsel 6 times. List this matter on 21st. 21st, no suddenly.
Gratefully, Lordships.
ಎಲ್ಲ ಸಡನ್ಲಿ ಬಂದವದೆಲ್ಲ ಹಿಂಗೆ ಆಗ್ತದೆ. ಆಮೇಲೆಲ್ಲ ಡೇಟ್ ಹೋಗ್ತದೆ ಅಷ್ಟೇ. ನಮ್ ರೋಸ್ಟರ್ ಮುಗ್ದೋ ಇರುತ್ತೆ. ನಿಮ್ದೇನ ರಿಲೀಸ್ ಇದ್ರೆ ನಾನು ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ, ರಿಲೀಸ್ ಆಫ್ ಅಮೌಂಟ್ ಗೆ. ಬಟ್ 21 ಮ್ಯಾಟರ್ಸ್ ನಾನು ತಗೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡೋದಿಲ್ಲ. ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಏನಾರು ಬಂದಿದ್ರೆ ಮಾಡ್ಬೋದಿತ್ತು. ಅಡ್ಮಿಷನ್ ಆಗಿದೆಯಾ ಇಲ್ಲ? ಅದು ಆಗಿದೆಯಾ? ಮತ್ತೆ ಅಡ್ಮಿಷನ್ ಆಗಿರೋದನ್ನ ಈಗ ತಗೊಂಡ್ ಮಾಡಿದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ? ನೋ.
Hello, court officer. Hello, court officer.
Court officer? Court officer?
ಮೇಡಮ್,
ಇದು 52 ಏನಾದ್ರು ಎಕ್ಸಾಮ್ ಆಯ್ತಾ ಇಲ್ವಲ್ಲ? ಫೈನಲ್ ಹಿಯರಿಂಗ್
ಆಗಿಲ್ಲ. ಏನಾಗಿಲ್ಲ ಮೇಡಮ್.
ಆಗಿಲ್ಲ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು
ಮೇಡಮ್. 51 ಏನಾಗಿದೆ? 51 ಸೀರಿಯಲ್ ನಂಬರ್ 51. 51 ಹೌದು. 51 ಕೆ ಸರೀಶ್ ಅಂತಿದೆ ನೋಡಿ
ಸರ್. 51 ತಾನೆ?
ಹೌದು, 51 51
ಸರ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಹೌದಾ? ಯಾಕೆ ಸರ್?
ಸರ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸರ್. ಆರ್ಡರ್
ಅಂದ್ರೆ ಯಾವತ್ತು? ಇವತ್ತಾ?
ಹೌದು. 966 of 12 ಕರೆಕ್ಟಾ?
ಅದೇ ಕೆ ಸರೀಶ್ ಅಂತ ಇದೆಯಲ್ಲ. ಕೆ ಸರೀಶ್ ಲೋಕೇಶ್ ಅಂತ ಇದೆಯಲ್ಲ. ಕೆ ಸರೀಶ್ ಲೋಕೇಶ್ ಸರ್.
ಹಲೋ
ಕೇಳಿಸ್ತಿದೆ ಕೆ ಹರೀಶ್ ಲೊಕೇಶನ್ ಅದು ಮ್ಯಾಟ್ರು.
ಅಲ್ವಲ್ಲ ಸರ್, ಬಿ ಬಿ ಗೌಡ್ರು ಬಸವರಾಜ್ ಇದೆ, ಸೋನಾಯಿ ಒಳ್ಳ.
ಅಲ್ಲ 51 ಸೀರಿಯಲ್ ನಂಬರ್ 51.
51 ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೆ ಇವಾಗ ತಾನೇ. ಅಮಿಕಸ್ ಕ್ಯೂರಿ ನಾವು ಬರ್ಲಿಲ್ಲ ಅಂತ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಆಗಿತ್ತು ಅದರಲ್ಲಿ.
ಓಕೆ ಅಂದ್ರೆ ಅದೇ ಕೆ ಹರೀಶ್ ಅಲ್ಲ ಮೇಡಮ್, ಕೆ ಹರೀಶ್ ಅಲ್ಲ ಮೇಡಮ್ ಹೇಳ್ತಿರೋದು.
51 ಅಮಿಕಸ್ ಕ್ಯೂರಿ ನಾನು ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದೀನಿ, ಸಹಾನಿ ಒಳ್ಳ.
ಓಕೆ ಅದು ಏನ್ ಮೇಡಮ್
ಐ ಜಸ್ಟ್ ಆರ್ಗ್ಯೂಡ್ ಅದರಲ್ಲಿ ಡಿಟೇಲ್ ಆಗಿ ಆರ್ಡರ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ.
ಹೌದಾ? ಓಕೆ ಯಾವತ್ತು ಮೇಡಮ್, ಯಾವತ್ತು ಅಪಾಯಿಂಟ್ ಇದು ಅಮಿಕಸ್ ಕ್ಯೂರಿಯಸ್ ಯಾವತ್ತು ಅಪಾಯಿಂಟ್ ಆಗಿದೆ ಮೇಡಮ್ ಅದು?
ಲಾಸ್ಟ್ ಟೈಮ್ ಜಸ್ಟಿಸ್ ಶ್ರೀಶಾನಂದ್ರ ಇರುವಾಗಲೇ ಆಗಿದೆ ನೋಡಿ.
ಓಕೆ ಮೇಡಮ್.
ನಾವು ಬರ್ಲಿಲ್ಲ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ, ಅದಕ್ಕೆ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದೀನಿ.
ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ ಮೇಡಮ್ ಅದು?
ಹೌದು ಎತ್ತಿಡಿ.
ಓಕೆ ಮೇಡಮ್.
ಸರ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ಮಾತಾಡಿ
ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 66 ಹೆಜ್ಜೆನಾಗಿದ್ದೀನಿ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 66
ಏನೂ ಆಗಿಲ್ಲ ಸರ್, ಇನ್ನು ಇದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
to be.
ಧಾರವಾಡ ಬೆಂಚ್ ಯಾವ್ದು ಧಾರವಾಡ ಬೆಂಚ್ ಇದೆ.
Please, my lord. I'm for the petitioner, my lord.
Response.
This is my successor by petition, my lord.
ಏನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನೋಡ್ರಿ.
ಅದರಲ್ಲಿ ಏನಿಲ್ಲ, ಇದು CW 1 to 14 to 20 ಅಂತ ಮಾಡ್ಬೇಕಾಗಿತ್ತು, PW ಮಾಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ 16 to 20 ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 14 to 20 ಏನೋ ಮಾಡಿದ್ರಿ ಅಂತ.
ಅಲ್ಲ CW ಬರೆಯಲ್ ಬಿಟ್ಟು PW ಅಂತ ಬರ್ದಿನಿ ಅಷ್ಟೇ, ಮಿಸ್ಟೇಕ್ ಇದೆ.
ಹಂಗಲ್ರಿ, ಇಲ್ಲ ದಟ್ ಇಸ್ ನಾಟ್ ಕರೆಕ್ಟ್. ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ CW 16 to 20 ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 14 to CW 20 ಅಂತ. 14 to 20
PW 14 to 20 ಅಂತ ಆಗ್ಬೇಕಾಗಿತ್ತು. ಅದು
ಆಯ್ತ್ರಿ, ಅದಲ್ಲ 16ರಿಂದ 20 ಆಗ್ಬೇಕಿತ್ತು, ಬರೀ 14ರಿಂದ 20 ಹಾಕಿದಿರಿ ಅಂತ.
ಅದೇ PW ಅಷ್ಟೇ ಬರಿಬೇಕಾಗಿತ್ತು.
PW ಅಲ್ರಿ, ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡಿ. ಅದು CW 16 to 20 ಹಾಕಿದಿರಿ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ CW 14 to 20 ಅಂತ. 14 15 ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ,
that's why I had office objection.
14 to 20 ಅಂತ ಹಾಕಿದ್ವಿ.
ಏನ್ ಮೇಡಮ್ ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್? ನಾ ಹೇಳಿದ್ ಕರೆಕ್ಟಾ?
CW
instead of 14 to 20.
ಬಟ್
ಎರಡು
ಹಾಕಿಲ್ಲ, ಇನ್ನು ಇಬ್ರದ್ದು ಹಾಕಿಲ್ಲ ಅಂತ.
ಅದು 20 ಇದು 40 ಇದು CW 14 ಇದು 20 ಇದ್ರಲ್ಲೇ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ, ಅದಿಷ್ಟು ಹಾಕಿದೀನಿ.
ಸರಿ ರೀ, ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಏನು ಅಬ್ಸರ್ವೇಷನ್ ಆಫ್ಟರ್ ದಿ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ CW 14 to 20 ಇರ್ಬೇಕು ನೋಡಿ, ಹೌದಾ? ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಏನು?
Earlier order, my lord, after charge sheet, my lord, after charge sheet bail was rejected, my lord.
Rejected and observation ಏನು ಅದು ಹೇಳಿ.
Criminal petition 101894/2021, my lord. Dated 24 November 2021.
Conditions are examined ಅಂತಿದೆ.
ಇದರ ಲಾಸ್ಟ್ ಇದೆ. You have taken a note earlier reason for the rejection of the examination of evidence PW 1 to 4 and the same cannot be changed circumstances. This cannot be appreciate the evidence under section 439 of the CRP where they turn hostile support of the case and the trial court has appreciated the material available on record. In view of the discussion made, I pass the following order. Rejected, my lord. Bail petition is rejected. Now the my lord, the evidence of the CW 1 to 20, my lord, completed, my lord. All evidence, my lord, turn to hostile, my lord.
1 to 20.
1 to 20, my lord.
Copy of the evidence of CW 16 to 20 are necessary. Hence, it is this application is allowed. And the petitioner is permitted to produce. Not completed. Now the evidence of PW 14 to 20 is completed.
ಈ CW 15 ತನ ನಾನು ಬೇಲ್ ಪಿಟಿಷನ್ ಆಗಿತ್ತು, ಈಗ 20 ತನ ಆಗಿದೆ ಎವಿಡೆನ್ಸ್.
16 to 20 ಹಾಕಿದ್ದೀರಾ?
ಹೌದು, ಪ್ಲೀಸ್ ಮೇಲ.
ಆಯ್ತು ಬಿಡ, ನೋಡೋಣ. ಫಸ್ಟ್ ಟೈಮ್ ಸೆಕೆಂಡ್ ಟೈಮ್ ಮೇಡಮ್?
ಸೆಕೆಂಡ್ ಟೈಮ್ ಮೇಲ.
HCGP ಇದಾರಾ ಅದರ್ ಸೈಡ್? HCGP ಫಸ್ಟ್ ಟೈಮ್?
ಸೆಕೆಂಡ್ ಟೈಮ್.
ಯಾರದು ಜಿಪಿ ಇದಾರ? ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಅವರು ಬರ್ದು.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿದೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿದೆ, ಅವ್ರು ಬಂದಿದಾರಾ ಇಲ್ಲ? HCGP ಧಾರವಾಡ ಬೆಂಚ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಅವರಿಗೆ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿದೆ, ಗೊತ್ತಿದೆಯಾ ಅವ್ರಿಗೆ ಇಲ್ವಾ?
ಗೊತ್ತಿದೆ ಸರ್, ಗೊತ್ತಿದೆ ಮೇಲ.
ಗೊತ್ತಾಕ್ ಬರ್ಲಿಲ್ಲ ಅವರು.
Lordship, I am appearing for the state.
ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ.
My respectfully submitted, my lord.
ಹೇಳಿ ಅರ್ಲಿ ರೀಸೆಂಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಏನ್ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ವಿ? 1 to 4 on the same cannot be a change circumstance and this court cannot appreciate the evidence under section 439 whether they turned hostile or support the case of the trial court has to appreciate the material available on record. Trial court appreciate ಮಾಡಬೇಕು ಅಂತ ಮಾಡಿದ್ವಿ ನಾವು ಮತ್ತೆ
my lord, the CW 1 to 20 evidence is completed, my lord. All CW 1 to 20 has a turn to hostile, my lord.
Then you get an order before the trial court. Trial court has to appreciate the evidence.
The prosecution was not established, my lord. The present petitioner has committed a murder.
Counsel earlier observation is this court cannot appreciate the evidence under section 439 of CRPC whether they turned hostile or supported the case of the prosecution, and the trial court has to appreciate the material available on record. Now according to you, all the witnesses were examined.
Please,
let the trial court appreciate the material and pass an order on merits. That's all.
My respect submitted, my lord. When the complaint and other Pancha also turned to hostile, my lord, the prosecution is not established. The present petitioner is a.
Sorry, whether this court under sitting under section 439 can appreciate.
My lord, in the complaint, my lord, the complaint stated that, my lord.
You are not answering to my question.
Please,
if all the witnesses are examined, you take an order on merits before the trial court. Whether this court sitting under 439 appreciate the evidence of the available before the trial court.
My lord, what happened, my lord? The present petitioner is admission in the MSW, my lord. The 2 months later, my lord, the exam is there, my lord. That's why all prosecution turn hostile, my lord. At least any condition imposed by this honorable court, my lord, bail was granted.
ನಾನು ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತಂದ್ರೆ ಹಿಂದೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರಿ ನೀವು. ಯು ಗೆಟ್ ಎನ್ ಆರ್ಡರ್. ನವೆಂಬರ್ ಆಗಿರೋದು ಆರ್ಡರ್, ಮತ್ತೆ ಯಾಕೆ ಇದುವರೆಗೂ ನೀವು ಮೆರಿಟ್ಸ್ ಫೇಲ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ?
ಇಲ್ಲ ನಾವು ಎವಿಡೆನ್ಸ್ ಮೊನ್ನೆ ಆಗಿದೆ ಈ ಕ್ರಿಮಿನಲ್.
ಆಯ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೇಳಿ. 313 ಅಪಿಯರ್ ಆಗಿ ಮುಗೀತು. ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೇಳಿ. ನೀವು ಎಲ್ಲ ಹಾಸ್ಟೆಲ್ ಆಗಿದ್ರೆ matter of another 1 week.
It will be take, my lord, some more days, my lord. The present petitioner is admission to the MSW, my lord.
ಏನ್ ಮಾಡಕ್ಕಲ್ಲ. ಆಯ್ತು ನೋಡಿ, Heard the petitioner, counsel, and also the counsel appearing to the state. This court-wide order dated 24th day of November 2021, while dismissing the successive bail petition, made an observation that the examination of PW 1 to 4 cannot be a change circumstance, and further observed that this court cannot appreciate the evidence of Section 439 of CRPC, whether they turned hostile or supported the case of the prosecution, and the trial court has to appreciate the material available on record. In spite of the said order has been passed, the counsel appearing for the petitioner submits that now the witnesses to 20 have been examined and all of them have not supported the case of the prosecution. The counsel also submits that this petitioner is
MSW first year melody he was admitted. Admission was melody exam.
Custody admission
court relief ಒಂದು ವಾರ ರಿಲೀಫ್ ಕೊಟ್ಟಿತ್ತು, ಇದು ಹೋಗ ಅಪಿಯರ್ ಆಗೋದಕ್ಕೆ ಅಡ್ಮಿಷನ್ ಮಾಡಿ ಬಂದಿದ್ದಾರೆ.
ಏನಾಯ್ತು ಮೇಡಮ್?
ಒನ್ ವೀಕ್ ಬೇಲ್ ಕೊಟ್ಟಿತ್ತು ಮಿಡಲ್ ಅಡ್ಮಿಷನ್ ಟೈಮ್ ಅಲ್ಲಿ.
Got admitted to MSW to pursue his further education when the trial court has given 1 week permission for admission, and he has to pursue his education. When the counsel appearing for the petitioner would submit that already prosecution evidence is over and witnesses have not supported, and trial court has to appreciate whether they have supported or not, and this court sitting under Section 439 cannot appreciate the material available on record, taking into note of in view of submission of the petitioner counsel already evidence is over, only yet to record the 313 statement and record defense evidence, and after hearing the arguments dispose the matter. Trial court has to dispose of the matter of merits, and hence this court can only direct the trial court to dispose of the matter within 45 days from today. If the prosecution evidence is already completed, with this observation, petition is disposed of.
Within 45 days, my lord.
Within 45 days.
Please.
ಯಾವಾಗಿದೆ ಎವಿಡೆನ್ಸ್ ನಿಮ್ದೇನ ಡಿಫೆನ್ಸ್ ಇದ್ರೆ ನೀವೇ ಇಮಿಡಿಯೇಟ್ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕು. ಡಿಫೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಪ್ಲೀಸ್
ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದು ತಗೊಳ್ಳಿ ಫಸ್ಟ್. 30 BP agde
please my lord. Question is, your lordship had posed me a question, my lord, whether the matter can be compromised after this, my lord, after the conviction at a revisional stage, my lord. Is 498A. 498A.
Yes.
498A, my lord. Whether it can be compromised. So, my lord, in the present case, what has happened is judgment of conviction was passed, my lord, confirmed by the appellate court. And thereafterwards, there was a divorce proceedings also, my lord, between the parties. So it is divorce be granted, and then, my lord, some compensation also to be granted. There was one child, my lord. Child was suffering from illness, and child has also died. So the parties have decided, my lord, to compromise the case. Usual course, my lord would exercise the powers in the right of Jan Singh's case, my lord. But my lord has posed a question, my lord, whether it can be done. My first submission is, my lord, section 3. Of course, it is applicable here in this case.
482 or the revision on the prasna.
Ashta, my lord. One thing is, now since it's a matrimonial dispute, my lord, and Gyan Singh's case covers it. The only question, my lord, can it be done under 482 CRPC or by the revisional court, my lord? For that, one principle in 320 may
compromise in the sense when they have compromised the matter.
ಈಗ pending
ಈಗ ಅಂದ್ರೆ ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಅಲ್ಲಿ ಚಿಕ್ಕಮಗಳೂರು ಕೋರ್ಟ್ ಅಲ್ಲಿ.
MC ನಲ್ಲ?
MC ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿ ಅದರಲ್ಲಿ ಒಂದು ಕಂಡೀಷನ್.
MC ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆದ್ರೆ ರಿವಿಷನ್ ಅಲ್ಲಿ ಆನ್ ಕನ್ವಿಕ್ಷನ್ ನಾವೇನ್ ಮಾಡಕ? ಅದರಲ್ಲೇನು
ಹಾಕಿದ್ವಿ ಇಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ನಮ್ಮಲ್ಲಿ ತಮ್ಮ ಮುಂದೆ ನಮ್ಮ ಮುಂದೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ?
482 my lord.
482 ಅಲ್ವಲ್ಲ, ಇದು ರಿವಿಷನ್ ತಾನೆ ಇದು.
ಹೌದು, ಇದ್ರೊಳಗೆ 482
IA ಫಾರ್ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಇದೆ. ಆಮೇಲೆ IA ಇದೆ, ಯಾವ್ದು IA ಇಲ್ವಲ್ಲ?
affidavit of both the parties.
ಇಲ್ಲಿದೆ ಇಲ್ವಲ್ಲ? ಏನೋ ಇದೆಯಾ ಮೇಡಮ್? ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್.
Not come, then I will see that my lord. You lodge me kindly. I will
ಇಲ್ವಲ್ಲ?
infecting counsel is there my lord. See that it is placed ಹಾಕಿದ್ದಾರೆ, already produced.
ಯಾವಾಗ ಹಾಕಿದ್ದಾರೆ? ಇಲ್ವಲ್ಲ? IA 1 ಫಾರ್ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಹಾಕಿರೋದು ಅಷ್ಟೇ.
Affidavit is filed both the parties my lord.
ಈಗ ಕೊಡ್ತಾ ಇದಾರೆ ನೋಡಿ.
I am so sorry.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಡ್ತೀರಾ? ಕೊಡಿ ಏನಂತೆ? $482 of CRPC. 482 ನಲ್ಲಿ ಪಿಟಿಷನ್ ಹಾಕೋಬೇಕು ಅಷ್ಟೇ ನಲ್ಲಿ.
My lord, one VV is my lord, separate 482 and my lord, which will go to another court, and then that has come before my lord only, because there cannot be two proceedings my lords. One 482 division my lord. So this now that this is the matter, examining the my lord under the 397 401 CRPC my lord. The power under 482 is also applicable my lord, because 482 is an inherent power of the court. It's not a.
ನಾನು ಕೇಳ್ತಾ ಇರೋದು ಯಾವ್ದಾದ್ರು ಇದೆಯಾ ಕೇಸು ರಿವಿಷನ್ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿ ಕನ್ವಿಕ್ಷನ್ ನ ಸೆಟಿಸ್ಫೈಡ್ ಮಾಡಿರೋದು ಅಂತ ಕೇಳಿದೀನಿ ನಿಮಗೆ. ಎಲ್ಲಿದೆ ಅದು?
Using the some citations my lord, how the courts
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ನಾನು.
I may pass on the memo my lord, citations my lord. First is the recent decision, 3 judge bench decision my lord, 2021 SEC online SC 9.
The parties have settled the dispute, hence he seeks for withdrawal of the petition. ಯಾವ ಪಿಟಿಷನ್ ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ ಇವರು? RPFC ನಾ? ಆಯ್ತು. ಇದು ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಇನ್ MC ಜಾಯಿಂಟ್ ಮೆಮೋ. ಆಯ್ತು, ಹೇಳ್ಕೊಡ್ರಿ ಏನಿದೆ? ಸುಪ್ರೀಂ ಕೋರ್ಟ್
First 3 judge bench decision my lords. Wherein my lord, there actually this was accused was already convicted my lord.
Right.
And after conviction, for first para itself my lord, which led to the
offense
act my lord.
3110 of the special enactment.
Also appeal before the High Court was also dismissed my lord. The question was if there is a compromise.
SLP file ಮಾಡಿದ್ರು. ಆಯ್ತು.
This question was answered my lord, whether 482 can be excised when there is already conviction my lord. So the honorable court please was observe my lord, kindly see my lord, para 10. So far as the first question is concerned,
I am not on the dispute that 482 they can invoke.
After conviction also it can be invoked, this my submission.
ಹೌದು ಮಾಡಿದೀವಲ್ಲ ನಾವೇ several cases. Except it affects the society at large, it cannot be done ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಇಯಾನ್ ಸಿಂಗಲ್ ಮಾಡಿದ್ದಾರೆ, ಇನ್ನೊಂದು ಸ್ಟೇಟ್ ಆಫ್ ಗುಜರಾತ್ ವರ್ಸಸ್ ಅದ್ಯಾವುದು ಅದರಲ್ಲೂ ಮಾಡಿದ್ದಾರೆ. 482 ನಲ್ಲಿ ಮಾಡಬಹುದು. ನಾನ್ ಕೇಳ್ತಾ ರಿವಿಷನ್ ಅಲ್ಲಿ ಮಾಡಬಹುದು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
I beg to submit my lord, the revisional court can do it, but in exercise of the inherent jurisdiction under 482. That power is always available even to the.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಹಾಗಂತ ಎಲ್ಲಿದೆ ಅಂತ ರಿವಿಷನಲ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಡೂ ಇಟ್ ಅಂತ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. If it is a petition under section 482, no dispute. Gyan Singh case also very clear. 376 ಇದ್ದಾಗ, 307 ಇದ್ದಾಗ, 302 ಇದ್ದಾಗ, these are the offenses against the society at large.
Please.
And also the economic ಇದು ತೊಂದರೆ ಆದಾಗ, ಫೈನಾನ್ಷಿಯಲ್ ಫ್ರಾಡ್ ಇದ್ದಾಗ, if it affects the country economy, then cannot be permitted ಅಂತ statement ಅಲ್ಲಿ ಇದೆ.
No, please.
I am not on. Even
direct pointed question how to can it be done in a revisional
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ ಅವತ್ತಿಂದ ನಾನು.
I beg to read para 10 for a moment my lord, then I will take that.
Para 10 of this order.
So far as the first question, first decision it would be ad rem to outrightly refer the decision of this court in Ram Gopal so and so, and 2 pages of this court consisting of a so and so confronted with an identical question. Answering the affirmative, it has been clarified that jurisdiction of a court under 320 CRPC cannot be construed as a proscription against the invocation of evident powers vested in this court on article so and so, nor on the powers of the High Court under 482. It is further held that the touchstone of exercise the extraordinary powers under 142 or 482 would be to complete justice. Therefore, the court of the High Court, as the case may be, after having due regard to the nature of the offence and the fact that the victim complainant willingly entered into settlement compromise, can quash the proceedings in exercise of their respective constitutional inherent powers. Para 11. The court in relation to further postulated that criminal proceedings involving non-heinous offences or the offences which is predominantly of private nature could be set aside at any stage of the proceedings, including at the appellate level. The word appellate is used, my lord. Revision is not used. Appellate level. The court, however, being conscious of the fact that unscrupulous offenders, then, my lord, how it cannot be permitted if it is a nature of the offence. So the Supreme Court says the appellate stage also it can be allowed.
Now we are not an appellate jurisdiction.
Your lordship is not an appellate powers, but may submit, my lord. This is the broad outlines that have been issued by the Honorable Supreme Court, man, holding that appellate stage is permitted.
Court also says 142 as well as 482. I am not on
yes,
the point that 482 court.
I beg to take my lord to the.
I only quashed some number of orders.
Page 17.
Number of orders in 482.
Page 17.
Divisional.
Page 15. I will point out, my lord. Page 15. Here, the matter was in that case, my lord. Matter was pending before the High Court. High Court refused to grant permission, my lord, to compromise. 498A. Page 15, my lord.
ಯಾವ judgment?
Page 15.
Page 15.
Itan Sen Gupta. There.
Here also 482, 320.
Allah, so ಅದರಲ್ಲಿ High Court ಅಲ್ಲಿ refused to permit it. High Court.
ಆಯ್ತು.
In the appeal ಅಲ್ಲಿ, my lord, kindly para 5, my lords. The dismissal of the appeal was challenged by filing a revision application before the High Court. Ali revision it, Swami. Para 5. High Court concurred with the Sessions Court dismissed the revision petition. Ali revision ಒಳಗೆ compromise ಮಾಡಿದ್ರು, they permitted. Next, as per the appellant's parties to settle the matter as they have decided to keep the harmony between them, so and so could compromise the records, etc. Both the parties have undertaken so and so. Para 7. High Court should have accepted. Revision matter was compromised by for the High Court. High Court refused to, my lord, in that case.
Division ಅಂತ ಹೇಳಿದ್ದಾರೆ. The dismissal of the appeal.
Your lordship will get it. Para 2, my lord.
ಆಯ್ತು. The appeal was challenged by filing revision application before the High Court. The High Court made input order dated also concurred with the findings of the Session Court and dismissed the revision petition. Merits ಮೇಲೆ concurred with the finding of the appellate court and dismissed the revision petition. ಅಷ್ಟೇ.
My lord, ಅಲ್ಲ ಇಲ್ಲಿ para 7
merits ಮೇಲೆ dismiss ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ para 7
revision
para 7 is an indication, my lord, how it is done.
In the aforesaid going by the spirit of the law laid down by this court in BS Joshi versus so state of Haryana, we are of the opinion that the High Court should have accepted the settlement and compounded the offences. It is more so when the settlement between the parties who were husband and wife was even acted upon as the parties took mutual divorce on that basis.
Please, that's all.
Offense ಏನಿದು 498.
How High Court should have accepted BS Joshi. And
this is judgment of 2018. ಆಯ್ತು.
Anantara, page 17, my lord, of course, the coordinated bench of this one court. Page 17. That's a revision petition, my lord, 498A. Whether in the revision court, my lord, the honorable court refers to BS Joshi, para 4, my lord, and then allows the compromise, my lord. The same BS Joshi which is referred to by the honorable
revision ado.
It is a revision, my lord. It is a revision. It's a revision, my lord.
This one I do not file.
Revision is filed by the accused by bringing agreed with judgment in criminal appeal, so and so and so.
Madam, what is it? Now they have settled anta. Parties idara?
Parties idare, sir.
ಎಲ್ಲಿದ್ದಾರೆ?
Accused is present, my lord. Here.
ಇದು ಅಫಿಡವಿಟ್ ಹಾಕಿದಾರ ಸಂಧ್ಯಾ ರಾಣಿನ ಯಾರು ಹಾಕಿದಾರಲ್ಲ ಇನ್ನೊಬ್ರು
ಹಾಕಿದ್ದಾರೆ.
ಅವರೆಲ್ಲಿದ್ದಾರೆ? ಕಂಪ್ಲೇಂಟ್ ಇದಾರ?
ಸಂಧ್ಯಾ ರಾಣಿ ಹೇಳಿದಾಳೆ.
ಯಾರ ಸಂಧ್ಯಾ ರಾಣಿ ಅಂತ ಯಾರು ಇರ್ಬೇಕಲ್ಲ, ಇದ್ರಲ್ಲಿ ಯಾರು ಪಾರ್ಟಿ ಹಾಕಿದ್ರು ಕಂಪ್ಲೇಂಟ್?
ಅವ್ರ ವಕೀಲರು ಚಿಕ್ಕಮಗಳೂರಿಂದ ಆನ್ಲೈನ್ ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ದಾರೆ. ಸಂಧ್ಯಾ ರಾಣಿ ಆನ್ಲೈನ್.
ಸಂಧ್ಯಾ ರಾಣಿನ ಅವ್ರ ನೀವು ಅಫಿಡವಿಟ್ ಹಾಕಿರೋ ಸಂಧ್ಯಾ ರಾಣಿ ಇದೆಲ್ಲ
ಇಬ್ರದ್ದು ಹಾಕಿದ್ರಿ?
ಇಬ್ರದ್ದು ಹಾಕಿದ್ರಿ? ಅವ್ರಿಲ್ಲ ಇಲ್ಲ 7320 ಇವತ್ತೇ ಹಾಕಿರೋದಲ್ರಿ ಅಫಿಡವಿಟ್ ಇದು? 7320 ಅಂತಾನೆ
ಇಲ್ಲಿ ಇದ್ದಾರೆ, ಗಂಡ ಇಲ್ಲೇ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ.
ಗಂಡ ಇದ್ದಾರೆ, ಹೆಂಡತಿನೇ ಇರ್ಬೇಕಲ್ಲ. TR ಸಂಧ್ಯಾ ರಾಣಿ ಅವ್ರದ್ದು ಇವತ್ತೇ ಆಗಿದೆ. ಇವತ್ತೇನೆ ಬೆಂಗಳೂರಿನಲ್ಲಿ 7322 ಅಂದ್ರೆ ಇವತ್ತೇ
ಬಂದಿಲ್ಲ. Your lordship may kindly ask her to, she's not present right now, my lord. So therefore, ಅವಳು ಬರೋ ಲೇಟ್ ಆಗುತ್ತೆ.
ಅವತ್ತು ಕೂಡ ನಿಮ್ಮ ನೋಟ್ರಿ ಇಲ್ಲೇ ಬೆಂಗಳೂರಲ್ಲಿ ಅಫಿಡವಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಹಾಕಿದ್ರು.
ಬಂದಿದ್ರು
ಚಿಕ್ಕಮಗಳೂರು ಅಂತೀರಿ, ಚಿಕ್ಕಮಗಳೂರಲ್ಲಿ ಇದ್ರೆ ಹೆಂಗೆ?
ಹೌದು, ಅಲ್ಲಿ ಬೆಂಗಳೂರು ಇದ್ರು. ನೋ ನಾಟ್ ಪ್ರೆಸೆಂಟ್ ಮೈ ಲಾರ್ಡ್.
ಯಾರು ನೋಟ್ರಿ? ಚಂದ್ರಶೇಖರಯ್ಯ.
At the outset I beg to submit this, ಅವಳು ಕಳಿಸಿರ್ತಾಳೆ ಅಲ್ಲಿ ನೋಟ್ರಿ ಮಾಡಿ.
Affidavit is sworn by the party in Bangalore.
ಅವಳು ಅಲ್ಲಿಂದ
ಯಾರು ಚಂದ್ರಶೇಖರಯ್ಯ ನೋಟಿಸ್ ಕೊಡೋಣ. Let him bring the register. Both of them have sworn before the notary in Bangalore only. Where is he now?
We will ask her to be physically present, my lord.
ಯಾರು ಈ ಚಂದ್ರಶೇಖರಯ್ಯ ನೋಟ್ರಿ ಯಾರ್ರಿ?
ಇಲ್ಲ, that one at the very compromise matters.
Compromise matters.
Both parties, my lord, should file the affidavit and they should be present. Putting
compromise, not only compromise, while swearing affidavit also to be present before the notary. No.
And then only it is actually compromise, my lord. Since she is not present,
whether court can put a seal to the illegality?
No, can't.
Then
we will see that both are physically present. One is physically present. Your lordship may kindly accommodate next week, madam.
At least would have kept the petitioner Sandhya Rani before the court, not petitioner, the complainant.
Oh, let them come, my lord. Let them come. Only thereafter your lordship may consider it, my lord.
She is appearing through other advocate.
ಹೌದು, other advocate. He is not also.
ಯಾರು other advocate ಯಾರು? PPA ಕಡೆ against ಯಾರು ಇದ್ದಾರೆ ಇಲ್ಲಿ? SPP. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್.
ಹೌದು.
ಮತ್ತೆ ಎಲ್ಲಿ ಅವರು?
ಬರ್ತಾರೆ ಅಂತ
ನೀವೇ ಮಾಡಿಸ್ಕೊಂಡ್ರಿ ಚಂದ್ರಶೇಖರಯ್ಯನ ಹತ್ರ, ಹೌದಾ? ಅಫಿಡವಿಟ್ ನೀವೇ ಮಾಡಿಸ್ಕೊಂಡ್ ಬಂದಿತ್ತು ಚಂದ್ರಶೇಖರಯ್ಯನ ಹತ್ರ.
My lord, I will fairly say this, all this, my lord, since it is a compromise matter that has been done, my lord. Let us, because that's how the generally advocates, my lord.
Advocate, notary, party, ಎಲ್ಲರನ್ನು ಈಗ advocate who got notarized this affidavit without the party before the notary. ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ? You only got it notarized, this affidavit, without the party. Hold. Petitioner counsel seeks time to keep the complainant, de facto complainant, in VC ನೆಲ್ಲ ಕರೆಸ್ತೀರಾ?
Come physical, as your lordship pleases.
ಫಿಸಿಕಲ್ ಕರ್ಕೊಂಡ್ ನಮ್ಗೇನಿಲ್ಲ, ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು ಅವರು?
ಚಿಕ್ಕಮಗಳೂರು ಬರ್ಬೇಕು.
ಅಲ್ಲಿಂದ ಅಪೇರ್ ಆಗ್ತಾರ ಅಥವಾ ಏನು? ಇಲ್ಲ ಕರೆಸ್ತೀರಾ ನೋಡಿ.
ನಾನ್ VC ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಆನ್ VC. ಯಾವಾಗ ಡೇಟ್?
Your lordship may kindly accommodate any day after next week, my lord.
15th.
Please.
ವಾಪಸ್ ಕೊಡಿ, ಅದು ಅವತ್ತಾಗ್ಲಿ ಅಫಿಡವಿಟ್ ಎಲ್ಲ ಇದೆ.
ಅಲ್ಲಿಂದ ತಗೊಂಡು ಮಾಡಿಸ್ಲಿ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಹೇಳ್ತೀನಿ ನಾನು. Because I will also advise my lord. This what is happening is this. I understood, my lord.
ಅಲ್ಲೇ ಮಾಡಿಸ್ಕೊಂಡು ತರ್ಸ್ಕೋಬೇಕಿತ್ತು.
I will see to it.
But notary here he has signed. Notary ಎಲ್ಲ ಮಾಡಿದಾನೆ. ಅಲ್ಲ ಚಿಕ್ಕಮಗಳೂರಲ್ಲೇ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರೆ this court have no any objection. ಅಲ್ಲಿ some advocates should have been identified her.
ಅದು ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ವಕೀಲರು ಫೋನ್ ಮಾಡಿ ಕಳ್ಸಿರ್ತಾರೆ, ನಾವು ವಕೀಲರು ಮಾಡ್ತಾರೆ. ಸೊ ವೆಪನ್ಸ್ ಇನ್ ವಕಾಲತ್ ಎಲ್ಲ ಹಾಗೆ ಮಾಡ್ತೀವಿ. I will see that it done there only, madam. Please. So grateful, sir. Please.
Next ಯಾವ್ದು ಮೇಡಮ್?
Rajesh, non-committed, please.
35 ರುದ್ರಪ್ಪ. ಏನ್ರಿ ಇದು? ರುದ್ರಪ್ಪ ಸಚಿನ್ ಬೆಳಗ್ಗೆ ಏನೋ ಹೇರ್ ಮಾಡಿದ್ವಲ್ವ ಇದು? ನೀವಿರ್ಲಿಲ್ಲ, ಸಚಿನ್ ಇರ್ಲಿಲ್ಲ. ಕುಡಿ ಏನದು? ಏನಾಗಿದೆ ಆರ್ಡರ್? Order not complied. Sentence was suspended. 50% of the fine amount made by virtue so and so directed the petition deposit to since the amount was not deposited, it was brought to the notice of this court. By order dated 3/3/21, directed the petitioner to first deposit 2,10,000 as a precondition for considering this application IA 2/21. It appears that petitioner made that deposit and filed IA number 3/21 for acceptance of the same. IA 3/21 was allowed and deposit was accepted. This court passed an order declining to modify the order dated 2/21. That means the petitioner was supposed to deposit balance of 50% on order 21. According to Learned Counsel for the respondent, the petitioner has not deposited 11,086 times to ascertain whether the petitioner has made such deposit or not. ಏನ್ರಿ ಮಾಡಿಲ್ವ ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ವಾ? ಆಯ್ತು ಹೇಳಿ, ಮೆರಿಟ್ ಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ. ಆಯ್ತು ಹೇಳಿ, ಏನ್ ಮ್ಯಾಟ್ರಲ್ ಬೆಳಗ್ಗೆ ಏನು ಹೇಳಿದ್ರಿ ನೀವು? ಎಲ್ಲಿ? ಹೌದು. When the petitioner not even complied with the order of this court, why this court has exercised the discretion in favor of you? Remand ಆದ್ರೇನು? Remand also an order. ಅಲ್ರಿ, ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅವ್ರ ತಾನೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವ್ರ ಹೆಂಗ್ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡಕ್ಕಾಗ್ತದ್ರಿ? ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡ್ಬೇಕು ಆರ್ಡರ್ ಅನ್ನ, ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡ್ಲಿಕ್ಕಾಗುತ್ತೆ ಅಲ್ವಾ? ನಾನು ನೋಟಿಸ್ ಹೋಗ್ಲಿ, ಲಾಯರ್ ಏನೋ ಅಪೇರ್ ಆಗ್ಲಿಲ್ಲ, ಸರಿ ಅವತ್ತೇ 3 ಸರಿ ಕರ್ಸ್ಬಿಟ್ಟು ಯಾರೀ ಜಡ್ಜ್? ಓ ಮೆಂಡೋಂಕ ನಿಮ್ ಫ್ರೆಂಡು ಎಲ್ಲ ಇದ್ ಬೇರೆ ಈ ಮೆಂಡೋಕ ಬೇರೆ, ಇದು ಮೈಸೂರ್ದು. ಇನ್ನೊಬ್ರು ಯಾರು ನಿಮ್ ಫ್ರೆಂಡ್ ಅಲ್ಲೆಲ್ಲ ಅವ್ರಲ್ಲ, ಪುತ್ತೂರ್ಲ ಯಾರು ಯಾವ್ದೋ 2 ಆರ್ಡರ್ ಸೆಟಿಸೈಡ್ ಮಾಡಿಸ್ಕೊಂಡ್ರಲ್ಲ, ಅದೇ ತಾನೆ? ಅವ್ರೆಂತದ್ದು ರುಡಾಲ್ ಪೆರಾರ. ಇವ್ರು ಇನ್ನೊಬ್ರು. ನಾನು ಇದ್ರಲ್ಲಿ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಇವರು? ಇದ್ಯಾಕೆ ಇಷ್ಟು ದಿವಸ ಪೆಂಡಿಂಗ್ ಇತ್ತು ಇಲ್ಲಿ? ಅಪೀಲ್ ಹಾಕಿದ ಯಾವಾಗ? ನೀವ್ ಯಾಕೆ ಡಿಲೇ ಎಷ್ಟು ದಿವಸದ ಮೇಲೆ ಹಾಕಿದ್ರಿ ರಿವಿಷನ್? ರಿವಿಷನ್ ಯಾವಾಗ ಹಾಕಿದ್ ನೀವು? ಆರ್ಡರ್ ಆಗಿರೋ 2019 ಅಲ್ಲಿ. ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು ಆರ್ಡರ್ 1/2/20 ಅಲ್ಲೇನ್ರಿ? ಎಷ್ಟು ದಿವಸದ ಮೇಲೆ ಹಾಕಿದಿರಿ ನೀವು ರಿವಿಷನ್? ರಿವಿಷನ್ ಲಿಮಿಟೇಷನ್ ಇಲ್ವಾ? ಓ ಇದ್ರ ಮೇಲೆ ಮಾಡಿದ್ರ ನೀವು? ಎಲ್ಲಾ ಸಿಕ್ಕಿದ್ದು ಹಾಕೊಂಡು ಉಜ್ಜೋದು ಕೋವಿಡ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವ್ರು ಕೊಟ್ಟರು ಅನ್ನೋದು ಹಾಕೋದು ಉಜ್ಜೋದೇ ಎಲ್ಲ ಲಿಮಿಟೇಷನ್. ಆಯ್ತು, ಯಾವಾಗ ಹಾಕಿದ್ರಿ? 25/1/21 ಈ ನಾಟ್ ಕರೆಕ್ಟ್ ರೀ ಇದು ಆರ್ಡ್ರು. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡ್ಬೇಕು, ಯಾರಾಗ್ಲಿ ಕಾಸ್ಟ್ ಹಾಕೋಣ, ಅವರಿಗೆ ಹೋಗ್ದಿದ್ದಕ್ಕೆ ಅಲೋ ಮಾಡ್ಸ. ಆಯ್ತು, this matter is listed for admission today and with the consent of both the parties heard the matter. This revision petition is filed challenging the order passed by the 4th additional set aside the order passed in criminal appeal number 248 of 2019 on the file of 2nd additional district and session judge Mysore dated 1/2/2020 and set aside the judgment and conviction order in CC number 1439 of 2015 passed by the trial court, and also sought for the relief to restore the criminal appeal with a direction to consider the appeal on merits by giving opportunity for arguments of the petitioner and grant such other relief. Having heard the respective counsel and also on perusal of petition available on record, criminal appeal number 248 of 2019 ಅಲ್ಲೂ ನೀವು ದುಡ್ಡು ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ, ಮತ್ತೆ ಎಲ್ಲ ಕಡೆ ನೀವು ದುಡ್ಡು ಡೆಪಾಸಿಟ್ ಮಾಡೋದಿಲ್ಲ. ಆಯ್ತು ರೀ, ಅಲ್ಲೂ ಡೆಪಾಸಿಟ್ ಮಾಡಲ್ಲ, ಇಲ್ಲೂ ಡೆಪಾಸಿಟ್ ಮಾಡಲ್ಲ. ಮಾಡಿದೀರಾ? ಇಲ್ಲಿ ಮಾಡಿದೀರಾ? ನೀವು ತಗೊಂಡಿದ್ದೀರಾ ದುಡ್ಡು? ನೀವು ತಗೊಂಡಿದ್ದೀರಾ ದುಡ್ಡು? ನೀವು ತಗೊಂಡಿದ್ದೀರಾ ದುಡ್ಡು? ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರ? ಎಲ್ಲಿ? ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಈ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅಲ್ಲಿ ಮಾಡಿದಿರಿ ಈಗ? ಆಯ್ತು, ಹಾಗಾದ್ರೆ ಅಲ್ಲೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ. ಏನಾಯ್ತು ಮೇಡಮ್? and also the trial court granted stay of conviction and sentence, suspended the sentence subject to condition, and periodically time also extended on several occasions. Ultimately, dismissed the criminal appeal on 7/2/2020. The appellate court, while dismissing seven 1-2 noted that matter was called thrice. The appellant counsel and as well as the counsel are absent. And appellant has not proceeded with the hearing of the appeal and has not appeared before the court. There are no grounds to grant further time, and hence dismiss the appeal for non-prosecution. Hence, the present revision petition is filed. Having considered the material and record, the trial court ought to have considered the matter on merits instead of dismissed the criminal appeal for non-prosecution. And hence, order into this not sustainable in the eye of law, and hence matter request to be interpreted and set aside, and matter request and also matter request to be remanded to the appellate court to consider the matter on merits. Hence, it requires interference of this court. It is also important to note that it is borne out from the records that though order was suspended subject to condition, no amount was not deposited before the trial court, and periodically time was extended. And ultimately, on direction of this court, an amount of rupees 2,10,000 was deposited before the appellate court or trial court. Before the trial court. Having considered this is the CC of the year 2015 and appeal also of the year 2019, it was dismissed in 2020 for non-prosecution. Matters to be heard and disposed of within a period of 3 months. Time stipulation within a period of 3 months. In view of the discussions made above, I pass the following order. Revision petition is allowed. The impugned order dated so is set aside, and criminal appeal is restored, and parties are directed to appear before the trial court on appellate court on 21st of March. 21st of March. I'll make a time bound on 3 months. And the petitioner also, both the counsels are directed to assist the appellate court in disposal of the matter within 2 months. Alinda, from the date of 21, the vacation start up 3 months. Criminal gain within 3 months. Within 2 months. Antakpudi, madam. From 21/3. May 24 ಮಾಡೋದು ಅಕಸ್ಮಾತ್ ಟ್ರಾನ್ಸ್ಫರ್ ಇದ್ರಿಂದ ಯಾರು ಜಡ್ಜ್ ವಿತಿನ್ 2 months. ಅಷ್ಟೇ. ರೆಕಾರ್ಡ್ಸ್ ಏನಾದ್ರು ಬಂದಿದೆಯಾ? ಇಲ್ಲಲ್ಲ, ಇಲ್ಲ. ಅದು ಏನೋ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಒಂದೇ ದಿವಸದಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರೆ, ಕಾಸ್ಟ್ ಹಾಕೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇ ಟೈಮ್ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟು ಒಂದೇ ದಿವಸ 3 ಸರಿ ಕಾಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಮಾಡಿದ್ದಾರೆ. ಟೈಮ್ ಸ್ಟಿಪ್ಯುಲೇಷನ್ ಯಾವ ಅಪ್ಲಿಕೇಶನ್? ನೀವಲ್ಲಿ ಹಾಕೊಳ್ಳಿ. ಟೈಮ್ ಸ್ಟಿಪ್ಯುಲೇಷನ್ ಮಾಡಿದೀನಿ ಅಲ್ಲ, ಹಾಕಿ. ಮೇಡಮ್ ಯಾವ ಇದ್ರಲ್ಲ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಮೇಡಮ್.
Yes, your lordship. This is a case of theft, your lordship. Theft by servant.
Case of theft, okay. By servant.
Under section 381.
Okay.
Simple imprisonment of 6 months and a fine of ₹1,000 has been imposed. And the same has been.
What is the article? Theft article?
One fly mobile, your lordship, and an amount.
Mobile.
Yes.
Mobile.
And mobile phone of fly company, and then 2,20,000 is the cash amount which has been.
Cash also.
Cash also.
2,20,000. Whether recovery is made?
Yes, your lordship.
All entire amount is recovered?
Entire amount is recovered. So the complainant is the owner of a company by name SV Products. Theft has occurred in his office at KR Baswangudi
Wherein he was working as
as
peon,
a, yes, as a worker with him. There is a certificate which is working certificate which has been produced by the owner of the company, where he states that he was working under him as an employee. And it happened on 10/5/2008 at about 7:30 p.m. Your Lordship, between 10/5/2008, 7:30 p.m., where they had locked the premises and had gone, and to 12/5/2008, because it was found on 12/5/2008, the theft. So 2 days the premises had been locked. So it is the accountant who has found that there was a theft which is committed. And there are 3 witnesses who have been examined. 2 are police witnesses. PW3 is the IO, and PW2 is the owner of the company. And there are some 6 documents which has been marked, Your Lordship. In this case, CW4, one thing is FIR has been lodged after a day's delay, Your Lordship. They came to know about the theft on 12/5/2008. FIR has been lodged on 13/5/2008. There is no explanation for the delay, Your Lordship. And none of the spot Mahazar witnesses and the recovery.
Regarding recovery, any witnesses are examined?
No, both spot Mahazar also no witnesses have been examined, and recovery Mahazar also none of the witnesses have been examined. And the statement which is at Exhibit P4, that has been marked in its entirety, Your Lordship. Exhibit P4. Section 27 is very clear. It says only as far as it's a provision to section 25 and 26, as Your Lordship knows.
Only portion. If it is a voluntary statement regarding recovery is concerned, that portion has to be marked.
Yes, Your Lordship. But it is marked in its entirety. And 1971 Supreme Court is very clear. 1976 Supreme Court at page 483 that it must be split into its components and to separate the admissible portion. Only
that portion has to be marked.
Components or portions which were the immediate cause of the discovery would be legal evidence, not the rest which be exercised and rejected. In view of the same, Your Lordship, the whole of it has been marked, and that is vitiated, Your Lordship. That cannot be looked into in view of the fact that the whole of the Exhibit P4 has been marked, not just a portion of it. And CW4 is a important witness.
Vipula,
she has not been examined. In the complaint which is at Exhibit P4, he clearly states that on 12th May 2008 at about 7 a.m., the accountant Srimati Vipula came to the office and noticed that the money of rupees 2 lakh.
1 second. What is the legal evidence, madam, before the court? Recovery, good recovery. Sorry, recovery. Yar witness yaru? IO bit kodi. IO bit very independent witness. Yarna examine madidire. Recovery of amount. ಎಲ್ಲಿತ್ತು ದುಡ್ಡು?
ಆ ದುಡ್ಡು ಕಬರ್ಡ್ ಅಲ್ಲಿ ಇತ್ತು ಸ್ವಾಮಿ. 3 ಲಕ್ಷ ಇತ್ತು. 3 ಲಕ್ಷದಲ್ಲಿ 2,20,000.
ಅಲ್ಲ ನಾನು ಕೇಳ್ತಾ ಇರೋದು after the theft where the amount was there?
In the premises itself it was found in a jar.
In the office premises only. ಬೇರೆ ಕಡೆ ಇಟ್ಟಿದ್ದ ಅಂತ.
ಆ ಜಾಗ ತಪ್ಪಿಸ್ಬಿಟ್ಟು ಅದೇ SVS ಪ್ರಾಡಕ್ಟ್ ಇನ ಜನರೇಟರ್ ಇರುವ ಸ್ಥಳದಲ್ಲಿ ಪ್ಯಾಸೇಜ್ ನಲ್ಲಿ ಇರುವ ಖಾಲಿ ಪ್ರಮಾಣ.
ಎಷ್ಟು ವರ್ಷದಿಂದ ಇತ್ತು ಮೇಡಮ್? ಇವರ ಡ್ರಮ್ ಒಳಗೆ ಇಟ್ಟು ಏನಾರು ಮಾಡಿದ್ರಲ್ಲ ಯಾರಿಗೆ? ಆಯ್ತು ಮೇಡಮ್, ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಲೀಗಲ್ lacuna is first of all the voluntary statement cannot be marked in entirety. Only operative portion. Adunu regarding discovery is concerned, it should be marked portion of the document. That is one thing. Second thing is with regard to the recovery is concerned, no witnesses are examined except the evidence of PW2, who is the owner of the company. Alva, PW1 yaru?
Who secured the accused, Your Lordship. Is the one who was arrested him.
Yes, who secured. And recovery is also in the very same premises. ಮತ್ತೆ ಇನ್ಯಾರು ಮತ್ತೆ witnesses? ಅಪಲೇಟ್ ಕೋರ್ಟ್ನವರು ಏನ್ ಮಾಡಿದ್ರು, ಬರೀ ಸುಮ್ಮನೆ ಟೇಪ್ ಹಾಕ್ಬಿಟ್ರ? Who apprehended the accused and produced before the IO report as per exhibit. Complainant PW2 Varuna has had complaint as per exhibit B2. He strongly suspected the accused. On the same day, he has been arrested by PW1 and submitted a report at exhibit B1, has given voluntary statement as per exhibit B4. On the strength of voluntary statement, IO went to the office of the complainant wherein the accused has hidden the amount. The same has been recovered and marked at exhibit P6. So in the presence of witnesses PW2 and 3, they have reported that whereabouts not known. There is no reason to disbelieve the oral evidence of PW1 and PW2. Even the PW3 has recovered the amount of rupees. PW3 yaru? Aivo. Only PW1 to 3 matrana? Witness. Foreign punch, ವಿಚಾರಣೆ ಮಾಡ್ದಾಗಿಲ್ಲಲ್ಲ, ಮಾಡಿದಾರ? whether punch witness has supported the case, ಏನಿಲ್ಲ, ಇಲ್ಲಿ ನೋಡಿದೆನಲ್ಲ ಅದಕ್ಕೆ. ಮೂರೇ ಜನ ಮೇಡಮ್ ಅಭಿಯೋಜನೆ ಪರ ಗುರುತಿಸಲಾದ ನಿಶಾನೆಗಳು P1 to 3. Go to page number 16, trial court. Huh? 1 to 3, madam. This one is Rajay Gowda is the ASI who apprehended. Aita. Even accused, even PW2 is the owner. PW3 is the marked again the IO. Only one witness, that is the owner of the company. Huh. ಎರಡು ಕೋರ್ಟ್ನವರು ಇವರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕನ್ವಿಕ್ಟ್ ಮಾಡಿ ಅವನಿಗೆ ಮಾಡಿದ್ರು. ಅಕ್ಯೂಸ್ ಟು ಕೀಪ್ ಯಾರು ಕೊಟ್ಟಿದ್ದು? ಆಯ್ತು, ಕೊಟ್ಟಿದ್ರು. ಈಗ ಅಮೌಂಟ್ ಅವ್ನು ಎಲ್ಲಿಟ್ಟಿದ್ದ ಅನ್ನೋದು ಬೇಕಲ್ಲ, ರಿಕವರಿಗೆ ನೀವು ತಗೊಂಡೋಗಿ ಎಲ್ಲೋ ಡಬ್ದಲ್ಲಿ ಇಟ್ಟಿದ್ನೋ ಏನೋ ಡ್ರಮ್ಮಲ್ಲಿ ಇಟ್ಟಿದ್ದೆ ಅಂತ ಅದಕ್ಕೆ ರಿಕವರಿಗೆ ಯಾರಿದ್ದಾರೆ ವಿಟ್ನೆಸ್? ಇಫ್ ದಿ ಓನರ್ is having any ill will against the employee, there must be some legal evidence ಅಲ್ಲ ಮೇಡಮ್. ನೋಡಿ not the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 10/5/2008 at about 7:30 p.m. to 12/5/2008 a.m. the accused committed theft of Leybrand mobile phone set and cash of rupees 2,20,000 from the cupboard of CW1 company, that is SVS products, situated at KR Road, Sasanugudi, Bangalore. And based on the complaint, case has been registered and investigated the matter and filed the charge sheet against this prisoner for the offense prisoners 381 of IPC. The prosecution, in order to prove the charges legal against the petitioner herein laid upon the PW1 to 3 and also the documents exhibit P1 to 6. ಆಮೇಲೆ ಅಭಿಯೋಜನೆ ಪರ ಗುರುತಿಸಿದ ಮುದ್ದೆಮಾಲೆಗಳು ಇಲ್ಲ. The petitioner also not examined himself, and only on the basis of the evidence of PW1 to 3 and exhibit P1 to 6, the trial court convicted the petitioner. The offense measure from 381 and sentenced him to undergo for sentence for a period of 6 months and the fine of rupees 1,000. In default sentence another 45 days. Hence an appeal is filed before the appellate court. The appellate court also on reappreciation of material available on record confirmed the conviction and sentence. The The counsel appearing to the petitioner would vehemently contend that first of all, the voluntary statement is recorded in entirety and not marked the portion of the voluntary statement. The same is hit by, you have the judgment head, madam? Hit by, yan idea judgment nimatra. What do you have Supreme Court? Huh? Regarding police trustworthy, I am not on that. Next. Madam, ನೀವು ಒಂದು ಯಾವುದೋ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳಿದ್ರಿ ಈಗ ಎಕ್ಸಿಬಿಟ್ P4 ಇನ್ ಎಂಟೈರಿಟಿ ಮಾರ್ಕ್ ಮಾಡ್ರ ತಪ್ಪು ಅಂತ ಹೇಳಿ ಮೇಡಮ್. ಯಾವ್ದೋ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿದ್ರಿ. ವಾಯ್ಸ್ ಕೇಳ್ತಾ ಇಲ್ಲ, ಮ್ಯೂಟ್ ಆಗಿದೆ ನೋಡಿ, ಮ್ಯೂಟ್ ಆಗಿದೆ.
Sorry, my apologies. 1976 Supreme Court, AIR 1976 Supreme Court 483.
483.
Section 27 ಮೇಲೆ.
ಅದೇ ಏನಾಯ್ತು ಮೇಡಮ್? Hit by the judgment, the same is not permissible. The counsel in support of his argument also relied upon, her argument also relied upon AIR 1976 SC 483 regarding discovery of fact is concerned. There cannot be marking of entire voluntary statement. The counsel also submits that in the case on hand also there was a recovery of rupees 2,20,000, but none of the witnesses have been examined before the trial court. The only witnesses examined is PW1 is the ASI who apprehended the petitioner, and PW2 is the complainant, and PW3 is the IO who conducted the investigation, and no other independent witnesses are examined. Both the trial court as well as the appellate court erroneously given the finding that the prosecution has proved the case, and hence the order passed by the trial court as well as the confirmation order is perverse and same is suffers from legality and its correctness, and hence it requires invoking of revisional jurisdiction. According to the counsel appearing to the state, it submits that though the PW1 and 3 are the official police witnesses and their evidence cannot be brushed aside unless the evidence is given with malafide intention to implicate the petitioner. Recovery of contrabanding ಸಂಬಂಧಪಟ್ಟ ಮೇಡಮ್ ಯಾವ ಪ್ಯಾರ ರಿಲೇ ಮಾಡ್ತೀರಿ ಮೇಡಮ್ ನೀವು? No independent head not dinner. No independent witness examined to substantiate the allegation of prosecution as they have been allegedly won over by accused. But evidence of official witnesses are trustworthy and credible, and a prosecution case is trustworthy. No reason not to rest conviction on basis of such evidence of official witnesses and confirmed the conviction. And hence, in the case on hand, PW1 and PW3 evidence is trustworthy and reliable, and this court cannot exercise revision to set aside the order. Having heard the respective counsel and also on perusal of the material available on record, and also considering the oral and documentary evidence, the point that would arise for the consideration of this court are whether the courts below committed an error in appreciation of evidence and relying upon exhibit P4 is suffers from legality and it requires interference of this court exercising the revisional jurisdiction. What order? Having heard the respective counsel, no doubt the revisional jurisdiction is very limited, and only if the order suffers from legality and its correctness, court can interfere with the exercising of revisional jurisdiction. In the case on hand, admittedly, the petitioner is working with the complainant, that is PW2. The case of the prosecution also that when the amount was kept in cupboard along with mobile, and the same was stolen, and the same is recovered at the instance of the petitioner herein. It has to be noted that the revision petitioner counsel brought to notice of this court marking of document exhibit P4, and on perusal of exhibit P4 is a voluntary statement of the accused. And the entire voluntary statement is marked, and hence the same is not permissible. The counsel also brought to notice of this court the judgment of the apex court, referred supra. And the same is also very clear that in a case of discovery is concerned, only portion to be marked, not the entire voluntary statement of the petitioner. In the case on hand, it has to be noted that discovery is also that the amount was recovered at the instance of the petitioner. But in the case on hand, it has to be noted that except the complainant, no independent witnesses have been examined before the trial court. Regarding discovery or anything is unearthed from the side of the petitioner, the same has to be proved by examining independent witnesses. Here is a case of the theft of mobile as well as cash of rupees 2,20,000. But prosecution mainly relied upon the evidence of PW1 who apprehended the petitioner and PW3 who conducted the further investigation in the matter. And only independent witness, that is, only witness is PW1. No other witnesses were examined regarding recovery and proving of the recovery, also no other witnesses. No doubt the counsel appearing for the state brought to notice of this court judgment reported in 2015 within bracket 6 SEC, wherein the apex court also observed that additional witnesses cannot be discarded. But here is a case of recovery of money, that too at the instance of petitioner, and no independent witnesses are examined. And though witnesses are cited, those witnesses were not examined. And apart from that, the trial court accepted the exhibit P4 that is not legally sustainable in the eye of law. And the entire voluntary statement of the petitioner was marked and not portion of the discovery. And hence there is a force in the contention of the petitioner counsel that the evidence available before the court is not legally sustainable. When the legal evidence is not available before the court, the very conviction against the petitioner is not sustainable. And both the courts have committed an error in not considering the legal evidence, instead of consider the evidence of the PW 1 to 3. And out of that, 2 witnesses are official witnesses and 1 is the complainant. Hence, the order passed by the trial court is perverse, and the same is also affirmed by the appellate court. The appellate court also, while reconsidering the evidence of the trial court in a callous manner, reappreciated the same. In page number 15, those witnesses who have been examined and exhibit P1 to 4 also taken note of it, but regarding the legality of the document of exhibit P4 has not been discussed. Only comes to the conclusion that there is no reason to disbelieve the oral evidence of PW1 and 2. That is, witness who apprehended the accused and complainant. Even observed that even the PW3 has recovered the amount of the 2,20,000 as per voluntary statement of accused in the passage of the complainant's office, and the accused has kept the said amount. It has to be noted that amount also in the very premises in which amount was stolen and not outside the premises. When these are all the aspects has not been considered by the appellate court also, but only comes to the conclusion that there is nothing on the recovery and discard the case of the prosecution. And nothing has been elicited in the cross-examination of PW 1 to 3. Mere examination of witnesses PW 1 to 3 is not enough. The same has to be proved by examining the witnesses, first of all regarding discovery as well as recovery. Nothing has been done and no witnesses are examined, and also not considered the legal evidence, and the very document of exhibit P4 is not legally admissible when the entire document is marked, not the portion of the voluntary statement, and hence the order passed by both the trial court as well as the first appellate court suffers from its legality, correctness, and hence it requires divisional jurisdiction. So set aside the order of conviction and sentence. In view of the discussions made by Pasi Palangoda, petition is allowed to include order of conviction and also the confirmation at the Kadu case number conviction sentence and confirmation in appeals also are hereby set aside. If any amount is deposited by the petitioner, is ordered to be refunded to the petitioner on proper identification. ಇದ್ರಲ್ಲಿ ತಗೋಬಹುದು ಅನ್ಸುತ್ತೆ ದುಡ್ಡು ಮೇಡಮ್ ನೀವು.
ಇಲ್ಲ ಸರ್.
ಸ್ಟೇಟ್ ವಿಲ್ ಗಿವ್ ಏನೇ ನಾವು ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ ಇಂದ ಕೊಡ್ತೀವಿ ಮೇಡಮ್. ಅದರಿಂದ ಯಾರು ದೋಸ್ ಹೂ ಇಸ್ ನಾಟ್.
I'm also learning because I'm on the usually I practice on the civil side. This is an opportunity for me. Knowledge, your lordship.
Right, maybe nodi. In this case, I think you are succeeded. I can direct the registry to. Martin, I thought the registry is directed to pay the amicus curiae charges in favor of the amicus curiae.
Much obliged.
Bandri Raju, ಏನ್ರಿ ಇದು ಕಾಸ್ ನೋಟಿಸ್ ಸರ್ವ್ಡ್ ಆನ್ ಪಿಟಿಷನರ್ ಚಂದ್ರಶೇಖರ್ ಯಾಕೆ? ನೀವು ಬಂದಿರ್ಲಿಲ್ಲ ಅಂತ ಕಾಸ್ ನೋಟಿಸ್ ಆಗಿತ್ತ? ಆಯ್ತು ಈಗ ಹೇಳಿ. 304 1 year ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತು, ಎಷ್ಟು ಜನ ಸಾಯಿಸಿದ್ದಾರೆ ಮಗುನ? He was driving goods vehicle. ಎಲ್ಲ ಔಟ್ಸೈಡ್ ದಿ ಸಿಟಿನಾ ಅಥವೇನು? ವಿಟ್ನೆಸಸ್ ಎಲ್ಲ ಸಪೋರ್ಟ್ ಮಾಡಿದಾರಲ್ಲ. Is it a ground for setting aside? ಆಯ್ತು, ಒಂದು 6 ತಿಂಗಳಿಗೆ ಕಡಿಮೆ ಮಾಡೋಣ ಅಷ್ಟೇ. ನಮ್ದೇನಾರು ಇದನ್ನ ಒಳಗಡೆ ಇಲ್ಲ, ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸಲ್ಲಿ ಏನು ಇರಲ್ಲ. ಓನ್ಲಿ 279 309 ಎರಡಕ್ಕೂ ಕನ್ವಿಕ್ಷನ್ ಮಾಡಿದಾರಾ? ದಟ್ ಕ್ಯಾನ್ ಬಿ ಮಾಡಿಫೈಡ್ ಅಷ್ಟೇ. 279 ತೆಗೆದು 304A, ಬಟ್ ಬೇರೆ ಯಾವ ಇನ್ನೊಂದೆರಡು ಅಫೆನ್ಸ್ ಇದಾವಲ್ಲ, ನಿಲ್ಸಾ ಇಲ್ವ ಅವನು ಓಡಾಬಿಟ್ಟಿದ್ದಾನೆ. ಅದಕ್ಕೂ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆಯಾ? ಅದಕ್ಕೂ 6 months ಎಲ್ಲ ಕನ್ಕರೆಂಟ್ ಆಗೋಗ್ಬಿಡುತ್ತೆ ಬಿಡಿ. 6 months ಅಲ್ಲಿ ಕನ್ಕರೆಂಟ್ ಆಗೋಗ್ಬಿಡುತ್ತೆ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಅಂದ್ರೆ. ಏನ್ ಹೇಳಿ? ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ನಾನ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ಲಿ? ಅದೇನ್ ಮಾಡಕ್ಕ? ಏನ್ ಮಾಡದ್ರಿ? ಎವಿಡೆನ್ಸ್ ಬಂದಿದೆಯಲ್ಲ ಅವನ ಮೇಲೆ, ಎಲ್ಲ ನೋಡಿ ಹೇಳಿದಾರಲ್ಲ. ಓಡಾಡೋದಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡದ್ರಿ? ಕನ್ವಿಕ್ಷನ್ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ ಅದಕ್ಕೆ. ಕೃತ್ಯದ ಬಗ್ಗೆ ದೂರು ಸಲ್ಲಿಸಿ ಶಾಸನ ಹೆಣಕುವ ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿ ಮೃತಪಟ್ಟ ಕಾರಣ ಅವರ ಸಾಕ್ಷ್ಯವು ಲಭ್ಯ ಇರುವುದಿಲ್ಲ. ಆದರೆ ಕೃತ್ಯದ ಪ್ರತ್ಯಕ್ಷದರ್ಶಿಗಳಾದ ಪ್ರಾಸವನ್ನು ಲಕ್ಷ್ಮಮ್ಮ ಇವರು ಸ್ಪಷ್ಟವಾಗಿ ಆರೋಪಿಯ ತಪ್ಪಿನಿಂದ ಅಪಘಾತ ಆಗಿರುವ ಬಗ್ಗೆ ಸಾಕ್ಷಿ ನುಡಿದಿರುತ್ತಾರೆ. ಪ್ರತಿಯೊಬ್ಬ ಪ್ರತ್ಯಕ್ಷದರ್ಶಿಯಾದ ಕೃಷ್ಣೇಗೌಡ ಅವರು ಕೃತ್ಯದ ಬಗ್ಗೆ ಸಾಕ್ಷಿ ನುಡಿದು ತನ್ನ ಪಾಠಶಾಲೆಯಲ್ಲಿ 3 ತಿಂಗಳು ದುಬೈನಲ್ಲಿ ಇದ್ದೇನೆ ಎಂದು ಸಾಕ್ಷಿ ನುಡಿದ ಸಂಶಯಕ್ಕೆ ಕಾರಣರಾಗಿರುತ್ತಾರೆ. ಆದರೂ ಸಹ ನಿಶಾನ P1 ದೂರಿನಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರ ತನ್ನ ಮಗ ರಾಮು ಇವರನ್ನು ತಾನು, ತನ್ನ ತಾಯಿ ಹಾಗೂ ಪ್ರಾಸ 8 ಕೃಷ್ಣೇಗೌಡ ಸೇರಿಕೊಂಡು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು, ಇದರಿಂದ ಪ್ರಾಸ 8 ರವರ ಕೃತ್ಯ ಸ್ಥಳದಲ್ಲಿ ಹಾಜರಿರುವುದು ದೃಢಪಡುತ್ತದೆ. ಈ ಕಾರಣಕ್ಕಾಗಿ ಪ್ರಸಾದ್ ಅವರು ಕೃತ್ಯ ಸ್ಥಳದಲ್ಲಿ ಇದ್ದು ಕೂಡ ಗಾಬರಿಯಿಂದ ತಾನು ಅಲ್ಲಿಗೆ ರಿಮೈನಿಂಗ್ ವಿಟ್ನೆಸ್ ಓನ್ಲಿ PW1. ಲಕ್ಷ್ಮಮ್ಮ ಸ್ಕೆಚ್ ಕೊಡಿ ನೋಡೋಣ ಮೇಡಮ್, ಲೋವರ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ. ಮನೆ ಮುಂದೆನೇನಾಗಿರೋದು? ಏನ್ ಪ್ಯಾರಾಲಿಸಿಸ್ ಆ ಗ್ರೌಂಡ್ ತಗೊಂಡು ಕಡಿಮೆ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ. ಬಟ್ ಅದನ್ನು ಪ್ಯಾರಾಲಿಸಿಸ್ ಇಲ್ಲಿ ನಾವ್ ಇಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಇಟ್ಸ್ ದಟ್ ಇಸ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇವೆಂಟ್. ಹೌದಾ? ನಾವು ಬಿಟ್ಟಿದೀವಿ. ಈಗ ಅವ್ರೊಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಾರೆ, ಫೈನ್ ಹಾಕಿ ಬಿಡಕ್ ಬರಲ್ಲ ಅಂತ. 2015 ನಾನು ಧಾರವಾಡ ಗುಲ್ಬರ್ಗ ಬೆಂಚ್ ಅಲ್ಲಿ ಏನ್ ಆಕ್ಸಿಡೆಂಟ್ ಇಸ್ ಅನ್ ಆಕ್ಸಿಡೆಂಟ್, ಅವನ್ನ ಜೈಲಲ್ಲಿ ಇಟ್ಟು ಅದಕ್ಕೋಸ್ಕರ ಮತ್ತೆ ಸರ್ಕಾರ ಖರ್ಚು ಮಾಡೋದು ಅಂತ ಹೇಳಿ ಫೈನ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೆ. ಸರ್ಕಾರನೇ ಖರ್ಚು ಮಾಡ್ಬೇಕಲ್ಲ ಅವ್ನಿಗೆ ಜೈಲಲ್ಲಿ ಇಟ್ರೆ 6 ತಿಂಗಳು. ಇದು ಆಕ್ಸಿಡೆಂಟ್ ಸ್ಪಾಟ್. ಅಲ್ಲಿ ರೋಡ್ ಬಿಟ್ಟು ಅಲ್ಲಿ ಹೋದ ಮನೆ ಮುಂದೆ ರೋಡ್ ಕ್ರಾಸ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಇಲ್ಲಿ ಕ್ರಾಸಿಗೆ ರೋಡೇ ಇಲ್ಲ. ಮನೆ ಫಿರ್ಯಾದಿಯ ಮನೆ ಇನ್ ಫ್ರಂಟ್ ಆಫ್ ದಿ ಹೌಸ್ ಈ ವೆಂಟ್. ರೋಡು ಅಲ್ಲ, 8 ಅಡಿ ಟಾರ್ ರಸ್ತೆ. ಟಾರ್ ರೋಡ್ ಬಿಟ್ಟು ಒಳಗಡೆ ಹೋಗಿದ್ದಾನಲ್ರಿ. ಅಪಘಾತ ನಡೆದ ಸ್ಥಾನ ಟೈರು ಉಜ್ಜಿರುವ ನಿಶಾನೆ, ತೆಂಗಿನ ತುಂಡುಗಳು, ನೀರಿನ ತೊಟ್ಟಿ. ಮನೆ ಮುಂದೆ ಒಂದು ತೊಟ್ಟಿ ಕೂಡ ಇದೆ. ಮಣ್ಣಿನ ರಸ್ತೆ, 4 ಅಡಿ ಮಣ್ಣಿನ ರಸ್ತೆ. ಅಲ್ಲಿ ಹೋಗಿದ್ದಾನೆ, ಅದು ಎಡ್ಜಲ್ಲಿ ಇದೆ. ಮನೆ ಮುಂದೆ ಹುಡುಗ ಆಟ ಆಡ್ಕೊಂಡಲ್ಲ, ಇನ್ನೆಲ್ಲಿ ಇರ್ತಾನೆ? ನೀವೇನ ರೋಡ್ ಕ್ರಾಸ್ ಮಾಡ್ತಿದ್ದ ಅಂದ್ರೆ ಎಲ್ಲಿ ರೋಡ್ ಕ್ರಾಸ್ ಮಾಡ್ತಾವ? ಆಯ್ತ್ರಿ, ರೋಡ್ ಎಲ್ಲಿ ಕ್ರಾಸ್ ಮಾಡ್ತಾವನ್ರಿ? ನೀವ್ ಹೇಳ್ದಂಗೆ ನೀವೀಗೇನೋ ಹೇಳಿದ್ರಲ್ಲ, ರೋಡ್ ಕ್ರಾಸ್ ಮಾಡ್ತಿದ್ದ. ಆಯ್ತು, 6 months ಮಾಡ್ಕೊಳ್ಳೋ. ಏನ್ ಮೇಡಮ್ ಏನಾದ್ರು ಇದೆಯಾ ಬೇರೆ ಹೇಳೋದು? ನೀವ್ ಹೇಳೋದು. ಐ ವಿಟ್ನೆಸಸ್ ಇದಾರೆ PW 108. 6 months ರಿಡ್ಯೂಸ್ ಮಾಡೋಣ. ಏನ್ ಮಾಡದ್ರಿ? ಪ್ಯಾರಾಲಿಸಿಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ನೀವು ಎಂಟೈರ್ ಬಿಡಕ್ ಆಗಲ್ಲ. ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಕಾಂಪನ್ಸೇಷನ್ ಹೇಳಿ? ಸ್ಪೆಷಲ್ ಕೇಸ್ ಅಂತ ಏನಾದ್ರು ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. ಏನದು? ಅದಾಯ್ತು, ನನಗೆ ಗೊತ್ತು. ಐ ಆಮ್ ಹ್ಯಾವಿಂಗ್ ದಿ ನಾಲೆಡ್ಜ್ ಆಫ್ ಕೊಡ್ತಾರೆ. ಮನೇನು ಮಾಡಿದೀನಿ ನಾನು ಕಲಬುರ್ಗಿಯಲ್ಲಿ. ಆಯ್ತು, ಬಟ್ ನೌ ದೇ ಆರ್ ರಿಲೈಯಿಂಗ್ ಅಪಾನ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರಿಪೋರ್ಟೆಡ್ ಇನ್ 2015. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೇಸ್ ಅದೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಕೊಡಿ, ಇದೇ ನಾವ್ ಮಾಡಿರೋದೇನ? ಯಾವ್ದ್ರ ಏನ್ರಿ ಇದೆ? ಇಲ್ಲಿಂದ ಇದೆ, ಜಸ್ಟಿಸ್ ಜಗನ್ನಾಥನ್ ಸಾಹೇಬ್ರಿಂದಲೂ ಇದೆ. ಜಸ್ಟಿಸ್ ಜಗನ್ನಾಥನ್ ಸಾಹೇಬ್ರು, ನೋಡಿದೆ ರಮೇಶ್ ಸಾಹೇಬ್ರು, ನಂದು ಇದೆ. ಮತ್ತೆ ಯಾವ್ದು ಇಲ್ಲ, ಇವ್ರದ್ದು ಇದೆಯಲ್ಲ, ಜಗನ್ನಾಥನ್ ಸಾಹೇಬ್ರು ಮಾಡೋರೆಲ್ಲ ಮಾಡಿದಾರ್ರಿ. ಬಟ್ ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ 2015. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ ಎಲ್ಲಿ? ನಮ್ದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ, ಕೊಡಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮನೆ ತಗ್ಸಿದ್ವಲ್ರಿ ಕಾಪಿ. ಮೆಡಿಕಲ್ ಗ್ರೌಂಡ್ ನಾನು ಈಗೇನ್ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕ? ಇನ್ನೊಂದ್ 4 ವರ್ಷ ಇಟ್ಕೊಳ್ಳಿ, ಏನಾದ್ರು ಹೋದ್ರೆ ಅಪೇಟ್ ಆಗ್ಬಿಡುದು. ಏನ್ರಿ? ಮೆಡಿಕಲ್ ಗ್ರೌಂಡ್ಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಈ ರಿಪೋರ್ಟ್ಸ್ ನಾವು ನೋಡಿ ಮಾಡಕ್ಕಾಗ್ತೇನ್ರಿ? ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ಸಬ್ಜೆಕ್ಟ್ ಟು ಪ್ರೂಫ್ ಅಗೇನ್. ಏನದು? ನಾನೇ ಮಾಡಿದ್ದೇನೆ, ಇಲ್ಲೇ ಮಾಡಿದ್ದೀನಲ್ಲ ಮೊನ್ನೆ. ಯಾರು ಬೇರೆಯವರು ಯಾರು ಮಾಡ್ದಂಗೆ? ಇದು ಯಾರ್ದು? ಮೊನ್ನೆ ನಾನೇ ಒಂದು ತೆಗಿಸ್ಬಿಟ್ಟು ನಾನು ಇದು ನೋಡಿ ಅಲ್ಲ, ಅದ್ರೆಲ್ಲ ಮೇಲೆ ಇಟ್ಟಿರ್ಬೇಕು ಮೋಸ್ಟ್ಲಿ. ಇದೆ ಅಲ್ಲ allowed in part. ಸ್ಟೇಟ್ ಆಫ್ ಪಂಜಾಬ್ ಇಲ್ಲಿ ಬರ್ದೇ ಬಿಟ್ಟಿದ್ದಾರೆ, ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ. ಇದು ಕಾಂಪನ್ಸೇಷನ್ ಥಿಯರಿನೇ. ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಾನು, ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಬಿಟ್ಟು ಯಾವ್ದಾದ್ರು ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ ವಿ ಕ್ಯಾನ್ ಕನ್ಸಿಡರ್ ಅಂತ. ಫ್ರಮ್ 2015 ಇಂದ ಇಲ್ಲಿವರೆಗೂ ಯಾವ್ದಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ ಕೊಡಿ ನೋಡೋಣ, ಕನ್ಸಿಡರ್. ಇಲ್ಲ ಥರ್ಡ್ ಇನ್ ಪಾರ್ಟ್. ನಿಮ್ಗೇನೋ ನಾಲೆಡ್ಜ್ ಅಲ್ಲಿ ಇದೆ ಅಂದ್ರೆ ಯಾವ್ದಾರು ಆರ್ಡರ್ ಆಗಿದೆ ಮತ್ತೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಬಿಟ್ಟು ನೋಡಿ, ವೆರಿಫೈ ಮಾಡಿ. ಏನಾರು ಇದ್ರೆ ಕೊಡೋಣ. ಸುಮ್ಮನೆ ಯಾಕ್ರಿ ಸರ್ಕಾರಕ್ಕೆ ಬರ್ಡನ್. ದಟ್ ಈಸ್ ಮೈ ಥಿಯರಿ. ಈಗ 304 ಏನಲ್ಲ, ಈಗ 10-15 ವರ್ಷ ಆಗಿರುತ್ತೆ, ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿ 20 ವರ್ಷ ಆಗಿರುತ್ತೆ. ಇಟ್ ಈಸ್ ಅನ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ವಾ? ಇಫ್ ಯು ಕೀಪ್ ಹಿಮ್ ಇನ್ ಕಸ್ಟಡಿ ಅಗೇನ್ ಇಟ್ ಈಸ್ ಎ ಬರ್ಡನ್ ಟು ದಿ ಸ್ಟೇಟ್. ಮೇ ಬಿ ಇಟ್ ಈಸ್ ಎ ಪೀನಲ್ ಪ್ರಾವಿಷನ್, ಬಟ್ ಇಟ್ ಈಸ್ ಎ ಬರ್ಡನ್ ಟು ದಿ ಸ್ಟೇಟ್ ಎಕ್ಸ್ಚೆಕರ್ ಅಲ್ವಾ? ಏನಾರು ಇದ್ರೆ ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಹಾಕಿ, ಕಾಸ್ಟ್ ಹಾಕಿ, ಅಟ್ಲೀಸ್ಟ್ ಲೆಟ್ ಇಟ್ ಗೋ ಟು ದಿ ವಿಕ್ಟಿಮ್ಸ್ ಫ್ಯಾಮಿಲಿ. ನಾನು ಎಲ್ಲ ವಿಕ್ಟಿಮ್ಸ್ ಫ್ಯಾಮಿಲಿಗೆಲ್ಲ ಮತ್ತೆ ಮಾಡಿ 1-1.5 ಲಕ್ಷ ಹಿಂಗೆಲ್ಲ ಮಾಡಿ ಬಿಟ್ಟಿದ್ದೀನಿ ನೋಡಿ, ಏನಾರು ಇದ್ರೆ. ಇದೇನ್ ಆಕ್ಸಿಡೆಂಟ್, ಇಂಟೆನ್ಷನಲ್ ಆಗಿ ಮಾಡಿದ್ರೆ ಓಕೆ. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಯಾವತ್ತು ಹೇಳ್ತೀರಿ, ಎಷ್ಟು ದಿವಸ ಬೇಕು? ಬಟ್ ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಾನು ರಿಲೇ ಮಾಡಕ್ಕಲ್ಲ. ನೀವು ಏನಿಗೆ ಕೊಡ್ತಾ ಇದೀರಿ ಮೆಡಿಕಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಪಾರ್ಟಿ ಕರ್ಸಿ ನಾನೇನ್ ಮಾಡಿ? ನೀವ್ ಹೇಳದ್ ನಾನು ನಂಬ್ತೀನಿ, ಪ್ಯಾರಾಲಿಸಿಸ್ ಆಗಿದೆ ಅಂದ್ರೆ ನಂಬ್ತೀನಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಬಟ್ ನಾನು ಐ ಕಾಂಟ್ ಹೆಲ್ಪ್. ನೋಡಿ ಮೇಡಮ್, ಅಲ್ಲ ಇಟ್ಟಿರಿ ನಾನು. ಧನಲಕ್ಷ್ಮಿ ಇನ್ಯಾವುದು ಡೇಟ್ ಕೊಡ್ಲಿಲ್ವ? ಯಾವತ್ ಬೇಕು ಡೇಟ್? ಒಂದು ವಾರ, 15th or 16th ಹಾಕ್ಬೇಡಿ. 16th ಕಡಿಮೆ ಇದೆ. 16th 54 ಧನಲಕ್ಷ್ಮಿ ಇಲ್ವಾ? ಯಾವ ನೋಡಿ, ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗ? ಹೌದಾ? ಜನವರಿ ಫೆಬ್ರವರಿ 2 ಸರಿ ಟೈಪ್ರೈಸ್ ಟೈಮಾ? ಏನ್ ಮೇಡಮ್ ಮ್ಯಾಟ್ರ್ ಇದು? 392 ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್. Petitioner counsel is absent, and on perusal of order sheet also, in the month of January and February, matter was urgent at the instance of the petitioner counsel only. However, in the ends of justice, one more opportunity is given. If counsel doesn't appear in the next date of hearing, matter will be considered on merits in the absence of petitioner counsel. List this matter on 16th March. Dilraj. ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ. ಆಮೇಲೆ ಹಿಂದೆ ಯಾವಾಗ ಬಂದಿದೆ? ಜನವರಿ 22
ಹಿಂದೆ ಅವಾಗ ಆಬ್ಸೆಂಟ್ ಅಂತ ಇದೆ. ಹಿಂದೆ ಬಂದಿತ್ತು ನವೆಂಬರ್ 21 ಅಲ್ಲಿ.
ಅವಾಗ
ಅಂತ ರಿಕ್ವೆಸ್ಟ್
ಜಿಪಿನ ಆಮೇಲೆ 2 ಸರಿ ಇವ್ರು ಬಂದೇ ಇಲ್ಲ ನೋಡಿ. ಏನ್ ಮೇಡಮ್ ಮ್ಯಾಟರ್ ಇದು? ವಾಟ್ ಇಸ್ ದ ಮ್ಯಾಟರ್? 323 324 ಏನ್ ಮಾಡಿದಾರೆ ಪನಿಷ್ಮೆಂಟ್? ಕೊಡಿ ಬರ್ದವ್ರು ನಾವೇ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ, ನಾವೇ ಓದ್ಕೊಂಡು ಇನ್ನೇನ್ ಮಾಡೋದು? ಇಲ್ಲಾಂದ್ರೆ ಇವ್ರು ಯಾರು ಬರೋದೇ ಇಲ್ಲ. ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಡಿಫಾಲ್ಟ್. ಏನು ಅಫೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ 20,000 ಪನಿಷ್ಮೆಂಟ್ ಡಿಫಾಲ್ಟ್ ಪೇಮೆಂಟ್. Undergo simple imprisonment for 3 months for the offense punishment for 323. Undergo simple imprisonment for 1 year each for the offense punishment for 324 along with fine of rupees 20,000. Injuries ಏನು madam? Simple injuries. Previous injury. How long they were in the hospital? Hospital ಎಷ್ಟು ಇದ್ರು? Discussion and judgment ಅಲ್ಲಿ ನೋಡಿ ಗೊತ್ತಾಗುತ್ತೆ. Injured persons PW4 ಮೂರು ಜನಕ್ಕೆ ಇಂಜುರಿ ಆಗಿದೆ. Eyewitness and PW5 Pushparaj is also the doctor who issued. Good. This matter is listed for final hearing. On perusal of the order sheet, the counsel appearing for the revision petitioner is not pursuing the matter diligently. Even when the matter is listed in the month of January and also in the month of February, there was no representation. And hence, heard the counsel appearing for the state and also the perused impugned order of conviction as well as the order passed by the appellate court. The factual matters of the case of the prosecution is that on 7/4/2005 at about 11 p.m. at Panshankri 3rd Stage, Bangalore, in front of house number 428, the accused persons being the persons voluntarily picked up quarrel with CW2 Jayamma with respect to chit amount and assaulted her with their hands. When CW1 and 3 intervened to rescue CW2, accused persons also assaulted CW1 and 3 with a club and caused them bleeding injury. Hence, case has been registered and Police have investigated the matter and filed the charge sheet for the offences prescribed for 323, 324, section 34 of IPC. The prosecution, in order to prove the cases, prosecution charges leveled against the petitioners herein, examined PW 1 to 11 and also got marked document exhibit P1 to P7. Examined PW 1 to 7, not 11, 1 to 7, and got marked exhibit P1 to 6. And thereafter recorded 313 statement and not had any defense evidence. Based on the oral and documentary evidence, convicted the accused for both the offences punishment from 323 and 324, and maximum sentence of 1 year for offences from 324 is imposed, and an amount of rupees 20,000 fine each. Being agreed with the judgment of conviction and sentence, an appeal in criminal appeal number 1697 of 2008 is filed. And on reappreciation of both oral and documentary evidence, the appellate court dismissed the appeal. Hence, the present revision petition is filed before the court. In the revision petition, it is contended that order passed by both the trial court and confirmation is against the material available on record. And this petitioner at no point of time they have assaulted either the complainant or the other injured persons. ಒಂದೇ ಒಂದು ಗ್ರೌಂಡ್ ಇಲ್ಲ ಒಂದು ರಿವಿಷನ್ ಅಲ್ಲಿ ಇಷ್ಟ. No point of time assaulted. A false case has been cooked up by the complainant. ಇದಕ್ಕೊಂದು ರಿವಿಷನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಏನು ಎಂತದೂ ಇಲ್ಲ. ಇವರೇ ಕಾಪಾಡ್ಬೇಕು ಲಾಯರ್ಗಿರಿಯ. ಏನಾಯ್ತು ಮೇಡಮ್?
Material on record, it is clear that at no point of time the assaulted the complainant.
The lower courts ought to have more vigilant in appreciating the fact. And hence it requires interference of this court. For contra, the counsel appearing to the state would suspect that the PW1 and PW8 are the PW1 to 3 are the injured witnesses, and PW4 is the eyewitness, and PW5 is the doctor who examined the witnesses, supported the case of the prosecution, and nothing is elicited in the cross examination of these material witnesses. And both the courts, considering the evidence of prosecution witnesses, rightly convicted and imposed the sentence, and hence sentence is also not exorbitant. The appellate court also on reappreciation taken note of evidence available on record, in particularly in paragraph number 14, discussed the oral and documentary evidence, that is evidence of PW1 to 3 and also the doctor who has examined the witnesses PW5, injured witnesses PW5, and also the eyewitness evidence of PW4, and comes to the conclusion that nothing has been elicited and contradictions or omissions are found. And hence there are no grounds to invoke revisional jurisdiction. Having heard the HCGP as well as the grounds of the revision petition, and also looking into the material, the pointer to the rest of the consideration of this court are whether both the courts have committed an error in appreciating oral and documentary evidence, and whether order amounts to a perverse order, and whether it suffers any legality and its correctness of the order. What order? Next, having heard Having perused the material available on record and also the grounds urged in the petition as well as the submission of HCGP, the prosecution mainly relies upon the evidence at PW3, 1 to 3, who are the injured witnesses. The doctor also treated the witnesses PW1 to 3 and issued one certificate in terms of Exhibit B 3 and 4. The prosecution also relies upon the evidence of PW4, who is an eyewitness. The eyewitness also spoken with regard to the incident was taken place with regard to the kid tissue. The injuries in terms of Exhibit B 3 and 4 are simple in nature. And Dr. PW5 stated that he has examined the witnesses on the same day. That is, injured Murugesh and Pandu were examined on the same day, and nature of injuries are also simple in nature. That has been discussed by the trial court in paragraph number 10. And other witnesses are official witnesses, that is PW6 and 7, ASI and also IO. Particularly the evidence of PW1 to 5 is the material witnesses. And PW4 is an eyewitness and PW1 to 3 are the injured witnesses. And the medical evidence also corroborates the case of the prosecution, that is PW1 to 3, who have suffered the injuries. In the cross-examination of those witnesses also nothing is illustrated. When such the case, the very contention of the petitioner counsel in the revision petition that trial court has committed an error in not appreciating the oral and document the evidence in proper perspective cannot be accepted. Unless the trial court not considered the evidence available on record, the court cannot invoke the revisional jurisdiction. Having perused the order of the appellate court, also the appellate court in paragraph number 13 reappreciated the evidence of PW1 to 3, and so also the evidence of PW5 who treated the PW1 to 3, and so also considered the evidence of PW4. In paragraph number 14, reconsidered the evidence available on record. And having considered the assault made with club and with the hands, the injuries which have been mentioned in Exhibit P3 and 4 have been caused. And the doctor also says that those injuries could be caused if club is used. And hence I do not find any merit in the revision. It comes to a conclusion that both the courts have committed an error in appreciating the evidence available on record. Unless perverse order is passed, question of invoking revisional jurisdiction doesn't arise. Apart from that, there are no any. And there are apart from that, the order passed by the trial court as well as the revisional appellate court not suffers from any illegality. And while invoking the revisional jurisdiction, there must be a manifestly an illegality committed by the courts below only can exercise the revisional jurisdiction, and the such circumstances is not warranted in the case on hand to invoke revisional jurisdiction. In view of the discussion, I pass the following order. Revision petition is dismissed. R. Srinivas. Yen matter nodi? IPC offenses. Amicus Curiae the this court-wide order dated 11/2/2022, considering the offenses invoked against the petitioner under 324 and 326 of IPC made it clear that if petitioner counsel doesn't appear, matter will be proceeded with by appointing amicus curiae. Hence, the counsel see ಯಾರು ಮೇಡಮ್ ಏನ ಕಲ್ತ್ಕೊಳ್ತಿದ್ರಲ್ಲ ಯಾರು ಇನ್ಯಾರು ಇದಾರ ಯಾರು ಮಾಡ್ತಾರ ಇದಾರ ಬೇರೆ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಯಾರು ಮಾಡೋರು ಇದ್ದೀರಾ? ಎನಿ ಕೌನ್ಸಿಲ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ಅಸಿಸ್ಟಿಂಗ್ ದಿ ಕೋರ್ಟ್? ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಆಗಿ ಅಸಿಸ್ಟ್ ಮಾಡ್ತೀರಾ? ಪ್ಯಾನಲ್ ಇರ್ಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ಪ್ಯಾನಲ್ ಇರ್ಬೇಕು ಮೇಡಮ್, ಹಂಗೇನಿಲ್ಲ. ಅಮಿಕಸ್ ಕ್ಯೂರಿಗೆ ಪ್ಯಾನಲ್ ಇರ್ಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ಆಯ್ತು. ಯುವರ್ ಗುಡ್ ನೇಮ್? G.S. Balagangadhar is appointed as amicus curiae to assist the court in disposal of this revision petition. The office is directed to provide a copy of the revision petition and other materials forthwith. List this matter on 21st. 3 ವಾರ ಕೊಡ್ತೀನಿ. ನೀವು ಮಿಸ್ಟೇಕ್ ಆರ್ಡರ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್. ನಾನ್ ಮಾಡಿರೋದಲ್ಲ, ಹಿಂದಿನ ಜಡ್ಜ್ ಮಾಡಿದಾರೆ. ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತೀವಿ. ಬಟ್ ಈಗ ಬರ್ದವ್ರು ಏನ್ ಮಾಡಿದ್ರಿ? ಎಲ್ಲ 2012-13 ರಿವಿಷನ್ ಪಿಟಿಷನ್ಸ್ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? IPC ಅಫೆನ್ಸಸ್ ಇರೋದಕ್ಕೆ ಮಾತ್ರ ಮಾಡ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ. 21st.
ಮಂಜುನಾಥ್
58 K. Manjunath. ಕೋರ್ಟ್ ನೋಟಿಸ್ ಸರ್ವ್ ಟು ಪಿಟಿಷನರ್ ಮರಿಬಸಪ್ಪ. ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆದ್ರೂ ಅವರು ಏನು ಬರ್ಲಿಲ್ವಾ? ಲಾಯರ್ನ ಕರ್ಕೊ ಬರ್ಲಿಲ್ಲ. ನೋಡಿ ಮೇಡಮ್, ಅಫೆನ್ಸ್ ಏನ್ ನೋಡಿ. 323 324 ಸಾಕು. ಅದನ್ನು ನೋಡ್ಕೊಂಡು ಮಾಡೋಣ. ಕೊಡಿ. ಸೇಮ್ ಸಿಮಿಲರ್ ಈಗ ಮಾಡಿದ್ವಲ್ಲ ಅದೇ. ಲಾಯರ್ ಬರಲ್ಲ, ನೋಟಿಸ್ ಕೊಟ್ಟರು ಪಿಟಿಷನರ್ ಬರಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಡಿಸ್ಮಿಸಿಂಗ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್. 58 ಮೇಡಮ್, ಕೆ ಮಂಜುನಾಥ್ ಅಂತಿದೆ. ಕೋರ್ಟ್ ನೋಟಿಸ್ ಸರ್ವ್ ಟು ದಿ ಪಿಟಿಷನರ್ ಮರಿಬಸಪ್ಪ ಆಗ್ಲೂ ಆಗಿದೆ ಮೇಡಮ್. ನೋಡಿ ಅಫೆನ್ಸ್ ಏನು ಸೇಮ್ ಇರ್ಬೇಕು ಮೇಡಮ್. ರವಿ NM ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು 138 ಇದ್ದಂಗಿದೆ ಮೇಡಮ್. ಇದು 138. And summons in respect of the Balraj ಏನ್ ಮೇಡಮ್? ಇದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ವ್ ಆಗಿದೆಯಲ್ಲ. ಇದು ತಗೊಳ್ಳಿ. ಕೋರ್ಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟರು ಕಂಪ್ಲೇಂಟ್ ಪಿಟಿಷನರ್ ಬರಲ್ಲ. ಮೋಸ್ಟ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರ್ಬೇಕೇನ. ಇದು ಆವಾಗಿಂದ ಬಂದೇ ಇಲ್ಲ ಮತ್ತೆ 2016 ಇಂದ ಮತ್ತೆ ಬಂದಿಲ್ಲ ಮೇಡಮ್. ಇಲ್ಲ ನೋಡಿ, ದಿಸ್ ಮ್ಯಾಟರ್ ವಾಸ್ ಲಿಸ್ಟೆಡ್. ಈ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ? 13/1/2016 ಅಲ್ಲಿ ಅದು. ಆಯ್ತು ತಗೊಳ್ಳಿ. 16 ಅಲ್ಲಿ ಅಂತ ಇದೆಯಲ್ಲ. ದಿಸ್ ಮ್ಯಾಟರ್ ವಾಸ್ ಲಿಸ್ಟೆಡ್, ಲಾಸ್ಟ್ ಲಿಸ್ಟೆಡ್ in 2016 and thereafter not listed, and hence one more opportunity is given to the petitioner counsel. List this matter on 21st. Harish date hoytena 60 Balraj AC. ಹೇಳ್ರಿ. ಬೆಳಗಿಂದ ಇದ್ರು, ಈಗೇನಾಯ್ತು? ಕೋರ್ಟ್ ಸಂಜೆ 4:30 ಇರುತ್ತೆ ಅಂತ ಹೇಳ್ಬೇಕಿತ್ತು ಅವ್ರಿಗೆ. ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಏನಾಗಿದೆ ನೋಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಏನ್ರಿ 2013 ಅಲ್ಲೆಲ್ಲ ಆಫ್ಟರ್ 1 decade ಆಮೇಲೆ ಬಂದೇ ಇಲ್ವಾ? ಆಯ್ತು. ದಿ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್ ಅಂಡ್ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಶ್ರೀ N. Praveen Kumar seeks time on behalf of the petitioner counsel. List this matter on ಯಾವಾಗ? ಎಷ್ಟಿಸ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಅವರಿಗೆ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬೋದಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಮೇಡಮ್. 18th ಕೊಡೋಣ. ಆಯ್ತು 18th. 61 ಅರ್ಜೆಂಟ್. 62 ಬಸವಣ್ಣ MD ಶ್ರೀಪಾದ ಗಿರಿಧರ್ H. NOC ಯಾರೋ ಇದಾರಲ್ಲ ಇದರಲ್ಲಿ, ಗಿರಿಧರ್ H NOC ಹಾಕಿರೋದ? ಬಸವಣ್ಣ ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಅಷ್ಟು ಬಿಟ್ರೆ ಮತ್ತೆ ಬಂದಿಲ್ವಾ? This matter was listed in 2014 and thereafter not listed. Hence, an opportunity is given to both the council since both the councils are absent. List this matter on 18th. K.M. Somashekar. Yes, madam. No, madam. But junior is fit. Junior is fit. Senior is not fit, but junior is fit. Argue, madam. No, madam. Argue. In what is the matter? 279? 304A. 6 months. 1 year for 304A. Is there any eyewitnesses? 1, 8 and 11. Madam, we will reduce it to 6 months. Auto driver. There are eyewitnesses, PW 1, 8, 9 and 11, and also identified the driver of the auto rickshaw. When you have enrolled, madam? 2019. Have you read the papers or not? Have you read the papers or not? You are from the same office or different office? Same office. So then why you came to court without reading the papers? Why you came to court without reading the papers? When your senior is not keeping well, you have to grab the opportunity. Whenever your senior is not keeping well, you have to grab the opportunity. Opportunity will not come always. Tomorrow, so petitioner counsel seeks time on the ground that senior counsel is not well, but undertakes to argue herself in the next date of hearing, and hence list this matter on day after tomorrow. ಓದ್ಕೊ ಬನ್ನಿ ನೋಡೋಣ, we'll see. Day after tomorrow date ಎಷ್ಟು ಮಾಡೋಣ? 9th. Balgangadhar. Jagadish.
My lord, for CH-18, my lord.
Yes, counsel. Ready, Allah?
My lord, the copy has not been served.
What copy?
My lord, petition copy has not been served, my lord.
Already 2014 matter, copy not served ಅಂತ ಹೇಳ್ತಿರಲ್ಲ.
My lord, the notice, Swami, late ಆಗಿ notice ಆಗಿದೆ.
Special counsel, ಲೇಟರ್ ನೀವು ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೇನ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆಯಾ? ಕೊಡಿ ನೋಡಿ ಇದೆಯಾ ನೋಡಿ. Otherwise you serve one more copy to him. ಅಲ್ವಾ? ಹೇಳಿ ಏನ್ ಹೇಳಿ. ಅಲ್ಲ ಅದು ಕನ್ಸಿಡರ್ ಮಾಡೋಣ, ಬಟ್ ಅವ್ರಿಗೇನು
also we had requested, my lord.
Obtaining a job may not by giving a false asset will not cover in the code of 61 surplus enough prevention of advances.
310 ಬರಲ್ಲ, 312 ಬರುತ್ತೆ. ಅದೇ 312 ಬರುತ್ತೆ ಅಂತ. 312 ನಲ್ಲಿ ಹೇಳ್ತಾರೆ ನೋಡಿ, ಯೂಸಿಂಗ್ ಆಫ್ ದಿ ಫಾಲ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂಡ್ ಗೆಟಿಂಗ್ ಎ ಜಾಬ್. 312 ಅಲ್ಲ, ಅದ ಆಮೇಲೆ ನೋಡೋಣ. ನೀವು ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಫಸ್ಟ್. ಅದ್ರ ಸೈಡಿಗೆ ಕಾಪಿ ಇಲ್ದಲೆ ನಾವು ನಿಮ್ಮನ್ನ ಹಿಯರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ತೋಳಿ respondent special counsel submits that copy of the revision petition is not served, and hence the counsel appearing for the petitioner is directed to serve one more copy to the petitioner, to the respondent counsel, and this matter 21st.
Please, ma'am.
March, really 21st. 20 ಆಯ್ತು, 28. ನಾನ್ ನಂಬರ್ ಅವ್ರಾಗ್ಲೇ ಡಿಸಪಿಯರ್ ಆಗೈತೆ. ಇದಾರೆ ನಂಬರ್ ಕೊಡ್ಬೇಕಂತ ನೋಡ್ರಿ, ಅವ್ರಿಗೆ ಕೊಡ್ರಿ, ಆಮೇಲೆ ಫೋನ್ ಮಾಡಿ. ನಂಬರ್ ಇದೆಯಾ ನಿಮ್ದು?
ಅವ್ರದ್ದು ನಂಬರ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
ನೀವು ಕೊಡಿ ಅವ್ರ ನಂಬರ್, ಅವ್ರು ನಿಮಗೆ ಕೊಡ್ಲಿ, ಏನಾರು ಒಂದ್ ಮಾಡಿ. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ 66 ಆಯ್ತು. ಮಲಿ ಪಾಟೀಲ್ PS, ಸಂತೇಶ್ ಹೌಜಿ. ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಕೆಪ್ಟ್ ಬಿಲೋ, ಏನಾಯ್ತ್ರಿ? ಆಗ್ಲಿಲ್ಲ, ಆಯ್ತು ಪರವಾಗಿಲ್ಲ. ಮೆರಿಟ್ ಮೇಲೆ ಹೇಳಿ ಏನ್ ಮ್ಯಾಟರ್ ಏನು? ವಾಟ್ ಇಸ್ ದಿ ಮ್ಯಾಟರ್? 138. ಆಯ್ತು ಹೇಳಿ. ಬ್ರದರ್ಸ್ are fighting from 2011. Elder brother.
Not to execute the sale deeds in respect of the loss which was on the land which was allotted in the partition. This is not agreed, it is not disputed. This is not the, after calculating the amount not received in the sale deed, but it has not reached, not up to 25 lakhs. Because of that, since I have not, the appellate court has reversed the order conviction.
ನಾವು ಈಗ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಅಲ್ಲಿ ರಿವಿಷನ್ ಹಾಕಿದ್ದೀರಾ? ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಾಯ್ತು? ಕನ್ವಿಕ್ಷನ್ ಸೆಟ್ ಅಸೈಡ್ ಆಯ್ತು. ಅದೇ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಾಗ ರಿವಿಷನ್ ಬರಲ್ಲ, ಸ್ಕೋಪ್ ವಿಲ್ ಬಿ ಎಕ್ಸ್ಪ್ಯಾಂಡೆಡ್ ಅಲ್ಲ, ಮತ್ತೆ ರಿಅಪ್ರಿಸಿಯೇಷನ್ ಆಗ್ಬೇಕಲ್ಲ, ಅಪೀಲೇ ಬರುತ್ತಲ್ಲ. ಎಗೇನ್ಸ್ಟ್ ದಿ ಅಕ್ವಿಟಲ್ ಈಗ ಎಗೇನ್ಸ್ಟ್ ದಿ ಅಪೀಲ್ ಅಕ್ವಿಟಲ್ ಅಲ್ವಾ? ಮತ್ತೆ ನೋಡಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ, ಯಾಕೆ ನಾನೇ ಬರ್ತಿದ್ದೀನಿ ಜಡ್ಜ್ಮೆಂಟ್. ಅಪೀಲ್ ಲೈಸ್ ನಾಟ್ ದಿ ರಿವಿಷನ್. ರಿವಿಷನ್ ಏನಾಗುತ್ತೆ, ಸ್ಕೋಪ್ ಲಿಮಿಟ್ ಆಗ್ಬಿಡ್ತದೆ. ಈಗ ನಾವು ದೇರ್ ಆರ್ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ಸ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕನ್ವಿಕ್ಟೆಡ್, ಇನ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಇಟ್ ಇಸ್ ರಿವರ್ಟೆಡ್. ಅಕ್ವಿಟಲ್ ಅಗೇನ್ಸ್ಟ್ ರಿವಿಷನ್ ಬರಲ್ಲ. ನೋಡಿ ಅದ್ ನೋಡೋಣ. ಅಣ್ಣ ತಮ್ಮ ಅಲ್ರಿ ಇಬ್ರು ಕೂತ್ಕೊಂಡು ನೀವೇ ಏನೋ ಮಾಡಿ. ಅಲ್ಲ ಆಯ್ತು, ನಾನ್ ಹೇಳೋದೇನಂದ್ರೆ ಅಣ್ಣ ತಮ್ದಿರಲ್ವಾ, ಇಬ್ರು ಕೂತ್ ನೀವೇ ಅಡ್ವೊಕೇಟ್ಗಳು ಇಬ್ರು ಮೇಕ್ ಯೂಸ್ ಆಫ್ ಯುವರ್ ಗುಡ್ ಆಫೀಸ್ ಅಂಡ್ ಅಲ್ಲ ಬಟ್ ಈಗ ಅವ್ರಿಗೆ ಈಗ ರೆಸ್ಟೋರ್ ಆದ್ರೆ ಮತ್ತೆ ಅದು ಅಲ್ವಾ, ಅದಕ್ಕೆ ಇಬ್ರು ಸೇರಿ ಏನೋ ಒಂದು ವಯಾ ಮೀಡಿಯಾ ಮಾಡ್ಕೊಳ್ಳಿ ಏನದು ನೋಡ್ರಿ. ಆಯ್ತು, ಕೇಳ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಬೇಡ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಂತ ಬೇಡ, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡೋಣ ಬಿಡಿ. ಇಟ್ಸ್ ನಾಟ್ ಪಾಸಿಬಲ್. ತಗೊಳ್ಳಿ ಅದ್ ನೋಡಿ ಹೇಳಿ ಅಷ್ಟೇ. ತಗೊಳ್ಳಿ both the courts ಅಲ್ಲ both the counsel seeks time to make submission with regard to the whether appeal lies or revision lies, and as list this matter on ಎಷ್ಟು ದಿವಸ ಬೇಕು? next week 18th. ಗಿರೀಶ್ ಎಸ್ ಏನ್ರಿ ಇದು ಯಾರಿಲ್ವಾ? 323, 324, 326 ಆಲ್ಸೋ. ಮ್ಯಾಕ್ಸಿಮಮ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 2 years ಅಂದ್ರೆ ಅವ್ನಿಗೇನು ಇಂಜುರಿ ಏನೋ ಫ್ರಾಕ್ಚರ್? ಇದ್ರಲ್ಲೂ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಮಾಡಿದಾರ? ಆಯ್ತು ನೋಡಿ, ಸೇಮ್ ಆರ್ಡರ್ ಮೇಡಮ್. ಈಗ ಯಾವ್ದೊಂದು ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟೆಡ್ ಅಂದ್ವಲ್ಲ, ಯಾರು ಮಾಡ್ತೀರೇನ್ರಿ? ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಇದ್ದವ್ರು ಯಾರು ಅಸಿಸ್ಟ್ ಮಾಡ್ತೀರಾ? ಕೌನ್ಸಿಲ್ ಮಾಡಿ ಬನ್ನಿ, ಹೆಸರೇನು ಹೇಳಿ? Allabaksh. Counsel Allabaksh is appointed as amicus curiae and office is directed to. ಇದ್ರಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಮೊದ್ಲು ಹೇಳಿದ್ನಲ್ಲ ಮೇಡಮ್, ನೀವೆಲ್ಲ ತಗೊಂಡಿದ್ದು ಡಿಕ್ಟೇಷನ್, ಅದೇ ಆರ್ಡರ್ ಸೇಮ್. ಬಟ್ ಅದು ಆರ್ಡರ್ ಡೇಟೆಡ್ ಏನಂದ್ರೆ 11/2, ಇದು 11/2 ಇರ್ಬೇಕು. ಅಪಾಯಿಂಟೆಡ್ ಅಂಡ್ ಡೈರೆಕ್ಟೆಡ್ ಟು. ನೀವು ಕಾಪಿ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋಬಹುದು. ಆಯ್ತು, ಡೇಟ್ ಯಾವಾಗ ಬೇಕು? ಡೇಟ್ ನಿಮ್ಗೆ ಎಷ್ಟು ದಿವಸ ಬೇಕು? 2 weeks ಬೇಕಾ? 21st ಆಗ್ತದೆ. 69 ಪ್ರಣಯ್ ಕುಮಾರ್ ಪೋಕರ್ನ. ಪ್ರಣಯ್ ಕುಮಾರ್ ಪೋಕರ್ ಇದೇನ್ರಿ? ಎಕ್ಸೈಸ್ ಆಕ್ಟ್ ಬರೋದೇ ಇಲ್ಲ ಕೌನ್ಸಿಲ್. ಕೊಡಿ ನೋಡೋಣ, ಎಕ್ಸೈಸ್ ಆಕ್ಟ್ ಏನ್ ಇದೆಯಾ ಮೆಟೀರಿಯಲ್ ಅಥವಾ ಏನ ಕೇಸ್ ಮಾಡಿದಾರ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಪನಿಷ್ಮೆಂಟ್? Senior counsel for the petitioner is ready to argue. Senior counsel for the petitioner is ready to argue, but the learned HCCP press time ಅಂತ ಲಾಸ್ಟ್ ಕೇಸ್ ಮೆಸೇಜ್ ಕೇಜೆ ಮುಂದೆ ನೀವೇ ಏನೋ ಟೈಮ್ ತಗೊಂತಂತಲ್ರಿ? How the learned counsel for the revision petitioner record admit. So petitioner counsel is absent. This is the matter of the year 2015. ನಿಮ್ದೇನ್ರಿ? ನಿನ್ನೆ ಕರ್ಸಿದೀವಲ್ಲ, ಯಾಕೆ ನಿದ್ದೆ ಮಾಡ್ತಾ ಇದ್ರ? ಪ್ರಣಯ್ ಕುಮಾರ್ ಪೋಕಣ್ಣ ಅಂದ್ರೆ ನೀವೇನಾ? ಮತ್ತೆ ನಿಮ್ ಸೀನಿಯರ್ ಹೇಳಿ. ಯಾರು ಸೀನಿಯರ್ ನಿಮ್ಗೆ? ಸೀನಿಯರ್ ಮತ್ತೆ ಏನಾಗಿದೆ ಅವ್ರಿಗೆ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಆಯ್ತು. ಜೂನಿಯರ್ ಕೌನ್ಸಿಲ್ ಸೀಟ್ಸ್ ಟೈಮ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಏನಾಗಿದೆ? ಆಯ್ತಾ, ನಾಟ್ ಕೀಪಿಂಗ್ ವೆಲ್ ಅಂಡ್ ಹೆನ್ಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್. ಯಾವತ್ತು ಬೇಕು? 16th. ಆಯ್ತು. ನಟರಾಜ್ ಬಲ್ಲಾಳ್.
I am appear for the petitioner, madam.
I appear for the respondent, please, madam.
Yes, both are there. Yes,
It's arising out of 138 proceedings, my lord.
Yes, counsel.
Lord, the transaction is arising out of a trade where the petitioner herein is the accused and he was a distributor for the respondent complainant. Lord, transaction was of the year 2003. He was a dealer during that time, my lord, and exhibit D1 was the agreement between the parties. Lord, thereafterwards, my lord, it was terminated, and again there was a fresh agreement. But the earlier check, my lord, according to them, according to the petitioner, it is a security check, which was misused. My main contention before this honorable court is that, my lord, exhibit P1, the check in dispute, your lordship may kindly see is tampered. Date is tampered.
Tampered,
Yes,
date.
yes, date. According to the, your lordship may kindly see the exhibit itself, my lord, because
Yes,
it
that's
shows
what I'm asking.
2010, 2000. It looks like, according to the complaint, it is 2010, 2006. But if your lordship kindly peruses the check date, my lord, it is 2010, 2004. My lord, both the courts have not considered this aspect at all. My contention before my lords is that, my lord, it was a security check. Transaction was for the earlier years. Lord, they themselves have produced exhibits, account statements, where the amount is different and the amount in the check is different. Therefore, my lord, in view of this tampering of the check, where I specifically contended that it is a security check issued earlier in the under as per the earlier agreement of the year 2002. This check could not have been presented because, as on the date of the presentation of the check, there was no liability, admitted liability. That has not been considered by both the courts.
Where is the statement of account?
My lord, statement of account is, my lord, exhibit. Exhibit P10, my lord. P9 account extract and P10 is the statement. P11 is account extract once again. In turn, my lord, I had contended saying that I had paid these amounts under three DDs, and it was sent to the complainant as per under a receipt, courier receipt D3, D4, and D5.
What is the check amount?
Check amount is, my lord, 1,15,319 rupees 95 paise. 1,15,319.95. And their account extract, my lord, shows that total outstanding on 2010-2006 is 1,62,783.95. That is exhibit P9. If it was the same check, my lord, and if I had issued this check for discharge of that liability, then the amount should have been 1,62,000 instead of 1,15,000. There is no explanation why it is not why it is a lesser amount. If they had claimed that
total outstanding as on 2010-2006
is 1,62,783.95, my lord, exhibit P9. Your lordship would kindly see.
Exhibit P9 only.
Yes. But that itself shows that, my lord, they have taken a check for 1,15,319 rupees 95 paise. And this exhibit P1, which your lordship kindly would appreciate that it is a tampered check. That is why, my lord, the complainant has not come to the court with the clean hands. Maybe there was a transaction for which, my lord, according to me, I have remitted the entire amount to the complainant. There is no amount due.
Have you given any reply to the legal notice?
No, that has not been done. That has not been done. That is
whether notice is served on you or not.
Yes, it is served. It is served.
Why you kept quiet if really you have paid the amount?
Lord, I have taken that defense before the courts below.
What is the defense?
In my defense, my lord, I have stated that I don't owe the money and I have paid the money. Lord, I have paid the money, whatever amount is due. This was a security check which is misused. That is what is my defense.
That's why you have not given reply that
reply. Yes, my lord. That for
security
that
check was given was misused. And by that time itself, you would have given reply.
Yes, that
this
is that.
This defense is afterthought.
My lord, but still, my lord, tampering of the check could go to the root of the matter, my lord. If they had that check with them.
Have you proved the defense of tampering by sending the document to the expert?
No, that has not been done. No application has been filed. No application has been filed.
If I may interfere, my lord, this tampering, my lord, the version is for the first time being argued, my lord.
Yes. Yes.
Not even a suggestion in the cross-examination, no evidence, no basis so far as tampering is concerned, my lord. For the first time.
Cross-examination, whether they have cross-examined in PW1.
They have
Yes, they have. We have done that.
But not even a suggestion of tampering.
But tampering.
PW1, one second. Cross of PW1.
Yes.
PW1. Yes, categorically stated in paragraph number 3 of the affidavit that the arrears was 1,62,783. Clear the balance. But he gave the check for rupees also.
Correct.
1,15,000. He has given stated in the petition itself, in the affidavit also. Though
Yes,
due
Lord,
was you gave the check for only rupees 1,15,319.95.
So that is their defense, my lord. I mean, their contention, my lord. No doubt that is their contention.
But now exhibit P9 cannot be looked into. ಆಯ್ತು ಕ್ರಾಸ್ ನೋಡೋಣ ಮುಂದುವರೆದ ಮುಖ್ಯ ವಿಚಾರ
ಕ್ರಾಸ್ ಅಲ್ಲಿ
ಏನ್ ಹೇಳಿದಿರಿ ನೋಡೋಣ.
No, I have not raised that. I have not raised that. Cross examination has not been done on that line.
ಸಾಕ್ಷಿಗೆ ದಾಖಲಾಗಿ ತೋರಿಸಲಾಗಿ ಸಾಕ್ಷಿ ಮೇಲೆ ಹೇಳಿದ ಕರಾರಿಂದ ಒಪ್ಪಿದರ ಮೇರೆಗೆ ಅದೆಲ್ಲ ಆಯ್ತು. ಎಕ್ಸಿಬಿಟ್ P1 ಆಯ್ತು. ಉಚಿತ ದಾಖಲೆ ಅವರ ಪ್ರಾಂಶದ ರೆಮೋನ್ ಹೆಸರನ್ನು ಕೊನೆಗೊಳ್ಳುತ್ತಾರೆ. ನಿಶಾಂತ್ ನಾಯಕರ ಬಗ್ಗೆ ಬಡ್ಡಿ ಹಾಕಿರೋ ಬಗ್ಗೆ ಕಾಣಿಸಿದೆ ಅಂದ್ರೆ ಸರಿ. ನಿಶಾಂತ್ 9ರಲ್ಲಿ ಬಡ್ಡಿ ಹಾಕಿರೋ ಕಾಣಿಸಿದೆ ಅಂದ್ರೆ ಸರಿ. ಬಡ್ಡಿಯ ನಮೂದು ಬಗ್ಗೆ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ಕೊಂಡುಕೊಂಡ ಬಗ್ಗೆ ಸೋನ್ಸ ಪಾವತಿ ಮಾಡಿದ ಬಗ್ಗೆ ನಮೂದು ಇಲ್ಲ. ಚೆಕ್ ಅನ್ನು ಆರೋಪಿ 29ರಂದು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಸದರಿ ದಿನಾಂಕದಂದು ಆರೋಪಿ ಮತ್ತು ಫಿರ್ಯಾದಿ ಸಂಸ್ಥೆ ನಡುವೆ ಯಾವುದೇ ವ್ಯವಹಾರ ನಡೆಯುತ್ತಿರಲಿಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದ ಆರೋಪಿ ಹಿಂದಿನ ಹಣ ಬಾಕಿ ಇದ್ದ ಕಾರಣ ಯಾವುದೇ ಮಾಲುಗಳನ್ನು ಅವರಿಗೆ ಕೊಡುತ್ತಿರಲಿಲ್ಲ ಎಂದು ಫಿರ್ಯಾದಿ ಮತ್ತು ಆರೋಪಿ ನಡುವೆ ನಡೆದ ಕೊನೆಯ ವ್ಯವಹಾರವಾಗಿರುತ್ತದೆ. 2 ಲಕ್ಷದಷ್ಟು ಮಾಲನ್ನು ಚೆಕ್ ಅನ್ನು ಆರೋಪಿ ಎಲ್ಲಿ ಕೊಟ್ಟರು ಎಂಬ ಬಗ್ಗೆ ನನಗೆ ಸರಿಯಾಗಿ ಮಾಹಿತಿ ಇಲ್ಲ. ವಾಸಸ್ಥಳ ಶಿರ್ಷಿಸುವಂತ ಮಂಗಳೂರಿನಲ್ಲಿ ನಡೆಯುತ್ತಿರುತ್ತೆ. ಆರೋಪಿ ಒಂದು ವ್ಯವಹಾರದ 2 ಖಾಲಿ ಚೆಕ್ ಫಿರ್ಯಾದಿ ಸಂಸ್ಥೆ ಪಡೆದುಕೊಂಡಿದ್ದರು ಎಂದು ನೋಡಿ ಹೇಳಬೇಕು. ಆರೋಪಿಯಿಂದ ಖಾಲಿಯಾಗಿ ಭದ್ರತೆಗಾಗಿ ಪಡೆದುಕೊಂಡ ಚೆಕ್ಕಿನ ಬಗ್ಗೆ ನಿಶಾನೆ D1ರಲ್ಲಿ ನಮೂದು ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿ. 17/4/2043 ಫಿರ್ಯಾದಿ ಮತ್ತು ಆರೋಪಿ ನಡುವೆ ಸದರಿ ಕಾರಿನಲ್ಲಿ ಒಂದು ಚೆಕ್ ಅನ್ನು ಭದ್ರತೆಗೆ ಆರೋಪಿಯಿಂದ ಖಾಲಿಯಾಗಿ ಪಡೆದುಕೊಂಡ ಬಗ್ಗೆ ನಮೂದು ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. That is denied.
No, that is second agreement, my lord. I have not given any security check. It is under the first agreement.
ಆಯ್ತು. Where is the suggestion regarding tampering in
No, that my lord, I concede, my lord, that there is no such. But at this point of time, my lord, my lord, your lordship has to appreciate. No, 2 courts have held against me, but it is check, my lord, which your lordship to the naked eye would be very evident that it has been tampered.
Court cannot become an expert in
no doubt.
Unless you take the defense. First of all, no denial at all and no suggestion with regard to the tampering at all also.
No, tampering but
check is also not bounced on account of any correction or tampering. It is only on account of
yes, all that I have no only
no ground. ಏನ್ ಹೇಳಿ ಬೇರೆ ground
ಇಲ್ಲ ಅಷ್ಟೇ ಸ್ವಾಮಿ. That is only ground I can urge at this point of time, because cross examination your lordship has already appreciated. Because one suggestion I have stated that there were 2 blank checks issued in the under the first agreement. That suggestion has been put. That has been put.
That is there in the document also. Agreement prakar
yes. That agreement has come to an end, and there was a subsequent agreement. 2003 was a new agreement. That is the cross examination and which has been.
Yes, counsel ಹೇಳ್ರಿ. ಉಸ್ತಾಪ ನಿಮ್ದೇನಾರ ಹೇಳೋದಿದ್ಯಾ ಇನ್ನ ಅಡಿಷನ್?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ತಮ್ಗೆ ಅರ್ಥ ಆಗಿದೆ ಏನು?
ಆಯ್ತು ತಗೊಳ್ಳಿ. Heard the petitioner counsel and also the counsel appearing to the state.
Respondent ಮಾಡ ಸ್ಟೇಟ್ ಅಲ್ಲ.
Sorry, respondent state ಹೇಳಿ ಹಂಗೆ ಆಗಿದೆ. Respondent. The factual matters of the case of the prosecution is that
prosecution
means you are also a prosecutor.
Yes.
Complainant is that the complainant is a company dealing in edible oils, and the accused through his firm, namely Raj Distributors, has been dealing with the complainant for purpose of purchase of edible oils credit basis. As on 2010-2006, the credit balance in his account was rupees 1,62,783. Towards repayment of the balance outstanding, the accused has issued a check, subject matter of check. And when the same was presented, it was returned with an endorsement. In Dizanada, insufficient funds.
Funds insufficient.
Was issued and no reply was given. In view of non-compliance of the demand, the current complaint was filed and cognizance was taken. The complainant, in order to prove his case, examined himself as PW1 and also got marked document exhibit 13. On the other hand, the accused petitioner examined himself as PW1 and got marked document exhibit D1 to D5. The trial court, after considering both oral and documentary evidence, the revision petitioner before this court and ordered to pay fine of rupees 1,30,000 and in default undergo simple imprisonment for a period of 8 months. Hence, an appeal is filed before the court in an appreciation of oral and documentary evidence. Again, the appellate court dismissed the appeal. Hence, the present revision petition is filed before this court. The main contention of the petitioner counsel before this court is that the exhibit P1 was issued in the year 2002 and on the said date was mentioned but overwritten. The date year of the check was not considered by both the courts. However, both the courts have relied upon exhibit P9 to 11 in coming to the conclusion that there was supply of goods and the same is also erroneous. The complainant also had failed to prove the exact amount due to him by producing proper account extracts, a statement of accounts. And complainant also not produced any iota of evidence. The complainant relying upon exhibit P9 as per exhibit P9 1,62,783 9.5. 9.5 is the due. But there was no any explanation forthcoming from the complainant to show that why it had accepted a check for a lesser amount. The trial court also not considered exhibit D3 to D5. The appellate court also fails to consider the matter, that is oral and documentary evidence, and committed an error in confirming the judgment of the trial court. Hence, it requires interference of this court. For counter, the counsel appearing for the respondent public complainant would submit that with regard to the tampering of document as contended by the petitioner counsel, no cross-examination. And hence, for the first time rising, the said contention. The contention of the petitioner also cannot be accepted regarding issuance of check to the tune of rupees 1,50,319.95. The counsel would vehemently contend that the balance was rupees 1,62,000 and odd. Out of that, an amount of a subject matter of check was given, and the same is stated in the complaint as well as in the affidavit of the witness. And hence, both the courts have not committed any error. Having heard the respective counsel and also on perusal of material available on record, the point that would arise for the consideration of this court are whether both the courts have committed an error in not appreciating the defense of the petitioner herein, and whether whether the orders passed by both the courts suffers from legality and its correctness, and it requires interference of this court by exercising the revisional jurisdiction. Point number 2, what order? Having heard the respective counsel and also considering the material on record, there is no dispute with regard to the parties that there was an agreement between both of them regarding business. It is also important to note that this petitioner was working as distributor. But the council also admits that earlier when there was an agreement between the parties, 2 checks are given for security. And also subsequently, one more agreement was entered into between, also not in dispute. No dispute with regard to no subsequent security checks are given. The main contention of the petitioner counsel that document exhibit the subject matter of the check, which is produced as exhibit P1 and perusal of their eyes on record. It is clear that the year was tampered. It is rightly pointed out by the counsel appearing for the respondent that during the course of class examination, no suggestion was made with regard to the tampering. And for the first time, the said contention is taken in this revision. Unless there is an effective class examination with regard to the tampering, for the first time in revision, the petitioner cannot urge this at ground. And hence, the first contention of the petitioner counsel cannot be accepted. The other contention of the petitioner counsel that though in terms of exhibit P9 balance was rupees more than 1,62,000, there was no any explanation on the part of the petitioner counsel accepting the check for rupees 1,15,319.95. But on perusal of the complaint as well as the affidavit, the petitioner, the respondent has given details that due was rupees 1,62,000 and odd, but check was given for rupees 1,15,319.95. In the case of the petition, complainant is clear that in discharging the liability out of the amount of rupees 1,62,000 and odd, a check, subject check was issued. The very said contention also cannot be accepted. Both the courts have considered the material on record, particularly the exhibit P1 subject matter of check, and also taken note of the relationship between the parties. And apart from that, exhibit P9, bank statement also produced before the trial court, and the same has been considered. And when there is no dispute with regard to the check is concerned, only contention for the first time in the revision that there was a tampering. And the said document is also not sent for any FSL examination. And apart from that, the said contention also not raised before the trial court. When settling it, I do not find any error committed by the trial court as well as the first appellate court, and both the courts have appreciated the evidence available on record. When such being the factual aspects of the case, it is not a fit case to exercise the discretion to invoke the revisional jurisdiction unless the order suffers from any legality and its correctness. And hence, petitioner has not made out any ground to invoke revisional jurisdiction in view of the discussions made above. And hence, I answered point number 1 as affirmative, negative. In view of the discussion made up, I passed the following order. Revision petition is dismissed. Deposit ಏನಾರು ಇದೆಯಾ ಇಲ್ಲಿ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಅಲ್ಲಿ ಇಲ್ಲ 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 ಕೆಳಗಿನ
Grateful.
ದಿಲೀಪ್ ಕುಮಾರ್, ಸಿರಿಲ್ ಪ್ರಸಾದ್ ಪಯಾಸ್ ಇದೀರಾ ಇಬ್ರು? ಬನ್ನಿ. ಏನ್ ಅಫೆನ್ಸ್? 138 ಹೇಳಿ. ಪಾರ್ಟಿ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ ಏನ್ ಮಾಡ್ತೀರಿ? 2015 ಅವನೇನ್ ಮಾಡ್ತಾನೆ ಈಗ? ರಿವಿಷನ್ ಓನ್ಲಿ ಲೀಗಲ್ ಆಸ್ಪೆಕ್ಟ್. ಪಾರ್ಟಿ ಏನ್ ಹೇಳೋದು ಮಾಡೋದು ಏನು ಇರೋದಿಲ್ಲ. 2 ಕೋರ್ಟ್ ಅಲ್ಲೂ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗುತ್ತೆ. ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಮತ್ತೆ ಪಾರ್ಟಿ ಏನ್ ಹೇಳ್ತಾರೆ? ನೀವ್ ಹೇಳ್ಬೇಕು. ನೀವು ಲಾಯರ್ ತಲೆ ಹೋಗಿಸಿ ರಿವಿಷನ್ ಒಳಗ್ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ಬೇಕು. ಆಯ್ತು, ಯಾವಾಗ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ಎಷ್ಟು ವೀಕ್ ಯಾವತ್ ಬೇಕು ನೀವ್ ಹೇಳಿ. ನಿಮ್ ಡೇಟ್ ಆಗ್ತದೆ. ಯಾವತ್ತು? ಆಯ್ತು. Petitioner counsel seeks time. Discuss matter on 17th ಯಾವ್ದು ಹಾಕಿಲ್ಲ ಮೇಡಮ್? ಅಲ್ಲಿವರೆಗೂ ಹೋಗೋದಿಲ್ಲ. ಸಾಕು ಎಳ್ದಿರೋದು ಈಗ. ಯಾವ ವರ್ಷದ ಕಂಪ್ಲೇಂಟ್ ಹೇಳಿ? ನಮ್ಮಲ್ಲೇ 2015, ಇಲ್ಲೇ 8 ವರ್ಷ ಆಗಿದೆ. ಅಲ್ಲಿ ಕೋರ್ಟಿಗೆ ಬಂದಿದ್ದು ಯಾವಾಗ ಅವನು? ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸಲ್ಲಿ 2 ವರ್ಷನ? 2012? ಆಯ್ತು, 1 ಡಿಕೇಡ್ ಆಗೋಯ್ತು. ಆಯ್ತು, ಸಾಕು 17, 16 ತಗಾರ 17th ಬಂತು ಸಾಟರ್ಡೆ. 16th 17th ಬಡ್ವಾ? 21st. 73 ಹೇಮಂತ್ ರಾಜ್. ಹೇಮಂತ್ ರಾಜ್, ಬಿಜೆ ಮಹೇಶ್. ಹೇಳಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ. ಹಾ,
ಚೆಕ್ ಬೌನ್ಸ್
ಏನ್ ಮ್ಯಾಟರ್ ಏನು? ಒಳಗೆ ಮ್ಯಾಟರ್.
proceedings.
ಹೇಳಿ. ಹಾ,
On 16/7/2014, the trial court by impugned order followed the case of the respondent. On 23/4/2014, the first appellate court has allowed the appeal by
divergent finding. Concurrent finding or divergent? ಅಲ್ಲ, allowed ಅಂದ್ರಲ್ಲ, ಕೇಳಿ.
Concurrent findings.
ಆಯ್ತು.
On 23/4/2014, the first appellate court has allowed the appeal by remanding the case to the trial court on the ground that the trial court has committed an error by taking evidence of the accused by way of affidavit and directed the trial court to dispose the case on merits after recording the defense evidence of the petitioner.
ಆಯ್ತು. ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ ಏನಾಯ್ತು? ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ ಏನಾಯ್ತು?
On 6/2/2015, this petitioner has given evidence before the trial court as per the direction of the first appellate court. And this respondent has failed to cross-examine the petitioner. Then your lordship is adopting the cross-examination of 18/6/2014, which is not existence in the eye of the law.
Existence earlier.
Earlier hoitadu evidence hoitadu. As per the appellate court, evidence is gone. Lordship is adopting the 18/6/2014 cross-examination. In the eye of the law, there is
subsequent he did not cross-examine the witness. ಆಯ್ತು.
ಮಾಡ್ಲಿಲ್ಲ. But however, the learned trial court judge, the one-sided, kindly take page number 12. All findings are given only one-sided. You should kindly take page number 12, para number 5.
Para number 5.
5, page number 12.
Trial court order.
Trial court order.
12.
Nice. Thereafter, the statement of accused number under section 313 of CRPC is recorded, para number 5. In which is totally denied the entire case of the complaint. In support of the denial of the case of the accused adduced his oral evidence on oath as DW1. Before remanding the case, the accused has given his evidence by way of affidavit, and after leading the defeat evidence, the complaint counsel has adopted the earlier cross-examination of DW1 before remanding the case, and thus the accused also closed the evidence. Then you should kindly findings one-sided. Entire findings is one-sided. Not appreciate the contention taken by this petitioner, page number 20. Para number 14, 19 ali, page number 19 ali. 14. But in this case, it is specific case of the accused that the alleged check has been given to the brother of complaint. The same has been misused by the complaint, etc. But in support of his contention, he has not examined any one of the witnesses or stated in the examination. Further, the legal notice the accused is written not claimed by the accused, but he has taken untenable contention that he has not received the legal notice. Except the formal dealing of the accused, he has not given any corroborative evidence or not given any rebuttal evidence to the case of the complaint. Under this circumstance, the accused failed to give rebuttal evidence. So let's kindly see. I have given my evidence, sir. He has not he has not challenged my evidence also. In spite of that, the learned trial court has given this kind of findings. Therefore, your lordship, this is not a lordship. The both the orders has to be.
Then what is the finding of the appellate court?
Same, your lordship, the same findings.
Appellate court.
Same replica of the findings of the trial court.
Where is the observation of the appellate court?
Page number 29.
Accused contended that after remand of the matter has led his evidence on oath by entering into the witness box. There is no cross-examination to the evidence of the accused. As such, his evidence remained unchallenged. Hence, accused Bapti reported the case. I have not accepted the arguments of the accused. Because
Even
court
first
permitted
appellate
the
court is not
complainant
considering this issue.
when it is so, the contention of the accused that there is no any cross-examination of his evidence cannot be accepted at all. On comparison of earlier affidavit evidence filed for examination in chief of accused and the present examination in chief are both one and the same. No documents produced by accused before the court to show that Raju had paid money to Jeevan, and for security accused gave check to Raju. Neither Raju nor Jeevan is examined before the court by the accused. The explanation given by the accused is that both have gone to abroad. It is not acceptable explanation. When the accused has taken contention to rebut the case of the complainant, then he has to prove the same. Merely taking contention is
Same
not
is the replica of the trial court order.
except putting
There is no
suggestion
finding.
to this one. So when Jeevan has taken the amount from Raju, the brother of the complainant, then the said Jeevan could have issued check to brother of the complainant. But why Jeevan has not issued check? There is no any explanation. Hence, contention of the accused cannot be accepted in all. In the examination, chief accused stated that Raju and his father came to the office of accused. When it is so, the persons who were working in the office of the accused could have been examined before the court to substantiate the contention of the accused. But it is not done. Probable defense put up by the accused would be acceptable defense. But in this case, the weak defense is taken by the accused in order to avoid payment of money. It is not given any notice to the complainant stating the fact that in this examination not taken any steps against the complainant for misusing the exhibit P1 check.
Without challenging the issue, the rebuttal of my evidence, both the court has given a specific findings against me. The respondent has not taken any pain to challenge my evidence. And he's adopted the cross-examination, which is not existence in the AFT law. That cross-examination already went out. I have given a fresh evidence after the remanding. And learned judge has not given any the findings in respect of the rebuttal of my evidence. Both the court is given the same replica of the order.
That is what Order the petition of counsel due to paucity of time discuss this matter on 9th for respondent's argument. 10th, ಆಯ್ತು 10th ಅಂತ.
Please, your Lordship, please.
ಅದನ್ನ ನೋಟ್ಸ್ ಇಟ್ಕೊಡಿ ಮೇಡಮ್. ಮುಗಿತಲ್ಲ ಅದರ ಇದೆಯಾ? ಅದ್ಯಾವುದೋ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಫೈಲ್ ನನಗೆ ಬರಲಿಲ್ಲ. ಆದ್ರೂ ಪರ ಯಾರ ಹತ್ರ ಇದೆ? ಅದ್ಯಾವುದೋ ಎಂಪ್ಲಾಯ್ಸ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತಂದ್ರೆ ಚೇಂಬರ್ಲಿ ಎಲ್ಲಿದೆ? ನನ್ನ ಹತ್ರ ಬರ್ಬೇಕಲ್ಲ ನನ್ನ ಟೇಬಲ್ ಫೈಲ್. ಎಷ್ಟು ದಿವಸ ಆಯ್ತು? ಇವತ್ತು ಯಾವ್ದೋ ಒಂದು ರಿಸರ್ವ್ ಮಾಡಿದ್ವಲ್ಲ, ನಾಳೆಯಿಂದ ಒಬ್ರಿಗೆ ಬರಕ್ ಹೇಳಿ, ಯಾರೋ ಒಬ್ರು ಬರ್ಬೇಕು 9:45. 4 ಗಂಟೆ ಮುಂಚೆ ಬರ್ಲಿ. ಏನಾಯ್ತಾ? 10+1 ಅಂದ್ರೆ 1 ಅಪೀಲ್ ಜೊತೆ ಅಪೀಲ್ ಎಲ್ಲಿದೆ? ಅದು ನಮ್ಮ ಹತ್ರ ಇಲ್ವಾ? ಅದು ಅಲ್ಲಿಗೆ ಹೋಯ್ತು. ನಮ್ಮಲ್ಲಿ ತೋರ್ಸೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ನಮ್ಗೆ ತೋರ್ಸೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಆಯ್ತು, ರಿಮೈಂಡ್
Court officer. Sir, court officer, sir. ಮೇಡಮ್ PL ನಂಬರ್ 65 ಫೋನ್ ನಂಬರ್ ಶೇರ್ ಮಾಡಕ್ ಹೇಳಿದ್ರು.
ಫೋನ್ ನಂಬರ್
ಹೌದು
ಸರ್ ಅವ್ರು ಇಲ್ವಲ್ಲ ಸರ್ ಇಲ್ಲಿಗ
ಇಲ್ವಾ ಮೇಡಮ್?
ಇಲ್ವಲ್ಲ.
ಅವ್ರ ಕಾಪಿಲಿ ಅವ್ರದ್ ನಂಬರ್ ಏನಾದ್ರು ಇದ್ರೆ ನಮ್ಗಾದ್ರೂ ಕೊಟ್ರೆ ಸ್ವಲ್ಪ ನೋಡ್ತೀವಿ ನಾವು. ರಿಪಿಟೇಷನ್ ಅಲ್ಲಿ
ಸೆಕೆಂಡ್ ಇರಿ ಸರ್. ಇದು GS ಬಾಲ್ಗಂಗಾಧರ್ ಅವ್ರದ್ದು.
ಹೌದು ಹೌದು ಮೇಡಮ್.
ಲ್ಯಾಂಡ್ ಲೈನ್ ಇದೆ ಸರ್.
ಕೊಡಿ ಮೇಡಮ್, ಕೊಡಿ ಕೊಡಿ.
233
233
ಹೇಳ್ತೀನಿ 12.
ಓಕೆ ಮೇಡಮ್.
304 ಸರ್. ಮಲ್ಲೇಶ್ವರಂದ ಅಡ್ರೆಸ್ ಹೇಳ್ಬಿಡ್ಲಾ ಅವ್ರದ್ದು?
ಹೇಳಿ ಮೇಡಮ್, ಹೇಳಿ ಹೇಳಿ.
250/6
250/6
ಸೆಕೆಂಡ್ ಫ್ಲೋರ್, ಸೆಕೆಂಡ್ ಮೇನ್, ಸಂಪಿಗೆ ರೋಡ್.
ಕ್ರಾಸ್ ಎಷ್ಟನೇ ಕ್ರಾಸ್ ಅಂತ ಇದೆ?
ಅದೇ ಹಲೋ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ
ಮೇಡಮ್? ಕ್ರಾಸ್ ಎಷ್ಟನೇ ಕ್ರಾಸ್ ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ.
ಅದೇನಿಲ್ಲ, ಬರೀ ಸೆಕೆಂಡ್ ಫ್ಲೋರ್, ಸೆಕೆಂಡ್ ಮೇನ್ ಅಂತ ಇದೆ. ಆಮೇಲೆ ಇದೆ ನೋಡಿ ಸರ್, 16th and 7th, ಬಿಟ್ವೀನ್ 16th and 17th ಕ್ರಾಸ್.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ ಓಕೆ.
ನಿಯರ್ ಬಡಗನಾಡು ಭವನ.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ.
ಮಲ್ಲೇಶ್ವರಂ ಅಂತ ಇದೆ.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಈಗ ಲಾಸ್ಟ್